draft jury charge. The state has reviewed it. The state accepts it. The state is fine with it. The state agrees with it. Thank you.
And let me also put on, I think I put this in my email, my intent is to take all of those emails I received over the weekend and file them into the record so that it's clear what was presented to the court as opposed to going back over all of it this morning. So all of that will be part of the record. I'll just do that as a notice of filing with those emails that I received from Travis McMichael.
Your Honor, we appreciate the court's work over the weekend. It really was a lot of hard work from all of us, so I do appreciate that. The only charge that remains that I would accept to is the duty to inquire submitted by Mr. Bryan, which is a civil charge about liability. It says, where a reasonable man would investigate further before instigating a prosecution or making an arrest, he may be liable for failure to do so. And I don't know that the jury will even understand why that's in there, because it's about liability. It's on page
16.
Yeah, 16.
Let me go further around the room and I'll come back. From Greg McMichael.
Yeah, we adopt Mr. Rubin's argument just now. On page 15, excuse me, the section concerning the requirement that an arrest be made contemporaneously. While we think that the wording is greatly improved over the request by the state, on one hand, I think it leaves it open. It's ambiguous enough that the defense can say that the felony need not have occurred at the time of the attempt to capture or for the escape. And that was the point of the memo and the case that I sent Saturday, was to say that. So on the one hand, I think this leaves it that open to argument, but also could be read to constrain a juror to believe, especially I think you say you're going to give the copy of the charge to them, so they'll have this in front of them. And so where it says, if a private citizen's warrantless arrest must occur immediately after the perpetration of the offense, or in the case of felonies during escape. Well, I take it that's as good as it's going to get. I'm just taking the exception.
But that's the language that I announced on Friday would be the language. What I indicated was I would look at what was submitted over the weekend to see whether that language should be changed, and I've kept it in the same format that I had put on the record. Now, it's different than what was in the draft charge, but that's the language that I had agreed to put into the charge on Friday. So it's remained that way. I have reviewed the two emails. There was one that went over case law, and then another one went through the more grammar-related arguments. And so I've reviewed all of that. That's where the court's going to stay with it.
We take exception.
No, I understand.
We'll join that, Your Honor.
And the other thing that Mr. Rubin had asked when we talked about prior difficulties, which I thought had been changed in court, but I didn't see it on the new one, instead of...
What I said on Friday was I'd read through the language, make sure I understood, but prior difficulties, what we'd said on the record Friday was prior difficulties, normally there were prior difficulties, and so what we normally see in a case is a discussion about prior difficulties between the parties, but the charge actually addresses circumstances where it's either prior difficulties exist or don't exist between the parties. So I wanted to read through the language, make sure I was clear about it with a clear mind, and I'm going to leave it in the charge.
And understood. What I thought we had each scratched out, though, was the word difficulties and had replaced it with, what was the word?
Either interactions.
Interactions, but I'm not sure if you...
Or encounters.
Encounters. That's what we had thought of, so we would have asked for that. We take exception to staying with the pattern. And I think that was it for us.
And we'll join that.
Thank you.
Thank you. And then, Mr. Goff, I received in the form of motions, well, first of all, I received your emails. Those, again, have been addressed, at least the substantive parts. There's also motions for reconsideration. I've reviewed those, and again, as I indicated Sunday, having reviewed those, the court has put the charge together the way that it was presented.
Your Honor, first of all, we will adopt the objections made by the McMichael defendants this morning and their requests. Second, we don't wish to argue the motions for reconsideration that I drafted. Ms. Burton would like to briefly address the court on the proximate cause issue, if the court will allow it.
That was addressed, I thought, in the emails. That's why the emails, everything that was submitted to the court is going to be filed into the record. And so those issues are preserved as far as the court is concerned.
I understand. I promised Ms. Burton that I would give her the opportunity to argue the issue if the court would hear it, because it's close to her heart. The court has indicated the court does not need to hear that argument at this time, and we appreciate the court's position.
Now, I spent a good chunk of time yesterday considering the proximate cause issues.
May I clarify? I was going to request that the court just state on the record the purposes for denying that particular charge.
I'll have to go back into it and think that through. Again, it's been denied.
Thank you.
Your Honor, we have two other matters. One is a motion that I believe I copied, Your Honor, and opposing all counsel with yesterday. That's a motion to sever. As evidence developed during the testimony of Travis McMichael, and as we went through the charge conference on Friday, it does seem at this point, for the reasons that are stated in the motion, that Mr. Bryan's defenses are sufficiently antagonistic, and there's certainly sufficient spillover, if from nothing else, the vigilante evidence that was presented against Travis McMichael on Thursday. And under the totality of circumstances, we believe that Mr. Bryan is entitled to a severance. But beyond that, I will stand on the written motion as filed.
Anything from the state?
Your Honor, we ask that the court deny the motion for sever. To make a motion to sever, the defendant would have to show clear prejudice. And looking at all the bullet points alleged by Mr. Goff, and Judge, if the court would like me to go through them one at a time, I can, but none of them show any reason for severance, because there's no showing of clear prejudice here that would be a denial of due process. So we would just ask the court to deny the motion for severance, Judge. But if you would like me to, I can definitely go through each one and cite some case law for the court.
I think we need to make a clear record on it. The other issue I have is, this is after the close of all evidence. So I don't believe it's even timely. There is very little, if anything, about this case that had not been already addressed by the court from an evidentiary standpoint, well prior to even the swearing of the panel. And this has not been raised in a formal motion, although it was threatened, discussed, not discussed. It was threatened a number of times during the trial. It was never actually submitted as a motion. So I believe, to begin with, it's untimely, but I would like to hear from the state on the basis
And,
that the
Your Honor,
state believes that it should be denied.
And Your Honor, unless I'm mistaken, I believe it was raised in his omnibus packet, but from the July motions, was it raised in your omnibus packet? I believe it was.
I think we reserved it in the omnibus. My recollection is it was reserved,
Okay.
consistent with what's taking place during the trial. I know we had prepared a written motion for severance, and we elected not to file it earlier in the case. But I think the charge conference on Friday covered a great many legal issues which had been unresolved prior to Friday. legal issues that are at the heart of this case. Your Honor will recall the discussion of several points that it was suggested were akin to directing verdicts of guilt. The other issue is the vigilante social media or messaging that came in on Thursday afternoon during the cross-examination of Travis McMichael. Now, I'm not saying that somewhere in 20 million gigabytes worth of discovery that wasn't there. I'm sure it was, but the state had not indicated, I don't believe, to any of the counsel in advance of the trial that they intended to use that. They did not use all kinds of other evidence that was highly prejudicial. But in any event, until they actually present that testimony, they don't create that issue. And then there's also the after-the-fact conspiracy issue and the spillover from the unindicted fourth defendant, Jackie Johnson, and the complications that has created. Anyway, Your Honor, I filed a motion. The court can deny it. It's untimely. The court can hear from the state, and we can go from there.
Yeah, I'll hear from the state. I just want to make sure we've got a clear record on it. Go ahead.
So, Your Honor, in ruling on a severance motion, the court should consider the likelihood of confusion of the evidence in law, the possibility that evidence against one defendant may be considered against the other defendant, and the presence or absence of antagonistic defenses. We don't believe we have antagonistic defenses here. A defendant who requests severance bears the burden to make a clear showing that a joint trial would lead to prejudice and a consequent denial of due process. Notably, a showing that a separate trial merely would give the defendant a better chance of acquittal is insufficient. In terms of the actual bullet points in the motion, Judge, I think numbers 1 through 5 essentially deal with voir dire, Jackie Johnson, something from the Atlanta Journal-Constitution, I believe Mr. Goff meant to put. It says prosecution, and other media outlets that are talking about Ms. Johnson being the fourth defendant. Also, he mentioned that several jurors have expressed concern about the delay in the prosecution in the case. I think he meant to put their potential jurors. As far as bullets 1 through 5 go, the potential jurors were questioned, Judge, at length about opinions regarding the delay in the arrests of the McMichaels and Mr. Bryan. Those jurors or potential jurors who said they could not be fair and impartial due to their feelings about the delay, if any, were excused by the court for cause. Those jurors said that they could be fair and impartial, or the jurors we have seated here making up the jury for this case. Also, the court has instructed the jury to stay away from the news media on this case, and we've seen no evidence that they've actually not been able to follow that law. There's absolutely no evidence that they went and saw the AJC article that Mr. Goff is talking about. Therefore, we don't believe he's made a clear showing of prejudice in bullets 1 through 5. As far as bullets 6 through 7, the only evidence of Greg McMichael's ties to the Glynn County Police Department is that maybe a few of the officers, I believe Detective Lowry testified that he knew Greg McMichael in passing. Detective Parker Marcy also, I believe he testified that he knew of him, but they didn't have any close relationships with Greg McMichael that would tend to show any reason for a cover-up. Also, notably, Jackie Johnson's name was never, ever mentioned in the presentation of evidence in this case, Judge. Mr. Goff is the only person who keeps bringing up her name. We have not elicited any evidence of a cover-up. We don't intend to argue any cover-up because it would be unsupported by the evidence. So here he's made no showing of clear prejudice to his client. As to bullet 8, the evidence showed that Greg McMichael and William Bryan knew each other, but they didn't know each other very well. Actually, Mr. Bryan didn't even know Greg McMichael had a son named Travis McMichael. Travis McMichael testified that he never met William Bryan, and there was no express agreement between the McMichaels and Mr. Bryan. There was evidence presented that Mr. Bryan and Greg McMichael were talking to one another right after the homicide happened and during the time when the officers got on scene. But this evidence, even if he were to get a separate trial, would still be admissible in his separate trial. So for those reasons, we don't believe there's been a clear showing of prejudice here either as to bullet 8. As to bullet 9, This court is going to charge the jury as to criminal trespass, burglary, hijacking a motor vehicle as Mr. Goff asked for. And it'll be up to the jury to determine what, if any, crime the alleged victim committed in this case, Your Honor. The McMichaels actually never asked for the criminal trespass instruction. I believe the state is the one who asked for that instruction. And if Mr. Bryan were to go to trial separately, we would likewise ask for that instruction in his separate trial as well. So given that, we don't believe a severance is necessary here. Regarding the different accounts from Travis McMichael and William Bryan, Travis McMichael's testimony, we would argue, actually helps Mr. Bryan, because he got up there and said he saw Mr. Bryan being attacked by the victim, his car being attacked by the victim. And then he also said, hey, there was no conspiracy between us. We did not have an express agreement. So rather than hurt his client, we believe that Travis McMichael's testimony actually helps his client. For those reasons, Judge, we don't believe clear prejudice has been shown here. As far as bullets 10 through 11 are concerned, I want to point the court to Strozier v. State. It's 277 Georgia 78. It's a 2003 case. There, the defendant asserted that the evidence against the co-defendant was so overwhelming compared to the amount of evidence against him that it had a spillover effect on the jury. Essentially, that's what Mr. Goff is arguing here. And the court there held that, quote, the fact that the evidence as to one of the two co-defendants is stronger does not demand a finding that the denial of severance motion is an abuse of discretion, where there is evidence showing that the defendants acted in concert. And here, the state's theory of the case is that all these defendants acted as parties to the crime. So, we believe that based on the holding in Strozier v. State, that no severance is warranted here either. As to the final bullet points, bullets 12 through 14, I want to direct the court to Swain v. State, 275 Georgia 150. It's a 2002 case, where the defendant argued that the fact that the jury was jointly selected with the co-defendant denied him his right to a fair and impartial jury. And in this regard, he argued that the jury was not fair and impartial because a jury chosen by two defendants would be different from a jury chosen by one defendant. And there, the court held that the mere fact that a jury chosen by two defendants would differ from a jury chosen by one defendant does not deny a defendant a fair and impartial jury. If it did, then joint trials would effectively be prohibited, as a joint trial would deny a defendant a fair and impartial jury under the defendant's rationale, since defendants are required to share peremptory strikes in selecting the jury. So, Judge, just to sum up, no showing of antagonistic defenses, no showing that the spillover effect would prejudice Mr. Bryan to the point where it would be a denial of due process. So we ask the court to deny the motion to sever.
Final word from the movement.
Your Honor, I think the grounds are covered in the written motion. I would note that in response to the McMichael's request to remove the charge I submitted on duty to inquire, we would go ahead and withdraw that charge on our own. That would resolve the issue. I hope that will satisfy the McMichael defendants.
Sounds good.
I guess sometimes people don't want help.
All right, let me look at it. I don't have to look at it right now. Before I get to that, I also have a fourth motion to prohibit any further conduct that may intimidate or influence jurors or otherwise interfere with Defendant Bryan receiving a fair trial, a motion to excuse or inquire further as to juror number 380. The court has looked at it. I think the matter has been addressed a number of times. The motion itself addresses the issues presented by Defendant Bryan. The court intends to deny that motion.
The only thing I would ask, Your Honor, is Exhibits 7 to 11 are sensitive enough that I wouldn't want them in the public record with respect to the anonymity of our juror, as best we're able to preserve it. I'm going to show these to the state, but I'm going to ask the court place Exhibits 7 to 11 under seal to preserve the privacy of Juror 380.
I think the other defendants probably need to see the matters before they're
Yes.
placed under seal.
This time I'm placing those exhibits back in the manila envelope that is marked Exhibits 7 to 11. Probably should have left them out before I did that. My apologies.
For the time being, I'm just going to attach them to the back side of the motion.
Yes, sir.
And we'll go ahead and put a sealing order on there. I understand the state has no objection to sealing these. I guess I should probably take a look before we do that.
All right, we're going to slip in a quick break as they discuss this motion. Be back with more right after this. Closing arguments coming up soon. Court TV Live, you see Judge Walmsley talking still with the attorneys. He has just asked the state if they are ready to proceed into closing arguments. The answer, yes, the panel is on its way. And in just a few minutes, Linda Donikowski will be delivering the closing argument for the state of Georgia. A lot at stake. Nicole DeBoard, Eric Purrier with us. Nicole, this is it. Both teams, all these individuals have been working months and months and months for this moment. And this closing argument wasn't constructed last night. It was a building process, was it not?
That's exactly right. This is something that these lawyers on both sides have been working on since before this trial ever began, collecting information so that they could present it in a well-organized fashion to this jury.
Eric? Oh, let's go. They're rising for the jury. Quickly, Eric, as the jury files into the courtroom, doesn't get much more tense than this, does it? Inside a courtroom and inside the stomachs of all of these attorneys.
Oh, yes. As you get ready for closing, you feel the tension, you feel the excitement, but there's stress that goes with it, and I'm sure they're feeling it.
All right, Linda Donikowski will deliver the beginning close. Each party has 2 hours. The state will break their 2-hour time allotment up. She'll deliver the first part of her close, and then she'll have the last word. As is always the case, let's listen in.
All right, welcome back, everybody. Hopefully with a long weekend, at least from court duties, y'all are back well rested and ready to go. As I indicated on Thursday, we would be ready to go ahead with closing arguments in the case here Monday morning. We are ready to do that. I understand the state is ready to proceed.
Yes, Judge.
All right, from the state.
Thank you, Your Honor. Once again, ladies and gentlemen, my name is Linda Donikowski. I, along with Larissa Olivier and Paul Camarillo, represent the people of the state of Georgia and the citizens of Glenn County. Today, you are Glenn County. So why we are here is to go ahead and present you with the state's closing argument. Now, the state gets to go first and last because the state has the burden of proof to prove this to you beyond a reasonable doubt. But not just to prove to you beyond a reasonable doubt the charges in the indictment, but remember from voir dire, you were asked, can you give meaningful consideration to the defenses presented by the defense if they put any up? Okay, and what we've heard is what? Self-defense and citizen's arrest, which the state has to disprove beyond a reasonable doubt to you as well. So ladies and gentlemen, what the state's going to do right now is we're going to go through kind of, I'm going to give you a snapshot, that kind of like, here it is in a nutshell sort of thing. And then I'm going to take you kind of through systematically, piece by piece, what the law is as it regards the charges in the indictment, self-defense, and citizen's arrest. All right? But the one thing I want to tell you before we got started is this. You will have a copy of the indictment with you in the back. Okay? So you don't have to write down the charges in the indictment. You have a copy in the back. In addition, Judge Walmsley is going to give you a copy of the law. Okay? So you'll have a copy. So when I'm putting the law up here, you don't have to furiously write it down. You will have a copy of it back there with you. All right? So let's go ahead and get started. This case is really about assumptions and driveway decisions. Now, you heard the defense talk about, well, probable cause. You're going to have to distinguish between assumptions based on gossip and rumor and all this neighborhood talk on Facebook, and actual probable cause to believe a crime had been committed and someone had committed that crime. The state's position is all three of these defendants made assumptions about what was going on that day, and they made their decision to attack Ahmaud Arbery in their driveways because he was a black man running down the street. So here's what we've got. The bottom line. They assumed he must have committed some crime that day because he's running real fast down the street, right? They did not call 911. They wanted to stop him and question him before they called 911. How do we know? Because that's what they told the police that night. That's what they said on the scene. Hey, stop, we want to talk to you. Can't do that. They made these decisions in their driveways. So what's really going on here? You know what's really going on here. Mr. Arbery was under attack. They committed 4 felonies against him. And those are the 4 felonies in the indictment. Then they shot and killed him, not because he was a threat to them, but because he wouldn't stop and talk to them. And they were going to make him, absolutely make him stop. We're going to point a shotgun at you. That'll make you stop. That should make you stop right here in your tracks because we want to talk to you. And what did he do? He still ran away. Still ran away. For 5 minutes, ran away. Travis McMichael went to intercept him with that shotgun, and he turned that corner. We can't see whether Mr. Arbery attacked him or grabbed the shotgun or anything. It doesn't matter. Because how fast did he shoot him? How fast did he just pull that trigger? They shot and killed Ahmaud Arbery. They all acted as a party to the crime. You'll note they've been indicted that way. And I'm going to talk about what party to a crime is so that you understand that concept. But the bottom line is, but for their actions, but for their decisions, but for their choices, Ahmaud Arbery would be alive. And that's why they've been indicted with murder, felony murder, and the 4 felonies that led to the murder. So what is the defense? I mean, I'm just going to take it right down there. We talked about that. What is the defense? We got self-defense. What is that? Well, they're going to try and convince you that Ahmaud Arbery was the attacker, that he was somehow threatening to them. 3-on-1, 2 pickup trucks, 2 guns. Mr. Arbery, nothing in his pockets. Not a cell phone, not a gun, not even an ID. They want you to believe that he is the danger to them. And Mr. Rubin said it in the opening statement. He was scary. So here's the thing. They're going to try to claim that they were justified in their actions. Okay? Because here's the thing, ladies and gentlemen. You cannot claim self-defense under certain circumstances. You can't. You don't get to say, I was acting in self-defense, and there's 3 of them, and it's the law. This isn't just something made up. There's 3 of them in the law, okay? If you are the initial unjustified aggressor, you don't get to claim self-defense. If you're committing a felony against somebody, you don't get to claim self-defense. And the 3rd one is if you provoke somebody so that they defend themselves against you. And then you go, oh, look, he attacked me first. But you really were the one who was provoking the attack on yourself. You don't get to claim self-defense. And that's the law. So here's the problem. They're going to try and claim they were justified in starting this in their driveways. They're going to try and claim they were justified in committing all these felonies against Mr. Arbery. How? Because they're going to try and convince you that this was a citizen's arrest. That's what they're going to do. But here is what a citizen's arrest really is. Okay? This is what the law says. This is the statute, and the judge is going to give it to you. A private person may arrest an offender if the offense is committed in his presence. Right here, right now, I'm seeing you do it. Okay? Right here, right now, I'm watching you commit the crime. I'm witnessing it. You're doing it in my presence. So what's the problem for the defendants? Well, we all know that Mr. Bryan's on his porch fixing it. Where's Travis McMichael? He's on the sofa inside the house. Where's Greg McMichael? This all started when I saw him running down the street. Now, it also says, or within his immediate knowledge. Well, the judge is going to charge you that that's synonymous. It means the same thing. So you got to think about, well, in my immediate knowledge, what does that mean? Think about the eye in the sky, you know, at Walmart. Like you're in Walmart, right? And you see all those things in the ceiling. You know there's a guy in a booth watching a bunch of video cameras, right? So he's not standing next to the person shoplifting, right? When she shoplifts, right? What's he doing? He's watching it on the camera. That's immediate knowledge. He's not right there, next to the person shoplifting, but he's watching it, so he has immediate knowledge because he can see it eye in the sky. That's just an example, how to think of immediate knowledge. But immediate knowledge and in your presence is the exact same thing. In order to make an arrest of an offender, the offense has to be committed in the private citizen's presence. Do we have that here? No. In addition, you will be charged, this is the second line, if the offense is a felony. So once again, the offense has to be a felony. The judge is going to charge you. Criminal trespass and loitering and prowling are misdemeanors. Okay? I'm going to pause right now. I'm going to ask you to read the criminal trespass thing. In order to be a criminal trespasser, you have to enter on the property with the intent to do an unlawful act, or somebody has to have told you you can't come back here, like Larry English or his representative. Well, Mr. Arbery was never told, don't come back here. You're not allowed. This is private property. He was never told, so he doesn't fall under criminal trespass. Now, I don't want you guys to make the mistake of thinking that we're endorsing, kind of, or not acknowledging what Mr. Arbery was doing. I mean, let's get real. All right, what was Mr. Arbery doing? He's going on to somebody else's private property. Yeah. What was he doing? We can see it. Wandering around for a few minutes each time. Right? And then what would he do? He'd leave. On video, never took anything, never damaged anything. So ladies and gentlemen, you decide. Is he this giant burglar who just happened to never show up with a bag or any means to steal anything? All right? Or is he a looky-loo? Yeah, a looky-loo who's going in there at night. He shouldn't be doing that. I mean, we all know this, okay? But it's trespass. It's a misdemeanor. And on February 23rd, 2020, none of the defendants knew that he had been inside in broad daylight, that location. And what did he do on the 23rd of February? Did the same thing he always did. Wandered around, and then left and ran off down the street. But they didn't know that. They had no immediate knowledge of that. It wasn't in their presence. Travis McMichael's on the couch. Mr. Bryan's in front of his house. Greg McMichael, you saw, he can't even see down the road. There's that trailer there. Remember the drone video? Citizen's arrest. This was not a citizen's arrest. Not present when any crime was committed. The suggestion that Ahmaud committed a crime is based on what? Not immediate knowledge, speculation. Speculation. How do we know? Because of the defendant's own words to the police. That's how we know. Wanting to question Ahmaud demonstrates uncertainty. Hey, where are you coming from? They don't know where he's coming from. What are you doing? They don't know what he's doing. Remember Mr. Bryan? Heard, what'd you steal? Okay? They don't know what he's done. They don't know why he's out there running. They don't have immediate knowledge. They have no knowledge. They have speculation because he's running down the street. Wanting to question Ahmaud demonstrates a lack of immediate knowledge, which is required under the citizen's arrest law. Because it's required, that means this was not a lawful citizen's arrest. Remember what Greg McMichael said? Did this guy break into this house today? I don't know. But hey, law enforcement officers, I'm sure he must have committed some crime today, so why don't you go out and figure out what crime it was that he must have committed today? Why do they think he must have committed something? Because he's running down the street. He might have gone into somebody's house. Pure speculation. And after he's lying there dead, Greg McMichael's there telling the police, hey, why didn't you investigate? Because I'm sure he committed some crime today. That's not a citizen's arrest. Not legitimate at all. So what are you going to hear?
I hate to interrupt closing argument, but the state is misstating the citizen's arrest law repeatedly in this section of its argument. And I'd like the court to instruct the jury that the law will come from the court. This is not an accurate statement of it.
The court is going to charge the jury on the law, and as indicated, you'll have a copy of that charge with you to review during your deliberations in the state.
Thank you. Judge is going to charge you these exact words. Judge is going to charge you these exact words. So what are you going to hear? The state suspects that what you're going to hear from the defense is this, that Travis McMichael had probable cause to believe that Ahmaud stole the stuff off the English's boat in 2019 and was escaping that felony on February 23rd, 2020. Not really sure how you escape on February 23rd, 2020 from a crime you supposedly committed on some unknown date in 2019 that Travis McMichael's mom told him about. But basically, we have this where he came in, took the stand, and said, yeah, that's what was going on. So I was going to go ahead and arrest him for this. Here's the problem. This was completely made up for trial because no one anywhere at any time ever mentioned Larry English's boat. Never on February 23rd, 2020. Travis McMichael had 2 hours and 45 minutes to talk to the police. He was given an hour to write a 3-page statement. An hour to write it down. Never, ever, ever once said anything about this. So what can you go ahead and assume? A year and 9 months later. Completely made up for trial. All right, so simply put, ladies and gentlemen, if you determine that this was not a citizen's arrest, this was not legitimate, he had no probable cause, you can't do this based on the law, then guess what? They're not justified in killing him. They're not justified in any of the felonies they committed against him. Not a citizen's arrest. Therefore, you're not justified. You're the initial aggressor. You're committing felonies. Self-defense. And that gets us to the charges in the indictment. So that's what we're looking at here. Based on that, at that point, you may find them guilty of all the charges in the indictment. All right, ladies and gentlemen, that was the snapshot view of what I think you're probably going to hear from the defense and what the state's position is on that. So now we're going to do some deep diving. What we're going to do is we're going to talk about the juror's duty. We're going to talk about some legal concepts that you need to be aware of. The judge is going to charge you. We're going to go over the charges in the indictment. We're going to talk about party to the crime. And then we're going to kind of really get into what self-defense and citizen's arrest is. And I know it's going to take a minute. Bear with me, but this burden's on the state. So we have to go through all of these things. All right? So here we go. Juror's duty. First off, this is your search for the truth. Okay? This isn't about the state. This is your search for the truth. You are Glenn County. You decide whether they're guilty or not guilty. Not the defense attorneys, not the state, you. Your search for the truth. You determine what really happened based on the evidence presented. Okay? And ladies and gentlemen, I'm going to go ahead and tell you right now, what's the evidence presented? Well, you can go ahead and look at State's Exhibit 190, which was the actual video. 191 is the half-speed video. You can take a look at State's Exhibit 194, the night owl video. You can go ahead and take a look at 129. That's that close-up compressed, sort of enhanced for coloration video that was produced that shows the close-up of Travis pulling that shotgun up. You can go ahead and take a look at State's Exhibit 117, Officer Rash's video. You can also take a look at 124, the video from December 17th, 2019. And of course, you can always ask to see State's Exhibit 315, the frame by frame, if you want to see it. So how that works is you send a note to Judge Walmsley and you go, we'd like to go ahead and review that evidence, and you come into the courtroom. When you come to the courtroom, we don't get to say anything. Okay? Nobody gets to talk. And actually, at that point in time, you're in control of what you get to watch here in the courtroom. So I wanted you to be aware of that in case you want to review any of this evidence. All right. You are the finder of fact. Not the state, not the defense. You are the finder of fact. You determine witness credibility. All right? You're the one who decides whether you believe these witnesses or don't believe these witnesses, or how much weight you give a witness's testimony. You're going to apply the law that the judge gives you to those facts as you find them to be, and that's what you're going to do. So, You have a duty to follow the law. You're bound by the instructions and the law that the judge gave you. In other words, this isn't about becoming an advocate for one side or the other. This is about what are the facts, and here's the law, and we apply the law to the facts. You have a duty to deliberate. Okay. The reason I put this slide up is because one time we had a woman who went and hid in the bathroom for like an hour and a half. Like hid in the bathroom. And the jurors didn't know what to do. They were just sitting back there for an hour and a half and had no idea what to do. Anything like that happens, just send the judge a note. Okay? Anything weird happens, anything you're unsure of happens, send the judge a note. But you have this duty to deliberate, to talk about the case. Now, sometimes it's helpful to think about what's inside the circle and what's outside the circle. Okay? Because there's some things outside the circle that you're not or shouldn't really talk about. And what are those? Well, that mostly concerns penalty and punishment. Ladies and gentlemen, you're going to be given a verdict form, and on that form you're going to write not guilty or guilty. That's all you're going to do. Okay? So it's not about passion or prejudice or you disagree with the law, you don't like the law, conjecture. It's about the evidence. And so what do you consider? Well, you consider the elements of the crimes. Judge Walmsley is going to give you that. The law. The expert testimony. Okay? Fingerprints. Fibers. The medical examiner. The photos and documents. Look at the crime scene photos. Take a look at those photos. They're hard, but take a look at them. The testimony of the witnesses, the credibility of the witnesses. The defendant's actions. Their driveway decisions and how it led to someone lying dead from 2 gunshot wounds in the middle of the street. The elements of the offenses. The reasonableness. And above all, use your common sense. This is the time when you put on that critical thinking cap, okay? Meaning you question everything. It's sometimes really easy to see somebody and you want just to go, well, I want to believe what they had to say. You know, I don't want to believe automatically that they're a liar or anything like that. I want to kind of give them the benefit of the doubt. This is the time, ladies and gentlemen, that you put on that critical thinking cap, where you go ahead and scrutinize everything the people on the stand said to you. So, reasonable doubt. That's the doubt of a fair-minded and impartial juror honestly seeking the truth. It's not about seeking out doubt. It's about seeking the truth. And it's not beyond all doubt or to a mathematical certainty. No. It's just beyond a reasonable doubt. That's the burden that the state has. All right, so the evidence. The first thing you're going to want to do is determine what really happened based on the evidence, but a lot of the evidence isn't in dispute, right? I mean, we know what days Larry English called the police. We know when we have videos. We know this was on February 23rd. The homicide's on video for the most part. Okay, a lot of these things are not necessarily in dispute. What's in dispute is, were they making a citizen's arrest so that they were justified in committing these felonies against Ahmaud Arbery and then murdering him? I mean, that's really what they're arguing about here. So remember, it's not a whodunit. Glenn County Police arrived very quickly afterwards. Minshew heard the shots. The defendants all made statements at the scene, immediately after. They're making statements. They're saying stuff to the police. Then, a couple hours later, the defendants are all down at the Glenn County Police Department, also making statements. But here's the thing, you've got to ask yourself, were these self-serving statements? I mean, think about it. The very first thing that we showed you was Duggan's body cam video. It was hard, right? But you got to realize, Travis McMichael is standing right behind Duggan when he rolled Mr. Arbery over. That's what he saw. That's what Greg McMichael and Mr. Bryan saw. So then you got to think to yourself, okay, what's going on in their heads? There's a dead man in the street. Travis McMichael has just shot him. Okay? The police are on the scene. There's now a video of it. So are their statements a couple hours later self-serving? You decide. The GBI did their investigation starting on May 5th, 2020, followed by the arrests. So first off, the credibility of witnesses. That's for you to determine who you believe and who you don't believe. Okay, so what does that mean is you're the one who decides whether Travis McMichael was telling you the truth or lying to you. All right? So let's talk about some of the defense witnesses. Annabelle Beasley. What did she do when she got off the stand? She walked over here and waved at them as she walked off the stand. I mean, I know you all saw that, right? Okay, so Annabelle Beasley, Team McMichael. Subi Lawrence. Who is she? Boy, Team McMichael. Even after this, after the shooting, she and Brooke Perez and Diego Perez, they're going out in the boat with Greg and Lee McMichael. They're still hanging out with them. Okay, Team McMichael. Brooke Perez, Team McMichael. Up until February 11th. And then what did she tell you? Her husband, Diego Perez, had it with this. Had it with Larry English, not calling the police. Had it with helping out Larry English. He wasn't going to do it anymore because this was not cool. Why was it not cool? Because Diego Perez went inside that house with his flashlight, and Greg McMichael came up and went in the house. What was Brooke doing? My husband's in there, my husband's in there. All right, well, Greg McMichael had his gun. Travis McMichael told you that. He had his gun, Diego had his gun, Brooke had her gun. Everybody had a gun. Everybody in this case had a gun except Ahmaud Arbery. And so what almost happened? Come on, let's get real. It's a miracle Diego Perez and Greg McMichael didn't kill each other inside that house, right? Pulling guns out. And that was it. What did Brooke tell you? No more. Not doing this anymore. You determined the credibility of those witnesses. Now, when you consider Travis McMichael and his testimony, here's some things you want to look at. The judge is going to tell you, these are things you consider. The manner of testifying. Evidence of bias for or against a party. Does he have bias for or against Greg McMichael? It's his dad. Okay? Motive in testifying. Yeah. He wants you to come back with a not guilty verdict. It's in his best interest. Think about the probability or improbability of their testimony. I wondered why he was attacking that truck. On Holmes? What are you talking about? I have no idea. Do you guys understand what he was getting at? I guess we're back to Ahmaud Arbery's a carjacker. Their interest or lack of interest in the outcome of the case, meaning do they have something to gain or lose by coming in here and making up a story for you? Their personal credibility as you observe it. That's for you to decide. Not for the state to decide, not for the defense to decide, for you to decide. All right, so did Travis McMichael have a motive to lie to you? Do you have a motive to make up additional things that he had never said before? All right? Did he have a motive to embellish his testimony? Did he have a motive to claim he now was confused on February 23rd, 2020? Isn't that convenient? Wow, it was the most traumatic, and I don't dispute that it was probably the most traumatic experience of his life. How did Mr. Arbery's day go for him? All right? Most traumatic experience for Travis McMichael. So he's all confused, but did manage to write out a 3-page statement and immediately put down, on January 1st, my gun was stolen. Had all sorts of contextual details in that statement. Did he have a motive to use talking points? Okay? Well, ladies and gentlemen, did he come up here? How many times did he say totality of the circumstances to you? Did he have his talking points down a year and 9 months later? That's for you to decide. The defendant's story. The law allows you to disregard his testimony from the witness stand if you don't find it credible. The law allows you to consider as the actual, real evidence his actions at the time of the murder if you don't find him credible. Intent to commit a crime. Well, ladies and gentlemen, you got to find that they intended to commit these crimes, and how do you look at that? Well, you look at the natural and necessary consequences of the act, right? Natural and necessary consequences of an act. Deadly force is the last resort. Never point a gun at someone you do not intend to shoot. So when you start pointing a shotgun directly at somebody, what's your intention? The natural and necessary consequence of the act. You're going to kill this person. You're pointing it at him. The defendant's not going to be presumed to have acted with criminal intent, but you may find intention, or the absence of intention, upon consideration of their words, their conduct. What did they do out there? Their demeanor, their motive, and other circumstances. So when you look at each defendant separately, because that's what you're going to do, you're going to get 3 separate verdict forms. When you look at Mr. Bryan, What were his words? What was his conduct? What's his motive? What were the circumstances there for Mr. Bryan? What were they for Greg McMichael? What were they for Travis McMichael? All right, so what we're going to do now is we're going to talk about the charges in the indictment. All right? I'm going to make a suggestion to you. This may help you. Start at the bottom of the indictment. All right? In your deliberations, start with criminal attempt and false imprisonment. It's just easier. You just work through that one, work your way on up, then to felony murder, then to malice murder. It's a suggestion. So what have we got? Criminal attempt to commit a felony, which is false imprisonment. What's an attempt? That's when you perform an act which constitutes a substantial step toward the commission of said crime. Mr. Bryan pulled out of his driveway and ran him into a ditch. Mr. Arbery was able to keep running. Right there, criminal attempt to commit false imprisonment. Criminal attempt to commit false imprisonment, this is actually what it says in the indictment. What do you have? In violation of the personal liberty of Mr. Arbery. Okay? Guess what? We're citizens of the United States, right? We live here. We have personal liberty because this is a free country. Other people can't go up and stop us and hold us and detain us. Okay? They have to actually have seen us commit that crime in order to effectuate a citizen's arrest. So you go around and you start stopping people, you're doing that in violation of their personal liberty. And what did they do? They unlawfully chased Ahmaud Arbery through the public streets of Satilla Shores in pickup trucks and did attempt to detain and confine him without legal authority on Burford using an F-150 pickup truck and a Chevy Silverado pickup truck. We all know that's what they did. False imprisonment. Now this is over on Holmes. In violation of the personal liberty of Ahmaud Arbery, did unlawfully confine and detain Ahmaud Arbery without legal authority. Once again, did not see him commit any crime, not a citizen's arrest. They are not law enforcement officers. They are not in a marked patrol car. They are not with badges on their arms. They're not in any uniform. Without legal authority. Said accused did chase Ahmaud Arbery with an F-150 pickup truck and a Chevy Silverado pickup truck to the public roadways of the Satilla Shores neighborhood and did confine and detain him on Holmes. Travis McMichael said he was pinned between the two trucks. Greg McMichael said he was trapped like a rat between the two trucks. The ultimate false imprisonment, he never left Holmes, did he? Never left Holmes. Aggravated assault did make an assault upon the person of Ahmaud Arbery with a Ford 150 pickup truck and a Chevy Silverado pickup truck. I got a legal note here for you. Okay, you notice how it says and. Okay, but what do we know? Mr. Bryan's driving the Silverado. Travis is driving the Ford F-150. Greg McMichael is in the passenger seat at first. Then he's in the back of the truck. So of course, it doesn't mean and, it's or. Okay, I know that sounds crazy. Don't you love lawyers? Don't you just love lawyers? Okay, and means or. So the way you should read this is with a Ford F-150 pickup truck or a Chevy Silverado pickup truck. Okay? So, what are pickup trucks? They are objects when used offensively against someone can result in serious bodily injury or death. You hit somebody with the F-150 pickup truck intentionally? You hit them with a Silverado intentionally? Are you going to hurt them? Break a leg? Paralyze them? You could even kill them. We all know that. Hit and runs, right? Vehicular homicides. We all know this. And the medical examiner told you so. Actual injury to Ahmaud need not be shown for aggravated assault with the pickup trucks. The judge is going to instruct you. You don't have to actually hit the person. You don't actually have to injure them for it to be aggravated assault. What you have to do is place that person in reasonable fear of receiving a violent injury. This is really important, ladies and gentlemen. Did the defendants commit acts with their pickup trucks that placed Ahmaud Arbery in reasonable fear of receiving serious bodily injury? Yeah. Yes, they did. We know Mr. Bryan did. He ran him into a ditch, then tried to go at him again, then went at him another time, then backed up toward him. Now, what did Travis McMichael get on the stand and say? Oh, I just pulled up next to him. No, I didn't startle him. No, he wasn't afraid of me. Do you believe any of that stuff? Just look at the night owl video. Look at how Mr. Arbery tries to get away from them, and then look at them speed off after him. So all you have to do is look at that night owl video, and you'll know that they put him in reasonable fear of receiving bodily harm, violent injury, aggravated assault with the pickup trucks. Aggravated assault in count 6. Did make an assault upon the person of Ahmaud Arbery with a firearm, a deadly weapon. That 12-gauge pump shotgun with 7 already in it. 2 steps, pull the trigger. That's all you gotta do. The evidence is that the defendants attempted to cause a violent injury to the alleged victim by shooting him. Now, that's aggravated assault with a shotgun. Now, I want to be really clear, okay? Travis McMichael does this with the shotgun. We see it on the video. This is the beginning of the aggravated assault. Beginning of the aggravated assault. The aggravated assault continues as he steps away from his car door and blocks the road. Now, what did he say to you? Oh, he's putting distance between me and Mr. Arbery. Was he putting distance, or was he blocking the road? You decide. Then what does he do? He doesn't stay right there, does he? We can't see this, but what do we know? He makes it around that car door, right? He makes it over here, right? He's in front of his truck, and he's moving forward, closing the distance on Mr. Arbery, intercepting Mr. Arbery, and is right here with that shotgun. It wasn't at port arms like this. It was right like this. And how fast does Mr. Arbery come around the corner? And boom, shoots him. That is one continuous aggravated assault ending in the shotgun blast to his torso, right here. Came out right here. Right? So how was he when the shotgun hit him? Like this. Right? Got it across the wrist, got it right in the torso, came out right here. So he's turned like this, according to the medical examiner. Felony murder. Felony murder is when you commit a felony and someone dies because of the felony. Classic felony murder scenario. Guy goes into a convenience store to rob the convenience store. He's not there to murder anybody. He's not there to kill the clerk. He doesn't know the clerk. But he's got a gun, right? So what does he do? Pulls out the gun and is pointing it at the clerk. And the clerk's like, and what does the clerk do? The clerk goes and tries to hit the gun away and starts punching at the armed robber, right? And then what does the armed robber do? Boom! Kills the clerk. Was committing a felony. You cannot claim self-defense. You've now murdered the clerk because during the felony that you were doing, you pointed, you were doing armed robbery, you're pointing a gun at somebody. You expect when you're committing felonies, people are going to fight back, right? The convenience store clerk's entitled to fight back, right? Imagine if armed robbers could come in and go, well, I had to defend myself against the victim of my crime. Could you imagine if that was the law? Right? I mean, but isn't that what they're saying? How dare Mr. Arbery defend himself against their 4 felonies? Isn't that what they're saying to you? So felony murder, let's take a look at it. What is felony murder? For felony murder, the state must prove that the defendant caused the death of another, check, by committing a felony. Check, we got 4 of them. Do not need to show malice, okay, meaning intent to commit the death of somebody. You know, like the guy showed up at the convenience store, he's not there to murder the clerk. Do not need to show he intended the death with the felony. What we have to show is this, that the felony directly caused the death. You pull the trigger on the shotgun, aggravated assault with the shotgun, yeah, immediately caused the death, right? That's a no-brainer. But what about the other 3? You're sitting there thinking, okay, Linda, what about the other 3? What are we really talking about here? Did the other 3 felonies, aggravated assault with the pickup trucks, false imprisonment, criminal attempted false imprisonment, did they play a substantial and necessary part in causing the death? The state's position is, yes, they did. In other words, but for this felony being committed, the death would not have occurred. It's real easy. But for the felony being committed, this death would not have occurred. All right, so when does this really apply? The defendants are in the process of committing a series of felonies. They're doing it together at the same time. The defendants shoot Mr. Arbery during the commission of the felonies. did that felony committed against Mr. Arbery ultimately contribute and lead to his death? So how do we look at this? Aggravated assault with a shotgun? Yes. Pointing that shotgun at him, having him run away around the side of the car, Travis McMichael intercepting him with the shotgun and then shooting him? Definitely aggravated assault, felony murder. Aggravated assault with pickup trucks. Well, once again, what do we have? Would he be dead if he hadn't been pinned between these two pickup trucks? Think about this. If he'd made it up Holmes and over on Zelwood, he'd have run out, right? If he hadn't been pinned between the two pickup trucks on Holmes, with Mr. Bryan running him towards the white pickup truck, would he still be alive? Yeah. Their use of the pickup trucks to go ahead and commit aggravated assaults on him, put him in fear of them and their pickup trucks, meant he was running away from them. He saw it, running away. Did their actions, were they such that they put him in reasonable fear of receiving bodily injury? And did that contribute to him ending up where he ended up and his death? Yes, it did. Felony murder. False imprisonment on Holmes. That's what we're talking about. Did they falsely imprison him on Holmes? We've already gone over it. Had him pinned on Holmes, trapped like a rat between the two pickup trucks, according to Greg McMichael. He's still, after 5 minutes, running away from them. If they hadn't done this, on Holmes, would he be alive? Ask yourselves that. If the answer is yes, felony murder. Check it off. Criminal attempt at false imprisonment. So you're thinking, well, Linda, I mean, seriously, okay, that was over on Burford. I mean, yeah, they pulled up to him. Hey, stop, we want to talk to you. He runs away. They pull forward. They go down to the end of Burford. He then runs away from them again. They're trying to falsely imprison him over there. Did that contribute to it? Yes, because that's when they began their attack. They're using the pickup trucks over on Burford to put him in reasonable apprehension of receiving serious bodily harm. They're putting him in fear with their actions. What does Mr. Bryan do? Actually runs him into a ditch. Runs him into the ditch. Aggravated assault. So what's Mr. Arbery doing? We know he runs away from them, and runs away from them, and runs away from them. Because they have tried to falsely imprison him on Burford, and they've used these pickup trucks to do it in a manner that's likely to cause him fear. We don't know what was going through his head. Nobody knows. That would be speculation. But you're allowed to look at it and go, were their actions such that it would put a reasonable person in fear of getting hurt? That's what you want to ask yourself. Those are the felonies in the indictment. So malice murder. What's malice murder? Well, cause the death of another person unlawfully and with malice aforethought. Now, malice aforethought is not ill will or hatred. It's not like what we think of. No premeditation is required, okay? Rather, it's the unlawful intention to kill without justification, okay? Well, what's justification? Justification is self-defense. Deliberate intention to kill is one way you see malice murder. I'm deliberately taking your life. I'm killing you. How do we usually think about that? You're out to get somebody. You want the husband murdered for the insurance money. You're going to go ahead and execute somebody. You're mad at somebody. You're enraged at somebody. You intend to kill them. That's deliberate intention, right? But there's another kind of malice, and that's implied malice. You are allowed to consider this when looking at malice. You may also find malice when there does not appear to be significant provocation, and the circumstance of the killing shows an abandoned and malignant heart. Don't you love lawyers? What the heck is an abandoned and malignant heart, right? Well, think about that. You just don't care. You just don't care. What you're doing, you want to do what you want to do, and boy, whoever you're doing it to had better be okay with it. I'm going to order you to stop and talk to me. And if you don't, I'm going to pull out a shotgun on you. And hey, you're still going to run away from me? Oh yeah, I'm going to come at you. I'm going to intercept you over here at the corner. How dare you turn on me? Bam! Malice, right there. Remember, Mr. Arbery had to have engaged in significant provocation. What did he do? What did Mr. Arbery do? He ran away for 5 minutes. He ran away from them. Ran away from them for 5 minutes. That's what he did. With his hands out at his sides, in those baggy shorts he had on. No weapon, no threats, no way to call for help, didn't even have a cell phone on him. Ran away from him for 5 minutes. The state doesn't have to prove premeditation. The state does not have to prove motive. Okay? Not required to explain to you why they did what they did. You know what they did. Some of you may know why they did it. But the state does not have to prove exactly why they did what they did. The indictment. So here's the thing, party to a crime. How in the world could Defendant Bryan be held responsible if he was in the Silverado filming all this, right? How can Greg McMichael be held responsible if he's in the back of the truck, finally on the phone with 911 when the shots ring out? Well, it's called party to a crime. That's what it's called. So what's party to a crime? Well, ladies and gentlemen, let me ask you this. Do you think that everyone involved, from the person who actually commits the crime, to someone who encourages or enlists someone to commit the crime, to someone who helps commit the crime, should be held responsible under the law in Georgia? Do you think that sounds reasonable? Well, guess what? The law does. The law says everybody involved is guilty. Okay? Person is a party to a crime only if that person directly commits the offense. Driving the trucks, pulling out that shotgun, attempting to falsely imprison, helping to trap somebody by pinning them between two pickup trucks, running someone towards a man with a shotgun, all directly committing or helping in the commission of the crime, or advises and encourages. Well, what's advising and encouraging? Hey, Travis, get your shotgun. That guy is outside. Not, hey, Travis, I need to call 911. That guy is outside. Let's get our guns and let's jump in the truck. Encouraging. Advising. Cut him off, cut him off, cut him off. Is what Greg McMichael said. So that's what we've got. Ladies and gentlemen, how do you really want to think about this? Everybody gets a Super Bowl ring, right? The quarterback gets a Super Bowl ring. The guys in the field get the Super Bowl ring. The dude on the bench gets a Super Bowl ring, right? Everybody is involved. Everybody's responsible. That's what the law says. Cooperation after the fact. Now this applies to the defendants, but mostly, kind of Mr. Bryan, because this has been brought up when he was talking to Agent Seacrest and everything. So, first off, cooperation after the fact doesn't erase the crime you committed. Bryan did film the murder on his phone. He gave the phone over in the video right away to the police. He made statements to the police at the scene, at Glenn County. He then goes and makes additional statements to the GBI in May of 2020. He consented to have his home night owl video downloaded. Guess what? Doesn't matter. Cooperation after the fact does not erase what you have done. Okay? That would be like two teenagers shoplifting at Walmart, and one's filming the other, he. Both of them are stuffing bikinis into their bag, right? The fact that one of them hands over her video of her girlfriend doing it, does that somehow make her not guilty of stuffing a bikini in her own bag? No. You still did the crime. So what if you were cooperative afterwards? Still responsible for your actions. This is about responsibility. All right, we're going to transition right now. I'm going to take a breath. And we're going to transition into self-defense and citizen's arrest. How's my time? person is justified in threatening or using force against another person when and to the extent that he reasonably believes that such threat or force is necessary to defend himself or a third person against the other's imminent use of unlawful force. Wow, that's a mouthful, right? Yikes. Okay, let's break it down. Travis McMichael had to reasonably believe that it was absolutely necessary to defend himself, and of course he threw in his dad, okay, which he never mentioned before at any point in time, but he threw him in on the stand, against the other's imminent use of unlawful force. That means Mr. Arbery had to be right there, imminently using unlawful force against Travis McMichael. Okay? It's the doctrine of reasonable beliefs, and the judge is going to go ahead and charge you on this. In other words, the belief that you have got to defend yourself, that it's life or death right here, right now, has to be reasonable. Okay? Guess who this standard applies to? Just take one guess who this standard applies to. Everybody. It applies to you. It applies to law enforcement. It applies to military people. Okay? It applies to Jason Bourne, Secret Service, CIA, FBI. It applies to everybody. There is no special exception for I was in the Coast Guard. There is no special exception for I used to be a law enforcement officer. The reasonableness applies to retired law enforcement officers just like it applies to anybody. A manager of a store, okay, applies the same way. In other words, the reasonableness standard is set by society. You all decide whether this was reasonable or not. Travis McMichael's belief that he had to defend himself with lethal force has to be reasonable. So we got pointing a shotgun at Mr. Arbery when he's yards and yards away, had to be reasonable and necessary. But where's the imminent use of unlawful force by Mr. Arbery? What was he doing? He's running away from Mr. Bryan's truck. Mr. Bryan has already tried to hit him with the truck numerous times. He's trapped between two cars with no weapon, no way for anyone to help him because there's nobody out there to help him. He's not threatening anybody. He's just running away from the man with the shotgun. Look at this. I mean, take a look at this. He's not even up to those mailboxes on the side. And that's Travis McMichael pulling that shotgun up. Well, what are they going to tell you? They're going to tell you what Travis said. Oh, he was running toward me. And I could tell he was going to attack me. Is that reasonable? Who brought the shotgun to the party? Who took the shotgun out of the car? Who pointed the shotgun? The guy's running away from them for 5 minutes. Here's the thing, you cannot create the danger to yourself. That means you cannot be the initial unjustified aggressor. You can't create the situation and then go, I was defending myself. You just can't do it. He moved to intercept. He attacked him. I'm not talking about Mr. Arbery attacking Travis. All right, here's the concept of excessive force. And this is a big one, because here's the thing. If you use excessive force during your self-defense, guess what? You're not justified, you're guilty. Not justified, you're guilty if you use excessive force. Because it's force that exceeded what was reasonably necessary. You guys ever heard the term that's saying, you can't bring a gun to a knife fight? It's unfair, right? You can't bring a gun to a fist fight. It's unfair, right? You can't use excessive force. You can't call someone out and go, hey, buddy, let's take it outside. You're starting it. And then when that person starts to beat you up and is better at the fight than you don't get to pull out a gun and shoot him. You started it. You called them out. They're better at this than you. And all of a sudden, you're like, I'm scared. I have to defend myself. That's not the way this works. Excessive force. So first off, Ahmaud had to be using unlawful force against them. Remember the guy running down the street, right here? He's using excessive force, he's using unlawful force against them right here, right? Then Travis McMichael had to reasonably believe that he had to defend himself against Mr. Arbery. And they're going to get up here, and the thing is, ladies and gentlemen, they're good. These defense attorneys are good. They're going to get up here, and they're going to make it perfectly, they're going to make this seem like, oh yeah, this is scary. And Travis had to pull a shotgun out on him. They're going to make it seem so reasonable. Put on your critical thinking caps. Use your common sense when they're up here giving their closing arguments. The amount of force has to be reasonable. Unarmed man running with hands at the sides, never pulled out a weapon, never threatened anybody. This is completely excessive force. Even if you think, ladies and gentlemen, even if you go, hey, it was citizen's arrest, hey, he was really defending himself, you then still have to go, this wasn't excessive force, in order to find them not guilty. All right? What you didn't hear from the defense in their opening statement are the 3 instances when a person can't claim self-defense under the law in Georgia. Can't be the initial unjustified aggressor. This is important. You can't start it with your driveway decision, unjustified, because you didn't see a crime committed that day, and then claim, oh, I acted in self-defense. What's their justification? What are you going to hear? We wanted Ahmaud Arbery to stop and talk to us, and he wouldn't. So we tried to force him to stop, and then we killed him. I mean, that's really what they're going to get up here and tell you. They'll probably make it seem much more palatable and okay, but that's really what they're going to tell you. You can't commit felonies against someone and then claim self-defense. You can't be the armed robber in the convenience store pointing the gun, and when the clerk goes to defend himself by grabbing that gun or hitting the armed robber, you can't shoot him. The law goes, not self-defense when you're committing felonies against someone. And you can't provoke someone into defending themselves against you so that you can intentionally harm them and then claim self-defense. Okay, what's that about, ladies and gentlemen? Think of your schoolyard bullies. Think of the 3 boys walking behind the one who's the target, kid who's getting abused, right? Okay, so you got 3 on 1. They're going down the hallway. They're menacing him, maybe threatening him, and they get him up against a locker, and he has nowhere to go. He's trapped, right? So what does the kid who's being bullied do? He takes it, and he takes it, and takes it until he can't anymore, and he finally shoves the one bully, and what does that bully do? Bam! Punches the target child, right? What's the bully always say? He started it. Isn't that what the bully always says? He pushed me. I was defending myself. Yeah, 3 on 1 with one kid up against a locker. You're bullying him, and he actually pushes you, and you get to then claim you were acting in self-defense when you punch him? Guess what? The law knows people do this. I mean, you get this. This is the law. The law knows people will goad other people into defending themselves so that they can claim, I was acting in self-defense. You can't do that either. 3 on 1, 2 pickup trucks, 2 guns, unarmed. Mr. Arbery was unarmed. So what are you going to hear? I don't know what they're going to say. They're good. They're good defense attorneys. They're going to get up here, and the state is so worried that they're going to make it seem so reasonable, that everything that Travis did and Greg did is just so reasonable. I'm just going to ask you, use your common sense and put your thinking caps on. But this is what I anticipate, what we anticipate they're going to say. The victim started it, or you're going to hear that he was the aggressor, okay, because he was running towards Travis McMichael, but he was running away from Mr. Bryan, who'd already tried to hit him with the pickup truck. And Greg McMichael said it. He was trapped like a rat. He knew there was nowhere else to go. Or they're going to tell you that, ladies and gentlemen, this is really about the front of the pickup truck. Forget everything else. It was all about the front of the pickup truck. And they're going to try and make it seem like, well, he attacked Travis McMichael. He very well might have. We can't see. What we know is his hand was like this, right? Doesn't matter. You know why it doesn't matter? Because they weren't committing a citizen's arrest. They weren't in fear, real fear, of imminent danger from Mr. Arbery. They were committing the 4 felonies. That's what they were doing. You're going to hear we weren't committing felonies. We were doing a citizen's arrest. We weren't trying to provoke him into defending himself. You're probably going to hear this. Yes, we pointed a shotgun at him to get him to comply with our orders. Not sure why anyone should comply with their orders to stop and talk to us, but there was no reason for him to defend himself against us because this was a citizen's arrest. Ladies and gentlemen, this is the bottom line. As I said in opening, I'm going to say it to you again. This was an attack on Ahmaud Arbery. They committed the crimes. They committed the 4 felonies. They attacked him. They shot and killed him. They can't claim self-defense under the law because they were the initial unjustified aggressors and they started this. And they were committing the felonies against Ahmaud Arbery. They have to somehow justify their actions by claiming citizen's arrest. I'm going to remind you once again, evidence from the witness stand, they never, ever said on February 23rd, 2020, that they were doing a citizen's arrest or trying to arrest him. It was all, we wanted to stop, we wanted to question him about what he was doing because he must have committed a crime that day, and we were going to hold him so the police could go back and figure out what crime it was that he must have committed because he was running down the street. Citizen's arrest. If the offense is committed in his presence or within his immediate knowledge. If the offense is a felony and the offender is escaping, a private person may arrest him. So what are they going to do? They're going to do this. Oh, I'm sorry. I forgot to tell you this. A private person may not act on the unsupported statements of others alone for their probable cause. What does that mean? No gossip, no hearsay, nothing along those lines. In other words, my mom told me about this, where she has no personal knowledge of it, doesn't count. That's unsupported, unreliable statements of somebody else. You have to have more than stale information from an unreliable source. A private citizen's warrantless arrest must occur immediately after the offense, or in the case of felonies, during the escape. If the observer fails to make the arrest immediately after the commission of the offense or during escape in the case, his power to do so is extinguished. Okay, what does that really mean? A citizen's arrest is for emergency situations when the crime really happens right in front of you and you can take action right then and there to arrest somebody because you know about it. You've seen it. You're taking action right then and there. If it's a felony, you can run after the person and chase them down. That's all this means. So it's not a citizen's arrest. They never said it. None of the defendants saw Mr. Arbery commit any crime that day. They were detaining him for the police so that they could investigate and find the crime that he must have committed that day because what is he? He's running down the street. That's not the law, ladies and gentlemen. Not the law at all. Travis McMichael, remember all his assumptions? He got up here and I wrote them all down. He may have run by. Matt Albenzi may have seen him. He may have broken in. Maybe the owner's down there. He may have been caught. He may be trying to avoid the police. That's testimony from the witness stand. He didn't know anything. Absolutely nothing. So where are we going to end up? This is where we're going to end up. Travis McMichael had probable cause to believe that Ahmaud stole the stuff off the English boat in 2019 because his mother gave him some gossip about stuff being stolen. And he was escaping. Use your common sense. How do you escape from a crime on an unknown date in 2019 on February 23rd, 2020? I'm sure they'll explain it to you. But use your common sense. And remember, what do you think? You think all this was completely made up for trial? Especially given no one ever said it on February 23rd, 2020? Ladies and gentlemen, use your common sense. Put your critical thinking caps on. It's all the state can ask you to do. Ladies and gentlemen, I give you the defense.
All right. What we're going to do, ladies and gentlemen, is take a short recess. Let's go ahead and take a 15-minute recess, and then we'll come back for the continuation of closing arguments. Again, do not discuss this case amongst
Okay,
yourselves.
Linda Donikowski delivering a powerful closing for the state. She'll have the last word as well. We'll take a break, talk about what we just watched after this statement. Welcome back to Court TV Live at our continuing coverage of the Ahmaud Arbery trial. Ooh, what a powerful close. And this is just the first part of the close from Linda Donikowski, very animated, dialed in. I think it would be fair to say, as she articulated to the jury the law and what she says the evidence shows in this case. Eric Prier's been with us this morning and was watching along with us. He's in Davenport, Iowa. Eric, your overall assessment of what we just saw from Linda Donikoski.
I think that was one of the best closings I've ever seen the state do. I think that she just did a wonderful job stepping through with the jury the different standards, the different legal requirements to claim self-defense, to claim citizen's arrest. And as she stepped through each of those, she made a point of demolishing the idea that these defendants' actions were in any way legally justifiable. I think that she is doing a good job of also looking forward to what the defense is likely to present in its closing, trying to argue against that. And I think she did an excellent job by reserving part of her time for the rebuttal portion so that the defense is not left with the last word. All in all, I think this really is one of the best closings that I've seen, and I think if the jury was paying attention to that, they will recognize that this was not self-defense.
Yeah, it is fantastic. Her passion as well, mixing the law along with stories, talking about how 3 bullies would pin a kid up against a locker, and then once the kid pushed him, the bully could claim self-defense. That's not self-defense. And addressing Roddy Bryant as well, the other individual who didn't have weapons, a weapon, but as she put it, everybody gets a Super Bowl ring. If you're part of the team, whether you're on the bench or you're the star quarterback, guess what? You are part of the team. Of course, in this case, the ring is a prison sentence. Let's listen to Linda Donikoski saying that this was not a citizen's arrest, arguing the law in front of the jury, saying don't fall for it.
All right, so simply put, ladies and gentlemen, if you determine that this was not a citizen's arrest, this was not legitimate, he had no probable cause, you can't do this based on the law, then guess what? They're not justified in killing him. They're not justified in any of the felonies they committed against him. Not a citizen's arrest. Therefore, you're not justified. You're the initial aggressor. You're committing felonies. Self-defense. And that gets us to the charges in the indictment. So that's what we're looking at here. Based on that, at that point, you may find them guilty of all the charges in the indictment.
Eric Puryear, how do you follow now? Because she, to your point, she has given the jury the foreshadowing of what you're going to hear, and guess what? They are going to hear it. She did a brilliant job of sort of stealing the thunder. How do you respond if you are now delivering a close on behalf of one of these 3 defendants?
Oh, yes, those defendants are going to have a difficult time here. Defense counsel is certainly going to earn their keep today. It's going to be hard to try to convince this jury that any of their actions were justifiable, that any of their actions were proper, but to try to convince the jury that each of their actions was proper all in a row, to chain it together to get to the point of a not guilty, I think that is going to be a nearly impossible burden for the defense here. I think they have their work cut out for them.
Do you get an uh-oh feeling when you see the prosecutor knock it out of the park right before you're going to get up there like a comedian following someone who just killed it? Or do you just, I mean, you have to just stay focused, right? You've got a plan, stick to your plan.
Oh, yes. I think that on the defense side, because you do believe in your client, you believe in your case, you've lived and breathed the case for so long, you're somewhat immune to that sort of worry that an objective bystander might have. But there are times when you can tell you have an uphill battle here, and you just have to try your best. And that's what defense counsel is surely going to do here. But the facts are what they are. What happened here, from the way a lot of people, including myself, see it, this was a terrible crime. And it's hard to overcome that in closing arguments.
All right, we will hear from the defense. We're going to hear 3 versions of closing arguments because there, of course, are 3 defendants. And then the last word will go to Linda Donikoski at the beginning of quite a morning here on Court TV. We'll slip in a break before that first closing argument from the defense. You are watching Court TV, and this is your front row seat to justice. Stay with us. Welcome back to Court TV Live. As we approach the top of the hour, we're glad to have you along with us on this Monday morning, starting off another big week here as we watch together the closing arguments in the case against the 3 men accused of killing Ahmaud Arbery. The prosecution has laid the groundwork, and now it is in the hands of the defense attorneys. We're expecting that the first one will be delivered by Jason Sheffield, who, of course, represents Travis McMichael, and that will happen within the next few minutes. They're setting up the courtroom. They've brought in a large screen in the courtroom, and they have some tech people in there getting the courtroom ready for what obviously is going to be a presentation that involves multimedia, and we'll see how Jason Sheffield responds to the powerful closing by prosecutor Linda Donikowski. Eric Puryear is in Davenport, Iowa. He's been watching along. Eric, you said it was maybe the best close you've ever seen from a prosecutor. She also used technology in that it was a PowerPoint, but it was old school PowerPoint, phrases, key points, very targeted, the way she delivered using a few images, not a ton, not a lot of video, not, it wasn't bells and whistles, but was it effective?
Oh, I certainly think so. Sometimes you'll see closings and other presentations to juries that use PowerPoint that just bore the jury to death and put them to sleep, where you have the jury trying to read a bunch of tiny text on a distant screen. She avoided that sort of a pitfall. She used the PowerPoint to emphasize important points, to emphasize key parts of the law, and I think that was very well done.
There was an objection at one point during her presentation, which you don't see very often, and it's risky to do because you're breaking up the flow of your opponent. Your take on the decision to make an objection on behalf of Greg McMichael during her explanation of the law?
I generally think objections during closings are poor form. I think I've objected literally once in my life during a closing, and that was because there was such a gross misstatement of both fact and law that I had to speak up. But other than that, I've never raised objections during closing, and I've only had my own closing interrupted once by an objection that the judge found to be improper. So I think that that was a poor move. I can understand why he'd want to do it, but I just don't think it panned out very well.
Franklin Hogue leveling that objection. He's an experienced lawyer, and he was smart in the way that he finished his objection by saying, the judge will instruct on the law, and then that sort of forced Judge Walmsley to pick up on that and say, yes, I will be the one that does that. So it wasn't as disruptive, or he may not take the blame that he could have because of his expert way of doing it. Let's again look forward to, first off, the lawyers representing Travis McMichael are up. Jason Sheffield, we expect, is going to deliver this close. Robert Rubin, also co-counsel. Whether they'll tag team or not, it's unclear. How do you justify this individual's actions? He did take the stand, and in a lot of cases where the defendant takes the stand, that's what it comes down to, right? The believability of Travis McMichael. What are you expecting we're going to hear in the next few minutes?
I think we're going to hear a lot about an attempt to spin this as people trying to protect their community, people being afraid for their own safety, efforts to try to stop crime. And, I don't think the jury is going to be as receptive to that as the defense would like, but I think that's going to be the effort. And I also expect we're going to see a lot of attempts to deflect blame, not so much between father and son. I think that family ties mean that's not as likely, but I think there are going to be efforts to push the blame somewhere else in the hope it doesn't land on each defendant. And it'll be interesting to see how those three closing arguments kind of mesh together or don't.
Do you think we're... Judge Walmsley's back on the bench. Let's listen in.
Did you get set up? Yes, sir. Okay. The other thing, timing standpoint. I mean, if we... 12:30 about it? Okay. I was going to say if there's a good time to break, but 12:30. All right.
Yes, Your Honor. I have an objection. Right now, I have came into the courtroom and saw Mr. Sheffield flipping through a number of his slides that featured photos I've never seen before. They featured photos that I had not been tendered into evidence, or not part of the evidence, and then I think there was a diagram that no one testified to. So having only seen 4 or 5 of them, and I get somebody writing some stuff down, maybe on use of force continuum, and then here's the different levels, because Travis testified to that. There appears to be some sort of use of force diagram that no one testified to or authenticated. There seems to be a picture of the entrance to Satilla Shores, and then there's a photograph of like the U.S. Marine or, no, the U.S. Coast Guard symbol, which is what I quickly saw. So right now, Your Honor, I don't know what Mr. Sheffield's putting up, but I have grave concerns that he's about to show the jury a whole bunch of stuff that they have never seen and no one's authenticated or testified to in this trial at all.
These are demonstrative things, Judge. This is closing argument. We've had a lot of testimony about the Law Enforcement Training Center. That's all that is. We've had testimony about his training, and we've had testimony about use of force. These are just demonstrative. These are just demonstrative things, not in evidence. I mean, they're in evidence to the extent they've been testified about.
The only thing that caught my eye there is the argument that this is what he received.
That's what he testified
That's what he testified to.
Right. Yeah, these are just demonstrative.
And there's
visuals.
nothing on those that show the Coast Guard manual or anything like that that would be, for example, I know that the state presented a few of the pages from the actual manuals
Nothing
themselves.
from the manual. The only thing that I have is what I've created that shows he testified about officer presence, verbal commands, control techniques, aggressive response techniques, intermediate weapons, and weapons retention.
Okay. And this, what is that? Is that something you put together, or is that actually coming
Yeah,
from his
I've
records?
clipped it and cut it from things that I found.
Well, what's behind it is an orange thing that has physical fitness standards and search incident to arrest behind it. So, and it says objectives completed. Travis McMichael never testified to any of those things.
Testified to his training and that he did these things.
And what's the thing at the top, Your Honor? We have Maritime Law Enforcement Academy Student Profile Report. That wasn't tendered in, and then we've got that next to it.
Well,
for official use only?
yeah, I just intend to talk about the course that he took, the courses that he took that he testified to.
No, there's more to it. I mean, that says it's a student profile report. That was not testified to. That was not tendered in. Lost it. Yeah, I don't have any problem with an argument about what he testified to, but once we start getting into what the curriculum was or an individual report,
All right, how's that?
that works a lot.
Okay. Then I just have
better.
this.
Can you go back to
Oh, sure.
I'm just digesting.
State objects to the heading on that, since it attempts to have a photo of something that was never testified to.
What's the heading?
It has an image of some Coast Guard thing.
It's where he went to school. He testified to it. What is so objectionable about that? Mr. Rubin showed in his opening statement. Seems a little silly.
Okay. He testified to where he went to school, he testified to what he did in the training, and he testified to his rank, which I think is actually the other thing that's shown on there.
Right.
We can get back to it. Yeah, actually, that removes even that part. Okay, I don't, the objection is, I guess, granted in part. As that slide has been amended, I don't have any issue with that.
Okay.
With that. The use of that,
This
that's
is what
part of
he
the
testified
argument?
to. Yeah, this is just
Yeah,
part of the
that's-
argument.
he's talked about.
And then there's the Satilla Shores neighborhood
Please
sign.
back up one more.
What was the right?
This is his testimony at trial.
Well, wait a second. Handwritten notes by the attorney as to his testimony at trial, we're going to show those to the jury?
Of course we are. I wrote them right in front of him as he was testifying. This isn't appropriate to get this deep into my presentation. These are the notes that I took at trial, the same way that I can show this one, Judge.
Well, those are your notes.
Yes, based on his testimony. I did it in front of the jury. just like I did this one.
They're not
I can put
going
my
out.
notes up.
They're just what you're referring to.
Yeah, I'm saying,
So-
you saw him testify.
So the unfortunate thing is when everyone's just talking as I'm working through things, I can't think it through. So what you are using the slide to show is what his testimony was at the time.
The state has chosen to type it up. They've decided to type up what was said. You heard Greg McMichael say, you heard Travis McMichael say. This is my notes as I was writing, as he was talking in front of the jury with the state present during trial. I do this because it captures what's said on the stand in a visual way and the jury can understand it. I don't see what the objection is. The state can talk about and type up, but I can't show what I wrote down during the testimony. That doesn't make any sense.
I understand now what that was. I did not, and I agree, Mr. Sheffield did write those things down on the big piece of paper. If he chooses now to show it this way, the state's okay with that.
Okay?
The problem becomes the next photo of Satilla Shores. No one testified to that photo.
We're really objecting that Satilla Shores is a neighborhood with a neighborhood sign out front? What's so objectionable about that? It's just a chapter heading of what I'm going to be presenting.
Judge,
And
my fear here is just that I'm going to have to object to every single slide when it comes up where no one's testified to it or it contains information no one testified to.
Well, and I think we've just seen a number of things. The state has a continuing objection then to the Satilla Shores sign. I understand that's not in evidence, but it's the sign itself. And if it's simply being used as indicated as sort of a chapter marker, then I'll permit the defense to use that. What the changes that have been made now to the slide that showed the training, what I understand now is limited to what was actually testified to. Correct. And it will be referred to that way as opposed to here's the manual or here's what the Coast Guard instructed him. I won't limit you on exactly how you're going to present that, but as long as it's not a presentation as if it was evidence separate from testimony that was provided by Mr. McMichael from the witness stand. And the use of force continuum is just what you're using to demonstrate the argument as opposed to relying on that as a training device or something that was actually presented in training.
Right.
Okay.
So Judge, I'm just asking for a little direction from the court. These are just the first couple, so if there's some photos that no one's ever testified to that are in this, I'm going to object. If there are other things, like for instance, there's a picture of the neighborhood and somehow they've marked every time a 911 call came in. No one testified to all the 911 calls in the neighborhood, but there may be a graphic that shows all of that. If such a graphic exists, I'm not saying it does. I don't know what kind of graphic Mr. Sheffield's going to be. I'm going to object. And if this happens more than twice within this PowerPoint, I'm going to ask that we stop, unfortunately, and go through every single slide, because at that point, I'm going to be up here objecting constantly to his closing because it contains things that were never testified to and no evidence was presented at trial because of it. That is my concern.
I have a slide of the neighborhood that I created, that I put little circles on, and I put things on it that are representative of the testimony of Officer Rash and the GBI and going door to door and neighbors who have been complaining about things. I'm not going to say the neighbor at this address called 911 on this date or that date. It's argument. It's demonstrative of my argument. I don't see any basis for the state to object, and I don't have anything else in here that's a photograph.
I understand the issue, and we'll see where it goes.
Thank you, Judge.
Okay, time to get the jury, and when we come back, Jason Sheffield will be delivering the closing argument on behalf of Travis McMichael. Stay with us. Welcome back to Court TV Live on this Monday. We are about to hear from Jason Sheffield, representing Travis McMichael, delivering his closing argument. The jury just walked back into the courtroom. Let's listen in.
For the defense's closing arguments, I just want to make sure, because we've had a little bit of movement around in the jury box, that everybody can see and that everybody's comfortable where they are. If you need to move, there's at least one seat in the jury box. We can move folks over if they want. But if you're comfortable where you are, that's fine too. With that, Mr. Sheffield.
Duty and responsibility and following the law will always be intertwined with heartache and tragedy. This case is about three things. It's about watching, it's about waiting, it's about believing. Travis McMichael spent almost a decade of his life learning about duty and responsibility. He received extensive training on how to make decisions that would ultimately impact his beliefs as a petty officer in the Coast Guard, as a boarding officer in the Coast Guard, into some of the most treacherous waters extending some 200 miles off the coast of the United States. He trained relentlessly about his duty and his responsibility. Even after active service and then coming into smaller communities and working in the Coast Guard, he trained weekly, sometimes daily, on what the law provided that he do, what his responsibilities were, how he would make decisions in critical moments of policing and in critical moments of rescue. These teachings were burned within his brain to the point of muscle memory so that he could perform his duty and his responsibility to his country and his community. He talked to you about officer presence and how he trained for officer presence. He talked with you about verbal commands and how he would use verbal commands to try to police or to try to calm or to try to de-escalate situations. He talked with you about control techniques and the things that he would have to use to get control from those persons who he was investigating. Aggressive response techniques, something that he never had to use on his job, but something that he trained weekly, every Friday with the red man suit. And he talked with you also about intermediate weapons, weapons retention, and the use of deadly force. Travis spent a long time going through these things in his testimony. If you recall, I was writing feverishly as he was testifying so that I could capture what it was that he had to share with us about these things. And it includes what gave him the right to search, examine, arrest, seize, inspect, inquire. He talked with you about the level of suspicion by a reasonable and prudent person given the overall circumstances to believe that crime has been committed, probable cause. He spoke with you about the use of force continuum. He talked with you about de-escalation and how de-escalation was always the goal. He talked with you about leaps, listen, empathize, ask questions, paraphrase, summarize. Why? So that you could gain understanding, so that you could continue to investigate, de-escalate, learn what's going on, and figure it out. And he talked also about weapon retention and using a weapon, if it had to come to that, to de-escalate a situation. When When Travis moved back home to Satilla Shores, he did so with his 3-year-old son, Everett. He moved in with his mother and his father, and then eventually his sister joined them in the home. You've heard about Satilla Shores from several witnesses who came to talk to you about what they were experiencing in this once idyllic neighborhood. A neighborhood that was once a place where elderly would walk at night, kids would play after dark. But over time, how that began to lessen. And Travis began to notice it, among others, about how things in the neighborhood started to change. From learning that the GBI went around, to learning that Officer Rash went around, to what was being posted on Facebook, to hearing from witnesses on the stand, to hearing Rash talk about driving through the neighborhood, witnesses talking about police cars going through the neighborhood at night, shining flashlights. This neighborhood was being covered in suspicious persons, in extra watches, in neighborhood patrols, in concerned citizens. It was everywhere. It was on Facebook. An account created so neighbors could help each other. And the types of things that these neighbors would talk about to each other was about the crime that was being committed to them, to their neighbors, crime that they had seen happening across the street from them, crime that some was reported but not all. You heard a lot of people talk about, I didn't call the police because what's the point? Crime is over and the people are gone. But they told you that what was happening in their neighborhood scared them. It caused them concern. It was unsettling to imagine people lurking and sneaking around your property at night so that your cameras are going off, your doorbell camera's going off. That's frightening. One of our witnesses testified about how emotional she got because she had to tell her children, you can't go out at night anymore. And the steps that they took to protect each other, using Facebook, hey, be on the lookout. You heard Cindy Clark testify about how she offered to go get license plates on 2 separate occasions for cars coming in the neighborhood. Or how she called the police on a bunch of people that were walking into the neighborhood after their car had supposedly broken down, but it was really stolen. These are real experiences of real people who were very scared. And so they took it upon themselves to do something about it. Got cameras, call the police, notify each other, citizens watch, neighborhood watch. And there's absolutely nothing wrong with that. Even Travis himself had taken it upon himself to try to investigate one particular person that had been identified as possibly being homeless and living under the bridge. Travis explained to you that he had learned about a neighbor having her purse stolen. Of course, there were other complaints of crime in the neighborhood as well, and he thought, after boating home one afternoon and seeing what he thought was a homeless encampment under the bridge, that this could be the guy. So he finished going home. He got his dad, who is a lifetime law enforcement officer and investigator, and they went over and they drove and they walked down under the bridge. And instantly, when Travis did this, you saw evidence of his muscle memory. He talked about walking down, not holding a weapon out, not armed with the gun out. He had his gun with him just in case he needed it for protection. But he walked down to do what? Use leaps, to listen, to have a conversation. And as he walked down under the bridge, he saw a bunch of trash and a bunch of items and a machete and a man fishing. So he followed his training. politely stepped in between the machete and the man. He said, "Hey, bud, you living down here? Everything okay?" As he's doing that, he's looking around, looking to see if that purse is there. He's looking to see if any of those other stolen items may be there. The man responded, "No, just fishing." When they left, they called the police. You have evidence of that. You heard Greg McMichael on the call with the police, non-emergency line, just saying, "Hey, we want y'all to go check out this guy under the bridge that we've called you about." State asked Travis, "Well, why don't you describe this fella for us? White, black, Asian, Hispanic?" The white guy. Called the police. He was gone by the time the police got there, and that was the end of it. But the man under the bridge, or the idea that there could be a man living under the bridge, did not go away. That theme and that person comes back during 2019. The real problem, as the neighbors and neighborhood of Satilla Shores were trying to figure out what was going on and who may be responsible for it, was that 220 Satilla Drive residents, a residence that had a unique type of crime going on in it, one much different from what they had been experiencing. So dark you can't even see the photograph of it. But it was the photograph of 220 Satilla Shores at night, along with the dock down by the water at night. And what all of these neighbors are going to soon become aware of is that there is a repeat offender who is coming at a time when he has absolutely no lawful reason for being there. Just to start with, on October 25th, Larry English calls the police. And we learn from Larry English that there is a man plundering around. Larry English at this time only has 2 cameras, one on the dock and one behind the house looking out in the backyard of the house. Larry English says he looks drunk or on drugs. That's concerning. Larry English identifies to the police, "I have a lot of valuables in my house. Tools, equipment, things of that nature. Never seen this gentleman before and it doesn't look good." Police come, but there is no person that is found. What you need to understand about burglary is burglary includes any house, building, or structure which is designed or intended for occupancy for residential use. This unoccupied, unsecure construction site, which could be anything, is not the same thing as Larry English's residence that's being built. That's a term that the state continues to use, the unoccupied, unsecured construction site, which doesn't even begin to tell the story of what this is. On 11/17/2019, 2 people are seen on the video. It's a white couple that goes in and comes out. What's significant about Larry English's report, though, on 11/17, is not that the 2 people that I saw on the video tonight have stolen something. He says, "We had stuff stolen about a week and a half, 2 weeks ago." He's now telling the police he had stuff stolen from his home. The next night, Mr. Arbery returns. At night, pitch black dark, no lights on in the house whatsoever. And this time, Larry English has put cameras inside the residence. Now, he sees and reports that Mr. Arbery is looking inside a boat. The same boat? No. No, that boat He got there on the morning of the 18th, and he took it back to Douglas, Georgia with him. What he says right there at the bottom, brought the boat back to keep from stealing electronics off of it. He is communicating this to 911. This is official. He is reporting again. We had a situation with the same guy a week and a half ago. It says it right there. He was on about 3 people's cameras. And just to emphasize, on 12/1/19, English calls the police again. He talks about somebody might be living under the bridge. That idea is still floating out there, still considering it. But again, he says, I had a bunch of stuff stolen out of the boat, which again confirms what we're talking about. And on 2 of these occasions, we have video of Mr. Arbery inside the residence. The first on the dock, and the second inside the house looking into the boat. The video ends right there. Travis McMichael has his own horrifying experience with a man that he is about to learn has just been involved in all this stuff with Larry English. He's been told some things by his mother and his father and other neighbors before this moment, but he's going to learn some things for himself on 2/11/20. On this night, Travis is driving out of the neighborhood to go get some gas. He wants to fill up so he doesn't get 4 a.m. and do it. And on his way out, as he's driving down the road out of the neighborhood, he sees a man run across the street and then duck into the shadows. From this house, ducking through the shadows, through the trees, all the way across until he gets in front of this house. Travis backs his car up and splashes his headlights up on the house. The gentleman steps behind a porta potty. Travis then starts to get out because he wants to say, hey, what are you doing here? The guy comes out from behind a porta potty, lifts his shirt up, and acts like he's reaching in his pocket, and that totally freaks out Travis. Despite his training, despite his experience, it freaks him out. Travis tries to talk to him. Now, the guy never says, hey, I'm sorry, I am so sorry. I was walking my dog, or I'm so sorry, I did not mean to startle you, like any one of you would if you were out in the yard late at night. Didn't say anything, just did this. Travis got in his car, reversed out, stalled the car, but backed up and zipped home to tell his dad. As soon as his dad hears what's going on, his dad decides to go check it out. At the same time, Diego Perez has apparently been called, and he's going to check it out. They take firearms with them. Travis tells you, he said, Dad, whoa, wait a second. This guy could be armed. Wait a second. But his dad is already walking down the street. Travis gets in his truck, he backs up, he's calling 911, and he returns to the house where he puts the headlights on the house, watching, waiting, believing that this man could be dangerous, believing that his dad could now be in danger, believing that something awful could happen. So he posts up right here, lights on, and waits for the police that he himself called. And when the police arrive, he stands there and he talks to the police. He tells them, hey, my dad's in there. Travis, why didn't you go in there? Why didn't you go in the house? He's like, I'm not going in there. I'm not going in there. When this guy did this, that was enough for me. I'm staying out here. It's a reasonable thing to do. Ultimately, Travis calls police, and we hear what he tells police instantly on the phone. We've had a string of burglaries, a lot of burglaries and break-ins. That's what he tells them. That's what's in his mind almost from the very beginning. He startled me. He reached into his pocket. I didn't know if he was armed or not. It looked like he was acting he was. He's sneaking behind a bush. He also tells the officer he had a pistol stolen about a month ago. This is what he's saying, and you hear him breathing. And the operator says, "You all right, hon?" Yeah, he just startled me. That's real. That's a real experience with the guy going into a house after being seen at night with headlights and reaching and then turning around and going into a house that's not his. Where is the logic in that? And Travis then stays, talks with the officer, and then sees the video and sees this gentleman just walking around the house like he didn't just get stopped, caught, and seen and had this interaction with Travis like it never happened. He's just walking around the house very calmly. And Travis feels that that is so bold and brazen to do that. It frightens him about this guy. It worries him about this guy. That's real. It's what happened. What happens next is the two officers show up, and being told what they've been told, that the guy acted like he had a gun and that he went into the house, they pull out their firearms and start going through the house looking and shouting and calling with their guns out because they might need to protect themselves. Are they committing an aggravated assault when they do this? Are they committing a false imprisonment when they do this? No, they're searching, looking, and trying to apprehend whoever's in the house who may be armed. And then everybody meets outside and they talk. And this is where Travis gets the rest of the information. Aside from his own personal experience, he and his father, talking to Officer Rash, Diego Perez, Matt Albenzi, Ronnie Olson, and Brandon Gregory, the officer who also works with Glenn County Police. They talk that night. And they talk about what's been going on. And Travis gets to see the rest of the video, and he's like, yep, this guy is that guy. It's all the same guy. Been break-ins. There's been a lot of burglaries going on. He knows that stuff's been stolen already. And they have a conversation, and you heard part of that conversation from the transcript. Rash says, well, we haven't actually seen him take it. It's because there was no camera on it. But I guarantee you, if one of you left your bag in this room and we all went out into the hallway, and then I walked in here and you saw me walk in here and you never saw me leave, and when you come back in, you walk in, you go, where's my bag? Well, nobody else came in here, but Jason did, and the bag is gone, and oh, look, there's a back door. Is it reasonable to believe that I may have taken your bag? Of course it is. This is a burglary. He says, haven't seen him actually take anything? Yeah, criminal trespassing, officer arrested. Yeah, at the very least. Travis is thinking about Ahmaud Arbery. He's thinking about what must be in his mind in order for himself to try to figure some things out. Travis knows that he caught Ahmaud going into the house. He knows that. And so Ahmaud should know that Travis knows that. He knows that Ahmaud has been down on the dock, and that Ahmaud should know he's been down on the dock, that he's been on someone else's property. He's got to know that by now, Travis is thinking. He knows it's not his home or his house under construction. He knows that he's been caught sneaking around in the bushes. Travis is the one that caught him. He knows that there's been a confrontation about that. He knows, he believes Mr. Arbery's got to be, this guy, this man has to understand that these things have taken place, that he had headlights on him, that somebody was trying to talk to him about why he was out after dark in front of this house and he didn't respond. If I say to one of you, hey, how are you doing? And you just look at me and you walk away, you know you've looked at me and walked away. You know that that's part of what's happened. And he still went in the house after being confronted in the dark. And then he looked around. He knows that he's in the house looking around. And eventually, that he'll be seen on the 23rd going in the house, and that people were trying to talk to him and that he's not answering anybody any questions. And ultimately, he knows that the police are on the way. Travis knows these things must be in Mr. Arbery's mind because they were part of the very real experience that he had with him. And because of that, Travis is starting to believe and expect certain things in return. Obvious, ordinary, natural things that should happen in return. To constitute the offense of burglary, it's not necessary that a break-in happen, that something gets broken. If you recall, all the questions by the state of the witnesses, well, was anything broken? Was a window broken? Was a door broken? That's not what's required for the law. Those questions are meaningless and they are red herrings. Nothing has to be broken. You just have to break the plane of the structure to constitute a burglary. Then, you don't have to show that an actual theft had been committed. Nothing actually has to be stolen. You just have to enter with the intent to steal something. Where do we derive a person's intent to steal something from a house? Well, they certainly go into a house that isn't theirs, that contains valuables, and they do it at a time when they shouldn't be doing it, and under circumstances that are very problematic, including running from other people who see you. Lastly, Larry English's deposition. Mr. English couldn't be here, he's very sick. Watching a lot of deposition is a hard thing to do. But the basics of this deposition, you made your neighbors aware, the ones that we've mentioned, Al Benzie, Greg, Ronnie Olson, you made these guys aware that you had stuff stolen out of your boat. Yes, and in fact, you wanted your neighbors to help you catch the guy. Yes, Diego. I wanted Diego to catch this guy. You never told them at any point, hey guys, I'm sorry, it wasn't stolen when it was at my house. It was stolen when it was off property. You never told them that, did you, Mr. English? Never told them that. You never announced it on Facebook. You never announced it on Next Door Neighbor. You never corrected what you now say is it was stolen off-site somewhere. You never told your neighbors that, and he says no. So then, therefore, Mr. English, to your knowledge, they were left with the impression that stuff had been stolen from your boat at 220 Satilla. I guess so. What was Ahmaud Arbery doing in Satilla Shores from October 2019 to February 2020? There is no evidence that Ahmaud Arbery ever jogged or exercised in Satilla Shores. Not one friend, not one family member, not one eyewitness, even Rash going door to door. There is no evidence whatsoever that Satilla Shores was a place of exercise and jogging for Ahmaud Arbery. Officer Rash testified that by December 19, he knew Larry had a cooler stolen, electronic equipment stolen from the offshore boat while it was parked in the RV garage. And Bob said, that's a burglary. A burglary had been committed in this residence. And he said, that's right. But it was never reported. Like, we didn't have a report about it, so I didn't really investigate it. But that is a burglary, and he has admitted that to you as well. February 23rd. Mr. Olson's surveillance camera shows that Mr. Arbery walked into the neighborhood. Didn't run. He then stood in the yard and put his hands on his hips, looked around like this, and then went into the residence. Matt Albenzi was doing work in his yard, and he saw this gentleman who resembled the gentleman who had committed what they thought was a burglary in that residence. He shut down the work that he was doing, he put a gun in his pocket, he grabbed his cell phone, and he walked all the way up the street to the corner where Jones meets Satilla, where he keeps his mailbox. And he stood there right next to this tree, and he called 911. At some point in the video, when you see Mr. Arbery run out, you'll see he passes right through the window. And Mr. Albenzi is standing right there on the phone calling the police. His behavior then changes. Instantly, Mr. Arbery is at a full sprint, running into the neighborhood. Running into the neighborhood, which the state is going to infer means he's going on his regular job. But no, because running out of the neighborhood is a problem. It's a problem now because there's a guy standing there on the phone looking at you back in the same residence that you've been caught in now 3 times. Caught meaning on camera, and police coming and searching with lights, and Travis McMichael, and to return to that house in the middle of the day like that after being run off. Imagine going to visit a house under normal circumstances. Oh, this house looks like one we might want to buy. I'm going to go in there. Then somebody comes up to you with headlights and tries to stop you from going into the house and confronts you about it. Are you literally ever going to go back to that house again? It is unreasonable to think that he's going back there for some lawful purpose after being run out of there 3 times before. So he doesn't run out of either of the entrances to go back across the street where he lives. He runs deep into the neighborhood. Someone has called the police. Now, Travis has told you, nothing has erased from his mind about this individual in the 2 weeks between February 11th and February 23rd. It's all still there. And while he's sitting in his home, his dad comes running in the house and says, the guy who's been breaking in down the street is back. He's running past. Get your gun. Travis and his dad carry their firearms for protection wherever they go. That's what they do. The law allows them to do it. They have permits to do it. Travis testified he had a concealed permit at one point. The law allows this behavior. Travis comes out to the street. He looks down the street, right across. Here he is at 2:30. He comes out here. Mr. Arbery has already run past. He comes out here. He looks down the street from where the house is and sees Mr. Matt Albenzi, who is walking towards him, and eventually, after a couple houses, goes like this and points down the street. It is reasonable to conclude that based on what his dad said, who just came running in the house, the guy's back who's broken in, to come outside and look and see Mr. Albenzi, who he knows, who he's talked with, who he's shared thoughts and feelings about the person breaking in the house, is now saying, go that way. The guy is back. To get in his car and go. You cannot act on the unsupported statements of others. The state has characterized that, which is an accurate statement of the law, as Travis's mom. Are you kidding? After all that we have seen, after all that he has experienced, after all the conversation that he's had, after all the videos that he's seen, after what he experienced himself, that he's just going off of what his mommy told him? This is what the state wants you to do something about. This is what they're trying to inject into this case, knowing, despite that Travis has called the police on the white man under the bridge, knowing that Travis called the police on a carjacker or told his police friends when he was in the Coast Guard and a report was made about the white guy that tried to rob his truck, knowing that Travis called the police about his gun being stolen and readily admits, I don't know who stole it, knowing that Travis called the police on the 11th of February. They want to try to reduce this case down to this statement, which is not true. Travis had all of this. His reading Facebook, everything going on at Larry English's house, knowing about what was happening in Satilla Shores, speaking with everybody on the 11th, his own experience, Albenzi signaling, Officer Rash and Matt Albenzi. This is what he carried with him when he left his driveway that day. Reasonable and probable grounds of suspicion. Reasonable and probable grounds of suspicion. Facts and circumstances to warrant a prudent person, one taking care to understand the truth, in believing that the suspect has committed the offense of burglary. Travis believes he's committed the offense of burglary. The facts necessary to establish probable cause for arrest are less than those required to prove guilt beyond a reasonable doubt. It's more than suspicion or possibility. It's got to be a probability, probably. And he said, I had a probability. There was a probability that this was the guy who did it, and here's why I think he did it. And I wrote down every one of the things that we talked about as he testified. I wrote them all down, and they are all encapsulated in that slide I just told you. This is where the duty and responsibility in following the law becomes intertwined with heartache and tragedy. Because you do have the right to perform a citizen's arrest. You do have the right to have a firearm when you make an arrest. You do have the right to stop a person and to hold them and detain them for the police. And there is risk with that. And there are tragic consequences that can come from that. And we can all sit here right now and say what the state has said from the very beginning and what Travis himself recognizes. If he had only stayed home that day, if he had just sat on the couch and fallen asleep with his kid that day, Travis told you it's not a day that doesn't go by that he doesn't think that exact same thing. But the law allows the citizens to make a citizen's arrest. And if doing so properly, it is the reason for the actions that follow. Here, you talk about an offense being committed in his presence or when his immediate knowledge. What could be more immediate than February 11th? What could be more immediate than seeing the videos of him in the house and talking with police officers and other people, including hearing from Larry English through others, that he actually had stuff stolen from his property? An offense has been committed, and he knows about it. He's seen everything other than the hand on the equipment that was stolen. If it's a felony and the offender is escaping or attempting to escape, then you can arrest him upon reasonable and probable grounds of suspicion, probable cause. Travis said many, many times it was the totality of the circumstances. That's his Coast Guard brain. That's his Coast Guard brain saying everything that I knew gave me the belief that a crime had been committed. Escape. Private citizen's warrant arrest must occur immediately after the perpetration of the offense, or, in the case of felonies, during escape. Not every person is arrested at the moment they commit a crime. Not every person is arrested by police, because sometimes the police don't get there in time. But if they learn about the person and they have information about the person, escape can happen anytime. Escape can happen later. It doesn't have to happen right at the same time the crime is committed. There's no law that says that. There's no time limit imposed. The police would never be able to arrest anybody. And a citizen is in the same shoes as an officer when it comes to citizen's arrest. So, Travis, leaving his house, decides he's going to follow. That's what he does. He pulls out after his dad crammed into the front seat with the kid seat there, and he follows. And he watches. And he pulls up next to this gentleman. No gun is raised. No violence is ensued. He doesn't get out of the car. He doesn't tackle him. He doesn't do anything. He does what a reasonably prudent person would do. He does what his training has taught him to use leaps. And he says, hey, man, what's going on? Can you stop for a second, please? I just want to talk to you for a second. There is no violence. If Travis wanted violence against this man, if Travis wanted to hurt him or commit an aggravated assault or commit a false imprisonment, he could have done it right then and there. He doesn't. He talks to him. Mr. Arbery looks him in the eyes, doesn't say a word, doesn't have to, but that's information for Travis. Is it so offensive to pull up next to somebody and say, hey man, can you stop for a second? I want to talk to you. Just for a minute, hold on a second. Is that so offensive? So, he stops. He starts to go back one way. Travis backs up alongside of him, 3 feet away, not pulling in front of him, not pulling behind him, just tries to talk to him. And Mr. Arbery takes off running down the street. And Travis watches him. There he goes.
Hey, to step aside, take a quick break. Jay Sheffield, his closing argument will get you back into the courtroom right after this. Julie Grant is next. This is Court TV, your front row seat to justice.
aren't just amazing STEAM projects. They're full of awesome moments like this, and this, and this. Get your first month free at trykiwico.com.
Welcome back to Court TV Live. I'm Julie Grant. Let's take you right back to Brunswick, Georgia, where we're seeing the closing argument delivered on behalf of defendant Travis McMichael.
He's sitting on this bench in the back of the truck. Travis says he's going with his foot on the brake pretty much 3 or 4 miles an hour. Drives all the way around thinking, I'm not going to go back into this mess down here. I'll drive around. And when he drives around, you've now learned about this dog leg. That black line essentially is the dog leg. You can't see past it. Travis tells you the first thing he sees is Mr. Arbery doing a U-turn right there at the crest of that turn. What does he do? He watches. Does he drive at him? No. Does he try to tackle him? No. Does he put a shotgun at him? No. Does he yell at him? No. He's trying to continue to assess the situation in a reasonable, prudent fashion. Then he drives across the dogleg, comes all the way to the end of the street, and he sees Mr. Arbery again with this truck. Again, with this truck, tangled up with this truck. And what looks like, again, aggression at the truck. So Travis stops. He stops. He's thinking to himself, why is this guy not running through this open yard? This is Satilla right here. This is Holmes. This is where he sees the truck. What is with it that this guy's not going this way? And who is that truck? What is happening? Instead, they both run around Travis, back up around the dogleg. So Travis says, okay, I'm watching, I'm looking, I'm going to pull forward, stop in my car at the end of the street, and I'm just going to take up a spot right here. I'm going to take up a spot here. I know that he's currently not over here. I know he's not behind me. I can see my house right there. I can see up Satilla Drive, and I'm looking up Holmes. I'm just going to take up residence right here, and I'm going to watch to see what happens next. Because maybe this guy will come back and we can stop him, or maybe he'll just keep running that way. Maybe he'll keep running that way, and I can tell the police, I'm pretty sure he's not this way, pretty sure he's not over here, he's not there, he's headed that way. What he doesn't know is that Mr. Arbery is turning around up on the other side of the dogleg, and this is where our video picks up with Roddy Bryan. By now, it should be clear. Travis doesn't even know where Roddy Bryan is. To say that Roddy Bryan's turn up there and to follow him back, Travis has no idea what's happening behind the blind side of that curve. And still doesn't know who this truck is and why this gentleman is interacting with it in the way that he is. But this is what's happening unbeknownst to Travis. Mr. Arbery turns around, and you get a quick glimpse of what's up the street, and it isn't Travis McMichael's truck. It isn't there. It's because it's all the way back down Holmes near Satilla. The state is going to play the recording that you've heard of Mr. Bryan turning, driving and revving and doing all this stuff. This will be the third interaction that Mr. Arbery will have coming at this truck. And Mr. Bryan is freaked out, to say the least. So freaked out, he drops his phone. This is where the phone drops and goes pitch black for about a minute. And in this time, you'll hear sounds. You'll hear engine noise. You'll hear turning. You'll hear shifting. You'll hear seat belts clanking. You'll hear the three-point turn eventually. He says, well, you know what? I'm going to head back that way. But what you don't hear on that phone, even after audio enhancement, even after any kind of working with audio specialists and digital specialists, you'll never, ever hear any yelling and no communication between Travis or Greg. The state wants you to think that it's at this moment. Greg McMichael drives by and says, I'm going to blow your GD head off. Well, if he said it, you'd have heard it. It'd been on that telephone and they'd have played it for you. It ain't there. So, Roddy Bryan is all the way up. This blue mailbox down here, a little closer up picture, is where Mr. Arbery turns around. This is the demonstration video with Seacrest, and this is Mr. Bryan's actual video. This is how far up the road he is. This is the minute that he's been with his phone down on the floor. And in this minute, 2 times Mr. Arbery is going to run towards Travis. First time, turn around and go back. And the second time, he'll turn around and go back. And that's where that video will pick him up, on the second time. So the first time, Ahmaud Arbery comes across that dog leg. He's coming at Travis. At this moment, he's looking into Travis's eyes, and he's coming at him, and ultimately is going to get within 10 feet of him running while Travis is saying, stop, do not come any closer, stop right there, stop. No gun in his hand, just saying, stop, do not come any closer. Now at this moment, Travis has already had his experience, obviously, where he reached for the gun before, where he was acting bold. He's not going to forget that. He's not going to forget that he just saw what looked like attacking this truck, acting violent, being bold. And none of what he experienced that day will be forgotten. Trying to talk to him. We want to talk to you. What's going on? We've called the police. And noting that he's not acting right, something is off, and Dad saying going back there, and he said, no way, I'm not going back to that. But now, he's running at Travis. We have proof that he was on that truck because his palm print is right there, and it's consistent with a right thumbprint right there. That's just one piece of proof that his hands were on the door that supports Travis's belief that he was trying to get into that truck. And here he comes. And Travis finally takes a stand and says, do not come any closer to me. Ultimately, Travis, when he gets about 10 feet, reaches into the truck like this, and that's what causes Mr. Arbery to turn. And he runs all the way back. Travis testified, I ran to him for about 10 yards. I don't know, because my main concern is this guy's got a gun. I'm trying to avoid the whole situation from happening. So he watches him. There's 2 options here. There's watching him until the police arrive and giving directions, and there's also stopping him. But he's not going to chase him to stop him. But he is going to try to stop him and detain him, especially when he's coming at him. So he watches. Again, taking up, looking out, trying to be ready. And by the way, where are the police? Where are they? They should be here by now. That's what he says to his dad. Where the heck are the police? Did you call the police? No, I don't have my cell phone on me. It's like, what? Dad. God. Dials the number, listens, gives it to him. Again, it's what they do. They call the police. And now Ahmaud is coming back for the second time. Travis felt, and it was through rehabilitation on redirect examination that we learned during his interview with Nohilly, he was telling Nohilly the same things. There's something not there. This gentleman's not connecting it up. Something's not right. I'm telling him to quit, stop coming at me. I see where it's going. The second time around, I see where this is going. And by the way he was acting prior to, I don't know if he had a weapon on him. An aggravated assault, by the way, is a felony that can be committed by the use of fists. The threat of the use of a dangerous object or weapon. The threat of it. The intent to use your fists to create serious bodily injury. Fists are that weapon. And right now, as Ahmaud Arbery is running toward Travis McMichael, he could have a gun, and he definitely has fists. And he's coming straight at him after being told the first time to stop and turn around and didn't do it until Travis had to reach inside his car. That has now put him on alert. The second time that Mr. Arbery comes down the street, Travis says he gets 30 to 40 feet from him. He's afraid that he will be on him in a matter of seconds. He is afraid that he will beat him with his fists or whatever weapon he might have. And he's scared. And so he's done what he thinks the law allows him to do, which is to try to de-escalate that approach by showing force. Showing force necessary to prevent Travis himself or his father from getting beaten and possibly killed. And so he raises the gun. And he does it to defend himself, to protect himself. They call it the 21-foot rule. So he was a little early. He was at 30 to 40. But he did it because he was afraid. And what happens is it causes a reaction from Ahmaud. He changes from the left side of the road to the right, but then he starts coming back at Travis across the road again, and then gets even closer. He starts on the left. It causes him to change, but then he comes back again. Once the gun is down, he comes back again and changes to the left side of the road, and now we see him going back over toward the right. Now, Travis, this is his truck looking down on it. Travis is here, originally in the door jamb, but he told you, as Mr. Arbery came closer, he did this and made him change direction. Now he's coming, he's wavering on the road, and so Travis is walking away. He's backing up. He's not charging at him. He's backing up to try to create space and distance. He has this gun here, and he is literally watching him. We see his foot plant right there, and Travis is thinking to himself, please turn, please turn, please turn. That's what he told y'all. That's what he told Nohilly. Please turn into this yard. Please don't come at me. I am backing up. I'm just trying to keep an eye to make sure please don't come at me. And as he comes around to the far side of the truck, he can't see him. He's backed up over here, but so he's stepped up over here to try to get a look at what's happening because he's afraid that Mr. Arbery is going to be down or finally go for the gun or seek cover or something. Please turn, please turn. Please go off into this yard. He never, ever, when he left his driveway that day, thought that things would end this way. Not ever. He told us, I'm on the left side of my truck. I'm waiting for him to get by. He told us, if he would have run by me, no problem. I was giving him the opportunity to run by me. Travis doesn't have a duty to retreat. He's allowed to stay where he thinks he is lawfully allowed to be and to try to defend himself and others. And then Ahmaud takes that turn. Not this turn, but this one. And you'll see his feet come, his elbow raises, and Travis is thinking, if this guy gets a hold of my shotgun, this is not going to end well. He's going to end up with the shotgun and kill me. Travis is thinking, my son. Ahmaud comes around, squares up, and you will see Travis's head is right there. His head never comes past that seat post. But you will see Ahmaud come across to Travis, and the first shot happens right over here. You can watch up top as he moves across. You see the white shirt moving across in between those two headrests, and you see Travis's head never comes beyond that front end of his truck. It's all up here with the t-shirt. Right here, his head is down. He's in full charge. First shot has already happened. You can see the same movement under the truck. If you look here, this is the shadow. It's kind of, eventually becomes kind of circular like a stop sign. But you'll see it moving in between these wheels right here. You see it? There it is, moving back, coming forward, coming all the way across. He's charging with his feet. Travis is trying to brace himself. Is there any question that Ahmaud Arbery had his hands on this firearm? Any question at all? Travis, in his interview, told you, I was under shock, I was under stress, I don't know. If he had his hand on the gun, I think he did. I think he did. I think he had my shirt. I think he was punching me. Travis is in a state of disrepair. There is no question that Ahmaud's hands are on this gun. And the medical examiner from that stand told you that if Ahmaud Arbery is grabbing this gun and trying to pull it away, that as the gun gets pulled out of his hands and fired, it could fire right on that wrist and shoot into the chest and go across the body. Pull it straight out. No question. This is about this gun. Travis turns into Ahmaud, trying to use his entire body, pulls the end of the shotgun away from him, gets pushed across the road into the grass, and the second shot goes off. Here's the plume, and it's believed that it didn't hit Mr. Arbery. Travis, coming out of the grass now, trying to yank this gun from Mr. Arbery. Again, trying to yank it away from him. Ahmaud's hand still on it. Ahmaud's fist now raising. Is there any question that Ahmaud Arbery is assaulting Travis McMichael right before that third shot? Not one single bit of question. And that third shot goes off. And these two men end where they started, face to face, looking into each other's eyes. Never a word being spoken by Mr. Arbery. And it is absolutely horrific and tragic that this has happened. And again, this is where the law is intertwined with heartache and tragedy. You are allowed to defend yourself. You are allowed to use force that is likely to cause death or serious bodily injury if you believe it's necessary. At that moment, Travis believed it was necessary. This is a law that is for a person in Travis's situation. And you can do it to prevent death to yourself or a third person, or to prevent the commission of a forcible felony, like aggravated assault. Aggravated assault is a felony which can occur by use of fists. Greg McMichael with a hip replacement, heart attack, stroke, sitting in the back of that truck. Travis was afraid for him. If this was a case about wanting to murder a black jogger, if this was really a case about that, Travis would not have reacted the way he reacted. It was described to you by Brooke Perez. She talked about how totally freaked out he looked, how totally discombobulated he was, and she was right. The officer saying, just breathe, just breathe. Just take a minute, just breathe. Just calm down. I know, just hold on a second. It was from that spot to this spot within just an hour and a half of what had happened, where he would be brought for several hours of questioning. He was afraid. He was in shock. His adrenaline was still going through his body. You guys know how fear and worry works. You sat here through jury selection all day and probably felt that just by getting asked questions for an hour. Travis testified, even though he didn't have to. The judge will give you the law that cloaks Travis in sort of a shield of silence. You don't have to testify. You are presumed innocent. You have the right to remain silent. The state has to prove that you did that. You don't have to get up there and testify. He did, because he wanted you to understand what happened from him. He told you about the thefts and the burglaries, the totality of the facts, why he believed what he did, that he wanted to follow him, that he wanted to talk to him, that he wanted to stop him, for the police to detain him. Don't be fooled by this word arrest. You don't have to announce you're under arrest. He told you why he raised the gun, because he was afraid that he would be on him within seconds. And the gun did exactly what he hoped it would be. It deterred him. And why ultimately he shot. The state wants to criticize Travis for testifying. I thought of this example as the state was talking about bias and prejudice. Travis is a liar. He's a liar because he has everything to gain by testifying here. He's got everything to lose by testifying. We are judgmental people. He's got 2 hours to tell you what happened, at the risk of all of you sitting in judgment of him and saying, I don't believe him. He's got everything to lose. But should he be labeled as so biased because the state indicted him for murder and brought this case to a trial where he has the right to testify if he wants to? Should we label him biased and motivated and a liar because he took the stand? How about I say to any of you, prove your name. Prove to me what your name is. I'm going to make up a name since we're not naming you and we're not identifying you. My name is Patricia. Okay, Patricia, prove your name is Patricia. Well, okay, my mother. I'll bring my mother into court. What are we going to say about your mother? Well, of course she wants to help you prove your name is Patricia because she's your mother. She loves you. She's on your side. See, that's how that works. Well, here's a piece of paper that says, here's a piece of mail that says my name is Patricia. Well, of course you bring that document, but where'd that come from? You could have doctored that up. This kind of stuff, while credibility is for you to determine, this whole assuming that somebody is biased simply because they elect to come and tell you what happened is a game. It's an unfair game. I wanted to show you the law about arrest and what it says, that it doesn't require you actually announcing that you are under arrest. It's doing any seizing or taking or detaining, either by touching or by any act indicating an intention. Stop where you are, stop right now, and at the last moment, he said stop and get on the ground. Even along Holmes or Burford, stop. Stop. I want to talk to you. Stop. He's trying to detain him. Travis could have not gotten in his car. Travis could have told his dad, this is not going to work today, Dad. You can't sit in the baby seat. Let's just go back inside. Travis could have watched Ahmaud run down the road. He could have done everything other than what actually happened. He could have done any of that and wishes that he would have. But that does not mean that his actions on that day weren't rooted in the law that enabled him to go out there based on everything he knew to do what he did that day. Travis could have is another red herring. It's a flawed argument to take you off and to make you feel emotional about this case. That we would be here but for. Well, of course that's true. But then we could go back and say, Travis wouldn't be here but for his grandparents, making his mother and father. But for is loose. That is not what we're talking about here. We're talking about probable cause, totality of circumstances, actual events. But for is some loosey-goosey, illegitimate term. You will not see it in the definition of probable cause. Travis told you, understanding that what he could have done differently that day would mean that Ahmaud Arbery was still alive. He told you, I know that. I know that I killed somebody. And me, and him, and our families, we will never be the same. And he carries that with him every day. The murder charge along with the felony murder charge, the intentional acts is what those are broken down to. Intentionally choosing to commit a crime that either intends to take the life of somebody or ultimately takes the life of somebody. The only time in this case where life was in danger was at the very end of Holmes, when Mr. Arbery chose to cut that turn and go all the way across the front of that truck. Every time they encounter each other on this road, 3 times in front of Roddy Bryan's house, 2 times at the end, 2 times down here. If he wanted to kill him, that's just a nonsensical argument. This was not about taking someone's life that day. Mr. Rubin mentioned to you in his opening statement about duty and responsibility. And I agree with that. Travis felt a duty and responsibility. He has felt it when he served in the Coast Guard. He's felt it to his community, and he felt it on this day, on the 23rd of February, and he felt it during this trial when he took the stand and testified. He felt it was his duty and responsibility to do that. The state, too, has a duty and responsibility. They have a responsibility to be honest with you, to incorporate all of the facts, and take on their burden. The state spent 2/3 of their opening argument saying what we were going to say. It was like 2 kids getting in trouble, and the first one that gets to the parent and says, so-and-so did something, and the parent needs to say, well, hold on a second, let's hear from the other child. They have a duty to you to prove under the law that Travis, at the time he raised that gun, was not in fear. That at the time Travis shot Mr. Arbery, as he came across the front of that car and held the gun and punched him, that he was not in fear of receiving a serious injury or death. And they have a duty to prove to you that when Travis stopped to talk to Ahmaud, that he did so to commit a felony of aggravated assault. That means every time you're walking in your neighborhood and somebody pulls up a truck next to you and says hi or hey, they've committed an aggravated assault or a false imprisonment. Where's the evidence of that? The last duty that is here is yours, and this is a very, very tough one. You all understand, and I will not belabor, the lengths that we have gone to meet you, to understand who you are, to understand your background, to understand the thoughts that you have about certain things, and the way that we communicated with each other for several hours to arrive at the point where we felt in our hearts and our minds that you all would carry the banner of the duty and the responsibility that is yours as jurors. This courtroom is sacred. It is our last place for truth. It is where we pull it from the witnesses if we have to, and we present it to you. And we ask that you hold it dear and that you accept your duty to not erode the law as you sit here and think about what the law allows a citizen to do. It is going to take courage. It's going to take courage to set aside what you think and feel, what may be trying to penetrate you from other sources that you have tried to do your best to avoid, and to focus on the bare facts of this case that have been captured on photograph and on video that have been testified to in this courtroom. It will take courage. In every count in this case, you're going to be asked to make a decision about each person accused. Travis McMichael will have his form, Greg McMichael his, and Roddy Bryan his. And you will be given the option on every one of these charges for not guilty or guilty. The evidence that's been demonstrated to you, I think, is overwhelming, but it doesn't come without hardship on you, consequence for these families. But I think the evidence is clear in this case. Travis had spent 9 years in the Coast Guard. Search and rescue, policing the water, sometimes 200 feet offshore, going into situations that were very difficult, working with law enforcement, reaching out and extending his hand as firefighter, law enforcement officer combination. For the first time in his life, Travis is now in those waters. He is now the one who needs help. Our goal here has been to do everything we can to dive into those waters, to search for the truth, to pull it from the icy depths and to raise it to the surface. And we have done that. We have done that with Travis McMichael. We have carried him to the surface to you. And now the choice is yours. Will you do as he has done in the past to others? Will you reach out your hand and extend it to Travis McMichael and pull him out of those waters? I think if you've heard anything that I've said, there's only one decision. He is not guilty on all charges. I thank you all for your attention.
Thank you. Yeah, we can just go ahead. Yeah. Thank you. All right, ladies and gentlemen, we are at a point we're going to break for lunch. We'll break for an hour. Or just a little bit under. We're going to reconvene at 1:30. Again, until all of the closing arguments have been made and you have received the final charge of the court, you are not to discuss this case amongst yourselves. So, with that instruction and all of the other instructions I've given you, enjoy your lunch. We'll see you back here at 1:30.
So, rise for adjourned.
2 of the closing arguments are in, 2 more to go in this case involving 3 co-defendants. As you know, we're going to step aside for a quick break. Lots more legal analysis and live reporting is ahead for you here on your front row seat to justice. You are watching Court TV Live, your front row seat to justice. I'm your midday host, Julie Grant, and we're so glad to have you along on this Monday afternoon. What a day it is in Brunswick, Georgia, as finally the jury is hearing the closing arguments in the case of the 3 men accused of murdering jogger Ahmaud Arbery. We just heard from Travis McMichael's defense attorney. Now, each of these defendants has separate counsel representing them in this matter, and the closings may differ slightly. We shall see. We have yet to hear from Gregory McMichael's attorney and William Roddy Bryan's attorney. So far, we've just, of course, seen the state going first, and then we saw Jason Sheffield, representing Travis McMichael, deliver his close right before the judge sent the jury off for a 1-hour-long lunch break. So what we want to do is unpack for you what we saw this morning, beginning with the state's closing argument. Of course, it was delivered by lead prosecutor Linda Dunikoski. She is the face and the voice we've seen now most prominently throughout this trial, though she does have co-counsel assisting her. She is from Cobb County, Georgia. Brought in as a special prosecutor on this case. And at one point this morning, she asked the jury, who was the bigger threat? She said the guy jogging with nothing in his hands or his pockets, or the 3 men who were in their pickup trucks armed with guns. She also explained why the McMichaels and Bryan cannot claim self-defense. Take a listen.
What is the defense? We got self-defense. What is that? Well, they're going to try and convince you that Ahmaud Arbery was the attacker, that he was somehow threatening to them. 3-on-1, 2 pickup trucks, 2 guns. Mr. Arbery, nothing in his pockets. Not a cell phone, not a gun, not even an ID. They want you to believe that he is the danger to them. And Mr. Rubin said it in the opening statement. He was scary. So here's the thing. They're going to try to claim that they were justified in their actions. Okay? Because here's the thing, ladies and gentlemen. You cannot claim self-defense under certain circumstances. You can't. You don't get to say, I was acting in self-defense, and there's 3 of them, and it's the law. This isn't just something made up. There's 3 of them in the law, okay? If you are the initial unjustified aggressor, you don't get to claim self-defense. If you're committing a felony against somebody, you don't get to claim self-defense. And the 3rd one is if you provoke somebody so that they defend themselves against you, and then you go, oh, look, he attacked me first. But you really were the one who was provoking the attack on yourself. You don't get to claim self-defense. And that's the law. Citizen's arrest. This was not a citizen's arrest. Not present when any crime was committed. The suggestion that Ahmaud committed a crime is based on what? Not immediate knowledge, speculation. Speculation. How do we know? Because of the defendant's own words to the police. That's how we know. Wanting to question Ahmaud demonstrates uncertainty. Hey, where are you coming from? They don't know where he's coming from. What are you doing? They don't know what he's doing. Remember, Mr. Bryan? Heard, what'd you steal? Okay? They don't know what he's done. They don't know why he's out there running. They don't have immediate knowledge. They have no knowledge. They have speculation because he's running down the street. Wanting to question Ahmaud demonstrates a lack of immediate knowledge, which is required under the citizen's arrest law. Because it's required, that means this was not a lawful citizen's arrest.
All right, let me bring in our guest analyst on the program today to discuss what we saw in the state's close. Joining us from New York City, trial attorney and former prosecutor Imran Ansari is on the program. Imran, always great to see you. Tell me what you thought of the state's close, please.
Hey, Julie, Linda Dunikoski doubling down on what she told the jury in her opening statement, that the McMichaels' actions were based on assumptions and driveway decisions. And you saw how she sort of picked apart the defense that this was self-defense, this was justified. She said the lawful citizen's arrest, that wasn't there. That wasn't there because, again, it was all based on speculation. And under the law, in order to effectuate a lawful citizen's arrest, you have to have the knowledge that crime was actually committed. she also then went on the attack with that, with the fact that these were actions by the McMichaels, by Brian, which were more aggressive. They were the initial aggressors in some respect because they were pursuing Ahmaud Arbery rather than the opposite. They were in pursuit. He was unarmed. So I think Dunikowski really went on the attack here. She doubled down on some of the themes that she put forth in opening statements. And I think it was a pretty effective closing argument.
Agreed, Imran. She has just been so solid, and she recognizes this kind of a case is certainly a marathon, not a sprint. And we've seen her proceed so methodically throughout this process. And really, I can recall hearkening back to that preliminary hearing that lasted so long, the 8-hour-long preliminary hearing back in June after the charging took place. And I just remember thinking, wow, she is just so powerful and knowledgeable. And today I felt like she was very conversational, the way she was instructing them to go through the form and how she was saying, this is how you get to a guilty verdict on every one of these counts. And that is what I wanted to ask you about, please, Imran, with respect to malice murder. Because when we see words used in the law, they have a different definition than we might use in just, common speak. And she explained that to the jury with malice, saying this isn't about ill will, this isn't about hatred, this is about having an unlawful intent to kill without any justification under the law. And tell me, do you think on these facts, the state has been able to prove what is count 1 in this indictment, malice murder against these defendants?
Yeah, Julie, I think so. I think the jury will also reach that conclusion, that decision, when they come to that charge, if they are able to get away from this defense theory that this was justified, and if they take and accept Dunikowski's closing arguments and the prosecution's closing arguments, that this was done with malice, that the sort of act of pursuing Ahmaud Arbery when there were other options available to them. Let's just say they did think that Ahmaud Arbery committed a crime. Well, you know what? They could have called 911. They could have went a different route. But there was this protracted pursuit of Ahmaud Arbery. And one view of that video, which the jury may very well have taken from viewing that video, that this was done with ill intent, with malice, with malintent, the act of pursuing this individual while he is running away, not towards, but away. And they are armed. So I think that the jury, if they have taken the summation and if they have taken the verdict sheet, matched it up and juxtaposed with the arguments made by the prosecution during summation, I think they could very well reach that charge.
I'm with you, Imran. Let's switch gears a little bit and talk more about what we just saw, and that was the close by Jason Sheffield. We have a couple clips we want to play now for anyone who may just be joining our coverage and might have missed it.
Greg McMichael with a hip replacement, heart attack, stroke, sitting in the back of that truck. Travis was afraid for him. If this was a case about wanting to murder a black jogger, if this was really a case about that, Travis would not have reacted the way he reacted. How about I say to any of you, prove your name. Prove to me what your name is. I'm going to make up a name since we're not naming you and we're not identifying you. My name is Patricia. Okay, Patricia, prove your name is Patricia. Well, okay, my mother. I'll bring my mother into court. What are we going to say about your mother? Well, of course she wants to help you prove your name is Patricia because she's your mother. She loves you. She's on your side. See, that's how that works. Well, here's a piece of paper that says, here's a piece of mail that says my name is Patricia. Well, of course you bring that document, but where'd that come from? You could have doctored that up. This kind of stuff, while credibility is for you to determine, this whole assuming that somebody is biased simply because they elect to come and tell you what happened is a game. It's an unfair game. I wanted to show you the law about arrest and what it says, that it doesn't require you actually announcing that you are under arrest. It's doing any seizing or taking or detaining, either by touching or by any act indicating an intention. Stop where you are, stop right now, And at the last moment, he said, stop and get on the ground.
All right, now, Imran, I know you saw the whole close there. Those were just a couple clips, and I do have to say, in looking at just the advocacy, those clips we just played really weren't indicative of the overall advocacy we saw from Jason Sheffield. At times, it was very, very passionate, poignant, really drawing the jury in. I even got a text message during the break from a very prominent attorney who said how impressed they were at the advocacy shown in the courtroom, and that is how you do a close. Those clips not necessarily indicative of what it was overall, but what did you think of the way Jason Sheffield closed to this jury for his client, Travis McMichael?
Yeah, no, I'm going to agree, Jason Sheffield. That was stellar advocacy. He has a job to do. He has to represent Travis McMichael with all the zeal and zealousness that is required under, the responsibility for a client. I think he delivered. He has, in my opinion, this is a different case than what we have seen in Rittenhouse. I think that the defense has a case before them, which is really, when you look at the video in this case, I think, again, this is my opinion, it tells a different story here. And I think the defense is going to have a tougher time here with the justification argument. James Sheffield, he did a good job. He was, again, explaining to the jury his view of the case, the facts that support his client. But I think here we have a very different case than what we've seen in Wisconsin in terms of the justification argument. And I think that he delivered his summation the best you could for your client when you're dealing with a certain set of facts.
I couldn't have said it better myself, Imran. Exactly. You play the hand that you're dealt. When you're a defense counsel, you have a job to do required by the Constitution of our country and the state constitution. And he definitely did a marvelous job on very bad facts and tough facts to get around. So certainly the advocacy was very impressive so far today from both him and from Linda Donikoski representing the state so zealously in this one. We are going to squeeze in a break. Imran, thank you so much. You're going to stay with us. We want you to do the same at home. Coming up, of course, we're going to get you some live updates from the courtroom. Our team is there. They've been watching the jury. So we have some of that to relate to you. Just how might they be reacting to all of this? And of course, we are also going to revisit that big case we were bringing you on Friday when the verdict came from the jury, not guilty on all counts for defendant Kyle Rittenhouse. And he spoke out for the first time this weekend. We'll tell you what he says about his case and what he says it was really about. That's next. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. While the jury may have been unanimous in their not guilty verdict for Kyle Rittenhouse, the country as a whole remains sharply divided. The case against the then 17-year-old who killed 2 men and injured a third amid protests in Kenosha, Wisconsin last summer sparked national debate over gun rights, self-defense laws, and police reformation. Well, now, in his first post-verdict interview, Rittenhouse is speaking out. In an interview with Fox News' Tucker Carlson, he attempts to set the record straight about the role these triggering issues played in his trial.
This case has nothing to do with race. It never had anything to do with race. It had to do with the right to self-defense.
Right.
I'm not a racist person. I support the BLM movement. I support peacefully demonstrating. And I believe there needs to be change. I believe there's a lot of prosecutorial misconduct, not just in my case, but in other cases. And it's just amazing to see how much a prosecutor can take advantage of somebody.
Ooh, prosecutorial misconduct. That was the term he used there. Let me bring in our guest, who formerly served as a prosecutor. Now he's in private practice, working in New York City as a trial attorney. Imran Ansari, still with me there. Imran, tell me, in looking at the case from start to finish, as you did, you were giving us analysis here on Court TV just about weekly during this trial. Tell me, did anything jump out at you that you thought would legally rise to the level of prosecutorial misconduct?
No, Julia, I don't think anything that the prosecution did in the Rittenhouse case would rise to that level. Whether the prosecution did a good job in terms of putting their case before this jury, well, the jury has spoken to that. But I don't think there was anything that rises as far as I know right now. We'll see maybe if there is going to be some sort of look at certain actions of the prosecution. I don't think so. But there's nothing that rises to the level of prosecutorial misconduct as far as I saw it in this case. Of course, the prosecution had some issues, but nothing in terms of misconduct, at least as far as I saw.
Imran Ansari, thank you kindly. We need to take a break as we're nearing the top of the hour here at Court TV Live. When we come back, we'll have more of your top legal news after the break, including the very latest from the trial. We're bringing you live in Brunswick, Georgia, the case of the 3 men accused of murdering jogger Ahmaud Arbery. You are watching Court TV Live, your front row seat to justice. I'm Julie Grant, your midday host, and we're so pleased to have you with us on this Monday. We are seeing the closing arguments delivered in the case of the 3 men accused of murdering jogger Ahmaud Arbery back in February of 2020. These are the 3 men accused: Travis McMichael, his father, Gregory McMichael, and their neighbor, William Roddy Bryan. They all have separate counsels. In this case, so far, we have seen the state deliver its closing argument. We saw counsel for Travis McMichael deliver his closing argument. Then the judge said, let's take a lunch break. We have yet to hear from Gregory McMichael's attorney or William Roddy Bryan's attorney. That will be after the lunch break. And then, of course, the state has an opportunity to deliver rebuttal before the jury is charged, and then we'll go back and deliberate this case. So now what we want to do is bring in our legal correspondent, Julia Janae. She's live outside of the courthouse in Brunswick to give us the latest. And Julia was inside the courtroom today serving as the pool reporter for the media group there. Julia, I know you have lots to share about what you saw inside the courtroom today.
Julie, today inside the courtroom, these jurors were taking everything in, but there were some points in the arguments by both the state and the defense that they were taking notes. And it was important because for the majority of the time during these closing arguments, they were not taking notes. They really were paying attention. Denokoski let them know that they would have the jury instructions. They'd have the law to take back with them into the deliberation room. So they didn't need to furiously write down everything. And it seemed that they took that to heart. But they were writing down when she explained to them citizens' arrest, when she explained that the requirement is in the presence of or immediate knowledge of a crime being committed. And she said that these two things are exactly the same, that if someone either sees it, it happens in their presence, or she gave the example of a security guard who's somewhere else, but he's watching it or looking at it on some sort of a monitor. That is still within their immediate knowledge, but it still has to happen like that. There were several jurors who were taking note of her description. And we heard Franklin Hogue for Gregory McMichael objecting to her definition of citizen's arrest, saying that she was misstating it. The judge told these jurors that the law would come from those instructions from the court. Now, during the defense's closing argument, the first one that we've heard from Jason Sheffield, they were seeming to write down what he said about probable cause, again, having to do with citizen's arrest. And he said it's a lower standard than beyond a reasonable doubt, the standard that they are faced with in this trial. He said you just have to have enough suspicion for it to be probable that a crime is occurring. A couple of jurors writing that down while he was describing it. Also noticed Wanda Cooper-Jones in the back room today leaving when Sheffield was describing how Ahmaud Arbery may have pulled the shotgun and caused the first shot, and then showed still images of when that moment would have been happening. She left and then came back into the courtroom about 20 minutes after that. Julie?
And Julia, tell me, who else is in the gallery that you were able to notice, in particular, who is sitting with Wanda Cooper-Jones today?
She's sitting next to her attorney, Lee Merritt. We've seen him many times throughout this trial, but he has been away. Other people have been sitting right next to her, but today he is in that seat. I didn't notice Marcus Arbery in the courtroom today, at least during the defense closing argument. She was, Wanda Cooper-Jones, sitting next to the mother of Ronald Green, who she said was someone who had been killed in Louisiana, but that mother did not stay there in the gallery with her throughout the defense closing either. We also noticed Special Agent Richard Dial with the GBI, the person who arrested the McMichaels and testified at the very end of the prosecution's case in chief. He is now seated in the courthouse, in the courtroom, back row next to Wanda Cooper-Jones. And on that second row, so the media is right in front of the family of Ahmaud Arbery, and then in front of them is the family and people who are there with the defense. So Lee McMichaels, the wife and mother of two of these defendants, she's sitting there along with a defense investigator, another attorney, and Amy McElrod, who is the girlfriend of William Roddy Bryan. She has been in the courtroom as well, and they have two women there that seem to be supporting them but did not want to give their identification.
Understood. Julia, before things got underway with the closing arguments today, we saw that Kevin Goff, the attorney who represents William Roddy Bryan, raised a motion that may have come as a surprise to some, a motion to sever his client's case from the other defendants' cases on the grounds that he said there was some new evidence that was just brought to light and that developed. And share with us what exactly went down, please.
Kevin Goff has been threatening to move to sever his client's case away from the other two, Gregory McMichael and Travis McMichael, but he hadn't done it until this moment officially, saying that his client deserved a different trial because they now have antagonistic defenses, so that they are going to be arguing something that is contrary to the other. And he blamed the prosecution for bringing in Travis McMichael's Facebook post that suggests that he was into vigilantism, that he was looking for a fight and wanted to be this pseudo police officer in his neighborhood. William Roddy Bryan, according to Goff, had nothing to do with that. And he says that now that creates this different kind of defense. He also talked about the fourth unindicted defendant, and he describes that as Jackie Johnson, the former district attorney. Even though the prosecution says her name has not come up at all in their case in chief, there's a suggestion, Goff says, that's out there that she is someone who helped cover things up for the McMichaels, and he believes that that also prejudices his client because he believes William Roddy Bryan didn't have the benefit of any of that, but he believes it's in these jurors' mind based on things he heard during jury selection. The judge ultimately denying that motion to sever, but it now is on the record going into closing arguments.
Oh, boy. Julie, did anything stick out to you in particular from the state when they had a chance to respond to what Kevin Goff was arguing?
They had a list on hand, Julie, clearly prepared for this motion and explaining all the things that they say actually help William Roddy Bryan with Travis McMichael taking the stand, that he was able to describe things and that William Roddy Bryan had the benefit of the things that was being said by Travis McMichael. In particular, the testimony about his black truck being attacked by Arbery. Travis McMichael testified that he first thought the black truck was perhaps with Arbery or perhaps someone from the house under construction, and then he described seeing Arbery go after the truck, trying to get in it, which goes to what Bryan would have testified based on what Goff has said in pretrial motions and during the opening and closings. So they said this is actually a benefit that he was there and taking the stand. They also said they never mentioned Jackie Johnson at all, so that should not be a reason to sever this case. And they also say all of the evidence that they brought in this case would still be brought in against William Roddy Bryan, the same portions of the statements, all of the evidence. So there would not be a benefit or a difference if he gets a different trial.
Oh, sounds like they were ready to deliver all of those responsive arguments to Attorney Goff's motion there. And as you told us, that was denied. So as we know, we're moving forward with them still all joined together. Julia, we know after the closings are all completed, rebuttals completed, then the judge will instruct the jury or charge them is the legal term, tell them, what the law is that they're applying to the facts of the case. And I understand that outside the presence of the jury, there was a proposed instruction that seemed to catch the defense team off guard. What exactly happened, please?
There was. This had to do with how this jury is going to be instructed on citizen's arrest. And they will get the statute as it is written that goes to what Donikoski explained to them, but will likely be countered in a way by the defense. But ultimately that a private citizen does have the right to detain someone when a crime has been committed, but that it has to be done in their immediate knowledge, within their presence, and that if someone is committing a felony, then they can during an escape, they can, if they have probable cause and reasonable suspicion that a crime has been committed and it's a felony, then they are able to go and detain that person who is escaping. But there's an instruction that the state wanted to get in on contemporaneous arrest. And it has to do with when that arrest can occur. And they say it has to be immediately when it's happening. It can't be after the fact. There was an example given about if you are robbed in your home and the person gets away, and then a week later you see that person at the gas station, whether or not you have the right to then arrest them after the fact, even though you have probable cause. So that contemporaneous arrest instruction reads like this, that a private citizen's warrantless arrest must occur immediately after the perpetration of the offense or, in the case of a felony, during escape, if the observer fails to make the arrest immediately after the commission of the offense or during escape, in the case of a felony, his power to do so is extinguished. Here was the response from the defense when they learned that the state was going to be getting the judge to instruct the jury this way.
Judge, if you charge the jury the way you're contemplating, you are directing a verdict for the state. You are rendering the second sentence in which it describes reasonable and probable grounds of suspicion meaningless. It's in there presumably for a purpose. It's a different burden than immediate knowledge or presence. And so I would urge the court to reconsider and eliminate this, let the state argue what they're going to argue. We have built this whole case around the probable cause, the second sentence, last phrase that Travis McMichael and Greg McMichael had on February 23rd for events that happened previously. And you are gutting all of it if you give this particular charge.
Bob Rubin, they're arguing against that instruction because part of their defense has been that it's all of the things leading up to February 23rd, 2020 that helped with the probable cause and reasonable suspicion, not necessarily just what Travis McMichael observed that day, Julie.
Understood. Julia Janae live for us in Brunswick outside of the courthouse. Thank you for all of that. We're going to bring in our guest analysts now who are on the program today to unpack a lot of what we've seen this morning and in those arguments outside the presence of the jury. Still with me, trial attorney Imran Ansari, and just joining us from Columbia, South Carolina, criminal defense attorney John Mobley is here. John, welcome. I want to begin with you, please, if I may. Asking you about that argument made by William Roddy Bryan's attorney before things got underway to sever his client's case because he is saying that now he's learned that Travis McMichael's defense and some evidence presented, particularly some digital evidence going to the fact that Travis may have been engaging in vigilantism, can harm his client's case. Does that argument hold water in your eyes? Is there something antagonistic about what we saw presented from Travis McMichael?
Well, I think for any time you have multiple defendants, the same trial, different levels of guilt, and when I say that, there's certain defendants that are going to have more serious conduct than the other. In this case, McMichael was a shooter, Bryant wasn't a shooter. There's always the argument the defendant's going to be so full that he's going to be painted with broad brush, and basically, some of the dirt conduct on the worst defendant's going to rub off on him. So yes, that is a legitimate argument to make. Is he going to win at this point? Is he going to get that case severed? No, his case was never going to be severed from the other two defendants. Not going to happen. And I think smart play, knowing that all along, and I'm not sure how much defense his lawyer did, but I think really Brian should have made his whole defense and laid it all on Michael, saying, hey, I was there along for the ride. These are the guys that had the guns and were, fired the shots and were trying to hit him with the truck, and I was just kind of there and things out of control, but kind of lay it all on them. So I think they anticipated that all along. The defense should have been tailored toward that understanding.
All right, John Mobley, thank you very much. You and Imran are going to be staying with us. We just need to squeeze in a break. Before we do that, I want to let you know that we have something special we want to share with you so you can make this programming note. Earlier, we heard the closing argument for Travis McMichael delivered by his attorney, Jason Sheffield. He will be joining our Michael Ayala tonight at 6 p.m. Eastern Time. As the day is concluding there in Brunswick, Georgia. He will be on Court TV. So again, 6 p.m. Eastern Time, Jason Sheffield, one of Travis McMichael's attorneys, will be joining our Michael Ayala here on Court TV. Time for a break. We will be right back after this. Welcome back to Court TV Live, your front row seat to justice. I'm Julie Grant. The case against Kyle Rittenhouse sparked national debate over gun rights, self-defense laws, and police reform, leaving much of the country sharply divided over these triggering issues. So it's no surprise the jury took their time deliberating the fate of the now 18-year-old who faced charges that included intentional homicide. Let's take a look back together now at the trial that captivated so many.
The defendant, Kyle Rittenhouse, who was 17 years old at the time, had armed himself with an AR-15 style semi-automatic rifle loaded with 30 rounds in the magazine. And using that rifle, he shot and killed Joseph Rosenbaum, an unarmed man. The shot that killed Mr. Rosenbaum was a shot to the back. This occurred after the defendant chased down Mr. Rosenbaum and confronted him while wielding that AR-15.
I like to think that he could hear me. It seemed that his eye was looking at me, but it was kind of rolling back, and then when I started talking, it rolled back kind of towards me, and I was looking at him. So I'm not sure if he heard me, but I think perhaps he did.
Did he say anything?
No.
When you said that this individual was doing that, was he doing it towards you?
In my general direction.
Was there anyone else around you that he was doing that to also?
There was an individual to my right and to my left. I don't recall who they were.
Do you know if those were other individuals that were guarding that car source location?
They were, yes.
I broke down and I can't get that image out of my head, so yeah. My sister picked me up about 8 a.m. and we went over to Car Source, and there was the mark where Joe had been laying, and I put my hand in it and my hand was wet with his blood, and that's again when I collapsed on the ground.
As the defendant had been essentially offering medical aid. And then that was the first time that I saw the defendant.
Do you know what happened with regard to that person who was being supported by other people and the defendant?
I only know what I had seen in the moment. I don't know what happened to this person afterwards, but what I observed was the defendant offering medical assistance, and then this individual being carried in a way onto the Car Source property.
You didn't drop your firearm. You were chasing Mr. Rittenhouse with your gun, right? Yes? You were chasing him with your gun? Yes?
No.
You didn't chase him down Sheridan Road, pulling your gun, chasing after him. That's a lie. You're saying that didn't happen?
I'm not saying that it didn't happen, but I wasn't chasing the defendant.
You were running after him?
No.
No. Okay.
I will represent to the jury, and there's no dispute about this. What we're seeing in this video in the middle of the street is the defendant, and on his left is Gage Grosskreutz. We can continue.
It's about to turn up here.
People shot everywhere, bro. We got somebody down right.
When the video reaches them, a male voice is heard yelling,
gun, gun, gun. You won't do exclamation mark. This appears to be Joseph Rosenbaum yelling. Do you remember that?
Yes.
They not only posed a danger to the physical property you were at, but you personally for guarding that property. Is that fair to say?
And everybody started screaming, "Get off the car," and Black Lives Matter was screaming, and he was shouting, and Rosenbaum started shouting back at us that he's gonna, pardon me, Judge, for saying this and everybody else, but he was gonna kill us and cut our hearts out.
He was very agitated. He was yelling police over and over and over. I'm not afraid to go back to jail, and shoot me N-word, shoot me N-word.
Mr. Rosenbaum was walking with a steel chain and he had a blue mask around his face. Sorry for my language. He screamed, "If I catch any of you alone, I'm going to kill you." There were 3 people right there.
Take a deep breath, Kyle.
That's what That's what I run.
We're going to just take it. Time for our break anyway.
You're making a deliberate decision to pull the trigger twice, correct?
Yes.
That wasn't an accident. That was your conscious decision, wasn't it?
Yes.
And you're firing an AR-15 at close range to this individual, correct?
Yes.
And you knew full well that if you hit him with one or both of those bullets, it could kill him, right?
There's that possibility.
That's incorrect. They took a total of 5.468.
I apologize.
2.933 was the time between the third and the fourth shot. Are you asking if you were to put both those two figures together?
Yes.
Yeah, it's about 6.5 seconds.
I didn't want to have to kill anybody. I was being attacked. That's why I shot him. Shot at him.
You shot at him with the intent of hitting him and killing him, correct?
I didn't want to kill anybody.
Then why are you shooting at someone with an AR-15 at close range if you don't want to kill him?
Because he's attacking me.
State of Wisconsin versus Kyle Rittenhouse. As to the first count of the information, Joseph Rosenbaum. We, the jury, find the defendant, Kyle H. Rittenhouse, not guilty. As to the second count of the information, Richard McGinnis, we, the jury, find the defendant, Kyle H. Rittenhouse, not guilty. As to the third count of the information, unknown male, we, the jury, find the defendant, Kyle H. Rittenhouse, not guilty. As to the fourth count of the information, Anthony Huber, we, the jury, find the defendant, Kyle H. Rittenhouse, not guilty. As to the fifth count of the information, Gage Grosskreutz, we, the jury, find the defendant, Kyle H. Rittenhouse, not guilty.
Members of the jury, are these your unanimous verdicts? Is there anyone who does not agree with the verdicts as read? Would you wish the jury polled? No. Okay. Okay, folks, your job is done.
Today, Kyle Rittenhouse, of course, is a free man. I want to ask our guests who are just watching that piece we put together at Court TV with all of the trial highlights, if there was a moment for you that really tipped the scales of justice in favor of acquittal. Imran, to you first, please.
Well, Julie, it was, I will comment generally that a lot of the prosecution's witnesses, including Gage Grosskreutz, the survivor of this shooting, their testimony ended up more favorable for the defense, in my opinion. And I think that was a problem that the prosecution grappled with. Of course, Prosecutor Binger had a lot of things sort of that he had to deal with on the prosecution's case that I think ultimately went in the favor of the defense. But I would say that the testimony of Gage Grosskreutz, the testimony from other witnesses giving this sort of narrative about the melee that Rittenhouse was facing when these shootings occurred, I think that in total, that really helped the defense in getting this acquittal. So I would say that the prosecution's witnesses, not Rittenhouse's testimony, but the prosecution's witnesses that ultimately put the favor of acquittal in that jury's mind. I would say those were the moments that I really took away from this trial.
Sure. John Mobley, same question to you, please. Was there a moment for you that really tipped the scales of justice in favor of acquittal?
No, not at all. I mean, I really believe that it was kind of a cumulative effect of a lot of the fact I'd always believed this to be a not guilty verdict based on so many different things in this trial. I mean, I'd always believed the prosecution had an uphill battle. I mean, I think first and foremost, from a legal standpoint, I've always said the law in Wisconsin self-defense is so broad that it was a major problem for the prosecution. There's no duty to retreat. There's no, exception for having any fault and bringing on the difficulties. It's very, very broad in that state, which is a problem for the prosecution. They got a number of key rulings go against them by the judge. The people that were shot referred to as victims. The judge allowed the defense to refer to everyone as looters and rioters. That really kind of set the stage for the defense to show that it was less of a protest and more of a looting and rioting type situation he was in. And, so all those things made a big, big difference. I think, in any case, the big intangible always is whether or not a jury is more sympathetic and identifies with one side over the other. And I think with the witnesses the prosecution put up as victims, they didn't appear very sympathetic to the jury. Some had weapons. They weren't always completely contrite with their testimony. And I just think those things overall hurt the prosecution in the case.
Certainly, John. John Mobley, Imran Ansari, thank you both. We're going to squeeze in a break as we are nearing the bottom of the hour, and we know that the jury in Brunswick, Georgia, is set to be back at 1:30 p.m. Eastern Time to hear the remainder of the closing arguments in the case of the 3 defendants accused of killing Ahmaud Arbery. We'll be right back. You are watching Court TV Live, your front row seat to justice. I'm Julie Grant. It's great to have you along with us on this Monday afternoon as we're bringing you gavel-to-gavel coverage of the case in Brunswick, Georgia, against the 3 men accused of murdering Ahmaud Arbery. So here's where we are. The jury is set to be brought back any moment to continue hearing closing arguments. We've heard 2 already. The state argument delivered by Linda Danakoski, the lead prosecutor heading up this prosecution. And then we heard from Jason Sheffield, Travis McMichael's attorney. And after he finished, the judge sent the jury out on a break. And just to let you know, Jason Sheffield will be on Court TV Live tonight with Michael Ayala, 6 p.m. Eastern Time. He will be talking with Michael Ayala. And the jury is not back in the courtroom just yet. I'm getting word from our team there. They're not back in the box just yet. So that gives us a little bit of time. This is a live picture you're looking at of His Honor on the bench, and there you see all of the attorneys. And we have our 2 guest attorneys standing by. We have Imran Ansari and John Mobley standing by for some analysis. I want to ask you both just briefly, because we imagine the jury's probably going to be brought back any moment. If it was a mistake, in your view, to not put on any evidence, we know that Gregory McMichael chose not to, William Roddy Bryan chose not to, and we know no evidence is required. There is no burden on any defendant in a criminal case ever. You're innocent until proven guilty. But in one like this one, where we saw one defendant put on a case, and we know he's the son of one of the other defendants, I think it was expected by many. John, I want to ask you, mistake or not a mistake, please?
I think it was not a mistake. I mean, I think ultimately, the facts in this case are not in dispute. And for the most part, the law's not in dispute. And, Julie, I got to call it like I see it. This is a case I do not believe it's going to turn on the facts or the law, because in every case, it's my experience, in every case I've tried, that ultimately what a jury decides is which side they want to vote for and how they're going to, I think you're needing to go.
All right, John, thank you kindly. Let's listen in. The jury's back in the box.
All right, welcome back. Hopefully everybody enjoyed their lunch. I understand we are ready to proceed with closing arguments. Ms. Hogan, on behalf of Gregory McMichael.
Thank you, Your Honor.
On the next break, we have something we need to put on the record that transpired over lunch. My apologies.
Okay.
My father worked for almost 50 years as a life insurance salesman, not because he liked it, because he didn't. He did it because he had 3 kids that he wanted to see grow up in a neighborhood that was safe and secure. A safe home surrounded by a community of neighbors who cared for each other. Band-Aids for skinned knees, July 4th parties, block parties that went on for hours, crocheted baby blankets when a new child was born, casseroles when we'd lost a loved one. He worked hard day and night to provide those things for the people that he loved. Larry English was a contractor in Douglas, Georgia, who worked hard every day to provide for his wife and 2 children, and to save for his dream to live on the water in a neighborhood just like that, safe, secure, filled with people who would care for each other. And when he became ill, he and his wife, Amy, had to fast forward their dreams. They fast forwarded that retirement dream, bought that land, and began working on their dream home, the project of building that home in Satilla Shores. It's the sort of life we all have the right to seek. The safety and security and comfort of people that we care about and who care about us. We work hard for our stuff. It's ours, and no one has the right to take it. And we should never, ever have to fear intruders. The police can be counted on to help, to respond, but they can't be everywhere and they can't be everything. A good neighborhood is always policing itself. Mr. Moore, you really need to put a fence around that swimming pool. I'm worried a child will fall in. Mrs. Pennock, Bobby is flying down Crossbrook Drive again in that new car. You have to talk with him and get him to slow down so no one is hurt. The police can't be everywhere, and in a safe, secure neighborhood, police are helped by those neighbors. Officer Rash testified, neighbors help neighbors, and neighbors help the police. There are really only two questions for you to answer to reach your verdict in the charges that the state has brought against Greg McMichael. Did Greg McMichael have reasonable and probable grounds of suspicion to believe that Ahmaud Arbery had committed a burglary at 220 Satilla Drive? And did he have reasonable and probable grounds to believe that Ahmaud Arbery was escaping or attempting to escape yet again on February 23rd? It is a 9-count indictment. 9 counts. So why only 2 questions? Well, I want to suggest to you what the state suggested, but in reverse. I'd like to suggest a methodical, efficient way to think about all this law and all these charges. I suggest that you begin at the beginning. Count 1, malice murder. And then take all the rest of those counts, 2 through 9, as one big chunk as you consider these important questions. Even count 1, that malice murder count, is defended by the answers to those questions. But with malice murder, I suggest to you, you don't even have to get to those questions. Greg McMichael pulled no trigger. How could the state seek a conviction for malice murder as Greg stood in the bed of the pickup truck on the phone with 911 as the fatal shots were fired? As a party to the crime, Ms. Dunikoski told you about the law that the judge will give you. If someone intentionally helps or aids or procures or hires or assists in the commission of a crime, they can be as guilty as the principal, as the person who fired the shots. But what is so very different about count 1 is that it's malice murder. It requires the desire and the intent to kill, the deliberate intention to take the life of another human being, where all of the circumstances of the killing show that an individual acted with an abandoned and malignant heart. The state will have to be asking you to find that Greg McMichael advised or encouraged Travis McMichael, his son, to take the life of Ahmaud Arbery because that's what he wanted to do. for no reason other than to see that young man die. And to see him die at the hands of his own son. And to do it right there in front of his eyes. Because the guy keeps breaking into that house down the street. That's the level of criminal intent, the level of depravity, heartlessness, sickness that you would need to find beyond a reasonable doubt to find Greg McMichael guilty of malice murder. That's why I suggest that you begin with count 1 and quickly dispatch of it with a not guilty verdict. And then move down to the remaining counts, counts 2 through 9, because it comes down to this. If Greg McMichael was authorized by law to attempt to execute a citizen's arrest, to try to detain Ahmaud Arbery for the police to come and do their job, to try to keep peace and safety within that neighborhood, then they were within the law to hold him there for the police. How else does one hold an individual who does not want to be arrested for the police? You have to contain him, not false imprison him, contain him. You have to possibly hold him at gunpoint without firing a shot, not an aggravated assault, but the use of a reasonable and measured amount of force to make him stay where he did not want to stay. So if they were acting within the law in trying to execute a citizen's arrest, to detain Ahmaud Arbery for the police, then Travis had every single right to defend himself. When Ahmaud Arbery inexplicably took that sharp left turn at the right front of the truck, seeking to disarm Travis McMichael. So, who's got to prove what? We begin, as we always begin in a courtroom, with innocence. And we stay there unless and until the state proves to you that this was not a citizen's arrest and that Travis was not justified in defending himself against Ahmaud Arbery's attack. And they have to convince you of that. Remove your belief in that citizen's arrest or justification to such a degree that you've got left nothing in your minds to doubt it. And that sounds like an enormous burden. Why? Because they have to make you sure of it. You have to have no hesitation, no ambivalence, absolute certainty, because the stakes are as high as they come. It's the highest level of proof we ever ask for in a courtroom. The court will tell you when they say murder and the facts raise justification, and the judge will tell you justification is self-defense, justification is citizen's arrest. That when the facts are raised to support those defenses, that the state has to disprove them, that you were justified. But why? Why is the standard so incredibly high? And the answer is something you witnessed in this very courtroom. Even in science, errors can happen. And without diligent investigation and inquiry, people can be convicted on the slightest errors, stripped of their freedom for another's inattention or mistakes. Imagine if Dr. Donahue, with all that experience, who made the decision, the conclusion, that the muzzle to target range, the end of Travis's shotgun to the chest of Ahmaud Arbery, was 4 feet away, based on a photograph he compared in a book, without having watched the video, and more egregiously, without even having looked at the clothes that covered Ahmaud Arbery's body. Imagine if that initial conclusion had been all you knew in this case. Wouldn't that have misled you? Wouldn't that have led you to wonder how what you saw in that video could match the opinion of a scientist? Imagine if Brian Leopard hadn't tested Ahmaud Arbery's shirt and scientifically concluded, based on that stippling, that these were contact or near contact wounds. Imagine further if I hadn't emailed Dr. Donahue to take another look at his conclusions based upon the clothing and Brian Leopard's expert report, and further imagine if Dr. Donahue was not an honorable scientist, if he wasn't willing to admit he'd made a mistake and take another look at the science. So that instead of 3 to 4 feet, we now know it's contact, or 3 inches. 3 inches, as opposed to 4 feet. That is a demonstration to you why the system has to work this way, why the state has such a high burden, with evidence that leaves absolutely no reason to doubt, before any one of you can consider declaring that a man seeking to protect himself and his community is a murderer. You determine the facts, and the judge will tell you the law. So, of course, you need to be given the facts accurately and completely. The painful beauty of this case is that almost all of it is recorded. Security videos from outside people's homes in Satilla Shores. Difficult to listen to 911 tapes. And then, of course, the really hard thing to look at, the cell phone video that captured the last moments. Based on those undisputed recorded facts, still in the face of all that you heard and saw, the state's case demonstrated in opening what Mr. Hope told you in opening statement. He told you Greg McMichael was absolutely certain, and he was absolutely right. You were so attentive, and I thank you for that. We all do. You took a lot of notes, and there was a lot of things to take notes about. So you know that the very first words out of Greg McMichael's mouth is that there was no doubt in his mind as to who this guy was. He told Officer Brandeberry that, and it was captured on the body cam that you saw. And later, interviewed at the Glynn County Police Department by Parker Marcy, that investigator told you, here's his statement, here's what he told me. I watched him, and when he came by me, I got a good, really good look at him. So I mean, it's the same guy. And it was Ahmaud Arbery on the video. He was an intruder. Larry English had reported because he believed that an intruder had taken thousands of dollars of boat equipment off the offshore boat that had been parked in his RV parking garage. It was Ahmaud Arbery, returning night after night without authority to a place where valuables were stored, with no legitimate reason for being there. And it was Ahmaud Arbery, as Greg McMichael told immediately after being questioned, who had hauled ass from that house on February 23rd, after he'd looked through the window at Matt Albenze on the phone, that he ran from that home. Add all that knowledge, that certainty, to what he learned when Travis jumped into the truck and shared with him what he saw on the driver's side of that truck.
That's not an evidence, and I object to, this is never an evidence, and the state objects to arguing that's not an evidence.
Your Honor, I believe that is an evidence, and I believe that Travis McMichael testified, and these statements that I'm talking about did come into evidence. I believe it's up to the jury to remember the evidence.
All right, ladies and gentlemen, it is up to the jury to recall the evidence that has been presented in this trial. And what lawyers say is not evidence, so it is up to you to recall what the evidence is in the case and to go ahead and address this matter on that basis. I don't have a complete listing of all statements made, but it's up to you, ladies and gentlemen, to recall that. And just because the lawyer says something, again, does not mean it is evidence, and this is argument. Go ahead.
You will be the decider of the facts. You took the notes, and I trust what you will remember from this trial. That Travis jumped into the driver's seat of that truck after having seen Matt Albenze standing in front of 220 Satilla Drive and pointing down that street, signaling down that street. That the man that Travis McMichael had seen only 11 days earlier with his own eyes, and then slowly pulled up alongside so that he could confirm for himself, Dad's right. This is the guy. And the judge will tell you. You will gather the facts from the totality of the circumstances. Did they have a reasonable and probable cause to believe that this was the guy? And you can know, and the judge will tell you, that you gather that from every sense that you have. Your hearing, your sight, your sense of what's going on around you. Certainty, though, is a way higher standard than what you even need to find in this case. Certainty was way more knowledge than they needed to detain Ahmaud Arbery to execute a citizen's arrest. And that was Greg McMichael's intent. He said it from the very beginning. He was asked by the investigator, Parker Marcy testified to you, what was your intent had he stopped? And he said, as clear as a bell, hold him for the police so that he could be arrested. The judge will charge you that a private citizen can effectuate an arrest, detaining someone for the police to arrive if a crime happens within his knowledge, whoops, there's the other one, or his immediate presence. Thanks, Jason. I appreciate it. So here's what you have to know. That you haven't yet heard from the state. There are no magic words. that are required. The court will tell you there's nothing special you have to say to be effectuating a citizen's arrest. There's nothing special you can't say while effectuating a citizen's arrest. If it happens within your knowledge or immediate presence, then you can effectuate a citizen's arrest and criminal trespass, the court will tell you, going on someone's property without the authority and for an unlawful purpose is a crime, the misdemeanor offense of citizen's arrest. And again, what you haven't heard from the state and got some misdirection about, there's no requirement, Judge Walmsley will tell you, for a posting of a no trespassing sign. There's no requirement that any officer execute this trespass warning. It's your place, and people should stay off it. We don't need to be telling people ahead of time and giving them warnings if you don't want to. And he'll also charge you that a private citizen can effectuate an arrest, detaining someone for the goal of holding them for the police, if he has reasonable grounds of suspicion to believe that a suspect is fleeing or attempting to flee from a felony. Burglary is a felony. Entering a dwelling place without authority with the intent to commit a theft in there. Not an actual theft, but the reason, the mindset for going into a place that's not yours. So how do you know that if there wasn't actually a theft? Judge Walmsley will tell you. The law will allow you to infer an intent to steal. If there's an unlawful entry, meaning crossing into a place that's not yours, a place where valuables are stored, and you heard testimony that plenty of valuables were stored at 220 Satilla Drive, with no other apparent motive for being there. That means every single time Ahmaud Arbery goes into that house, he is committing a burglary. But you hardly needed a jury instruction to tell you that. Coming into someone else's house at night, where it's pitch dark, repeatedly, even after you've been run off, into a place where an offshore boat is holding expensive equipment, the intruder comes in, and sometime after that intruder has left, your stuff is gone. Reasonable grounds of suspicion is nothing more than probable cause. And probable cause, as Mr. Sheffield and the court will tell you, are facts necessary to establish a probability, more likely than not. It's less than certainty, but it's more than mere suspicion. So think of it this way. If Officer Rash had been on one of his patrols in Satilla Shores on February 23rd at about 1:08 p.m., and as he turned onto Satilla Drive, he saw Matt Albenze, who he'd already met, standing in front of 220 Satilla Drive, just signaling down that street. And down that street, hightailing it, is Ahmaud Arbery, the man that Officer Rash had seen on those video cameras over and over again. So if he saw and heard what these men did, he too would have had probable cause to arrest Ahmaud Arbery for the crime of burglary. There's no doubt he would have put on his sirens and tried to stop Ahmaud Arbery. And there's no doubt, after the events of February 11th, that Officer Rash would have had his gun at the ready and not taken any chances. And I suspect, in your minds, there would be no doubt that Ahmaud Arbery would have known exactly why he was being chased. Because there can be little doubt as well that Ahmaud Arbery knew exactly why the McMichaels were trying to detain him on February 23rd. The truth of life is that it's very complicated. A beautiful teenager with a broad smile and a crooked baseball cap can go astray. He can deteriorate and lose his way. And years later, he can end up creeping into a home that is not his own and running away instead of facing the consequences, acting erratically when approached, and making terrible, unexpected, illogical choices. But a mother's love doesn't fade from that beautiful boy in the ball cap to the young intruder. And sadly, no verdict can change the grief of that future not realized. The hope that he could have turned himself around. Because all we can guess about the young man is that his teenage years were full of promise, but his early 20s just led him in the wrong direction. The facts presented in this trial bear no resemblance to the story that the state told you in opening statement. A 25-year-old who met a brutal death after being chased and killed by residents of a neighborhood who wanted nothing more than to murder him for having the audacity to jog in their neighborhood. Not a single piece of evidence that's been presented to you in this entire trial supports such a hateful and gruesome set of circumstances. Turning Ahmaud Arbery into a victim after the choices that he made does not reflect the reality of what brought Ahmaud Arbery to Satilla Shores in his khaki shorts with no socks to cover his long, dirty toenails. There were two sets of decision makers on February 23rd. It is not just the McMichaels' decisions that led to this tragedy. And it is a tragedy. I see it in your faces, and I have felt it in mine. A young life lost, grieving parents. Greg and Travis didn't have to do anything on February 23rd. Greg could have looked up from his boat cushions, saw Ahmaud Arbery run past, and shrug his shoulders. Maybe call 911, maybe call Officer Rash, maybe text Diego Perez, and the fear and the frustration of this neighborhood would continue. But Greg McMichael's driveway decision wasn't the only decision that set this tragedy in motion. Ahmaud Arbery was not an innocent victim plundering through Larry English's house on February 23rd, just as he wasn't an innocent victim all the other nights, like October 25th or November 18th or December 15th or February 11th? Is he the person responsible for stealing Larry English's expensive boat equipment? I don't know. We don't know. No one investigated that. But can anyone reasonably believe that Ahmaud Arbery was just doing a looky-loo on those nights in what has been described and shown to you as a home drenched in absolute darkness? The judge will instruct you that you must use common sense and reason. Common sense and reason. There was no legitimate reason for Ahmaud Arbery to be plundering through Larry English's house those 4 nights, and again on the afternoon of February 23rd. Ahmaud didn't live there. He didn't work there. He didn't have friends there. He didn't have a girlfriend there. He wasn't hanging out with a friend in that neighborhood who was a friend of a friend. He didn't jog through that neighborhood. He was a recurring nighttime intruder, and that is frightening and unsettling. A looky-loo in an open, unsecured construction site. Why did we have to withstand that drumbeat? Why? Let's clear a few things up. The judge will charge you that for burglary purposes, a dwelling is any structure that is intended for residential use. It makes no difference if it's occupied, being built, under construction, unoccupied, or vacant. And that only makes sense. How could you ever build a home if it wasn't really yours to protect until it was done? For that matter, how could you ever expect your stuff to be safe when your teenager forgets to close the garage door? Really, with all the important law to consider, why the misdirection? Why? And why the insensitivity to the neighbors of Satilla Shores? It's only a looky-loo when it isn't your neighborhood. It's only an open, unsecured construction site when it's not the building of your dream home, hastened by this impending fatal illness of Larry English's. It's only a property crime when you're not Subi Lawrence, across the street from that house, living alone, trying to raise 3 rambunctious boys, and you can't even let them outside to play. It's only a property crime if you're not Diego and Brooke Perez, trying to raise 3 little girls safely next door to 220 Satilla Drive. No one but Ahmaud Arbery made the decision to repeatedly and unlawfully enter into that house over and over again. No one but Ahmaud Arbery made the decision to run like the wind when the police car responded to the calls from the owner and the neighbors. No one but Ahmaud Arbery made the decision to either reach for or certainly give the very real impression that he was reaching for a handgun on February 11th, and then to yet again run away when the police arrived. And no one but Ahmaud Arbery made the decision not to stop when Travis's truck rolled up beside him. To wait to tell the police what he was doing there, or just plain run away into the woods or in the culverts that you'll see all over the state's evidence, or the open yards or the open garages, or yell the word help, or just keep going right, straight down Satilla Drive, right into Officer Minshew's patrol car. I realize, probably more than any of you, what an incredibly unpopular thing that is to say. But in a courtroom with Greg McMichael facing the charge of murder, somebody's got to say it. And believe me, I'm proud to be the one to say it. Not to cause harm, not to cause pain, but because the truth in this place is really all that matters. Be very clear. Be very clear. No one is saying that Ahmaud Arbery deserved to die for whatever it was he was doing inside 220 Satilla Drive, because that's not why he died. He died because for whatever inexplicable, illogical reason, instead of staying where he was, whatever overwhelming reason he had to avoid being captured that day and arrested by the police, he chose to fight. He chose to fight. To, without any sense of reason, to run at a man wielding a shotgun, leaving him with no other alternative but to be placed in the position of killing another human being. Greg McMichael had probable cause through all that he saw, all that he heard, all that he knew, to believe reasonably that Ahmaud Arbery had committed a crime and that he was fleeing from it yet again. If the state hasn't removed every doubt, every single reasonable, logical doubt in your mind that Greg McMichael was attempting a citizen's arrest, attempting to simply detain Ahmaud Arbery for the police on February 23rd, then you have reached your verdict, ladies and gentlemen, on counts 2 through 9. If they can't strip you of any reason to doubt the evidence that's been presented to you on citizen's arrest, but if they have left you wanting to know more, if they have left you wanting to inquire into the next steps of these offenses, there are still more steps. One of those is causation. How any of the other acts in counts 2 through 9, other than the actual shooting of Ahmaud Arbery, could have been the direct cause of Ahmaud Arbery's death. Or that it would have played a substantial and necessary part in causing the death. You would have to find that the goal of trying to detain Ahmaud Arbery for the police without using any excessive force, no fists, no discharge of the weapon, before that left turn attack on Travis, then the case is over yet again on counts 2 through 9. it would have to be not guilty because there would have been no causation between the counts that don't involve the actual discharge of that firearm. And then if you wanted to go one further step, you would have to ask yourself about Greg's role in all of this while riding in the back of the pickup truck. As a party to the crime, the state would have to prove to you that that Gregory McMichael intentionally helped in the commission of the shooting, or advised, encouraged, hired, counseled, or procured Travis McMichael to shoot Ahmaud Arbery as he was on the phone with 911 shouting the word "no." Without proof beyond a reasonable doubt of all of those pieces, all of those elements, the state simply has not met their case. When I sit down, I get no more chance to speak with you, and that's a tough thing for me. I have to know that the state gets the last word. So given the state's opening and some of their cross-examination of witnesses, despite how careful I know you all were with your notepads and pens, with your attention, with your focus, I have to raise a few more things to make sure you notice them, because the stakes are so incredibly high. Ms. Dunikoski told you in her initial closing argument she was afraid that we'd persuade you of the things that we're sharing with you about the state's case. I'm afraid that she's going to cherry pick. Cherry picking is this: it's choosing and taking only the most beneficial items from all that's been provided to you and trying to turn that into a fact. Don't look over there at all the rest of the stuff. Just look at these beautiful cherries I've picked. Context determines meaning. Stop. And you heard it all the way through the trial. Cross-examination. Versus the actual reality that I think I saw you all write down of what Greg McMichael told Parker Marcy and what the investigators testified about what it really meant and when it really was supposed to have happened. Greg McMichael said that horrible sentence, "or something." "Stop," he said to the investigator. I said to him, "Stop." But most importantly, what we now know is that Greg McMichael fought in the panic and adrenaline and fear and of that horrible situation. He thought that's what he said at the very end of this encounter. Mr. Hogue cross-examined every witness who was with Greg McMichael when he shared that piece of information. The DA wants to make you think, by cherry picking, that Greg McMichael said that anywhere, anytime, over and over, all through, anywhere through the pathway. But what those witnesses, those investigators and officers told you is that Greg McMichael was talking about the final encounter. Officer Brandeberry was asked, "When did you understand he was telling you he said that?" And Officer Brandeberry said, He's talking about the final encounter on Holmes Road. Yes, that's my understanding. Parker Marcy was asked, when would that have occurred? Would that have occurred giving the context of the full statement, which because of the laws in this courtroom and around the state of Georgia, you cannot have all of the statement read to you, so there had to be context. And that gets a little dicey. And that's why you have to be extra careful when you're sharing that information with a jury. So Mr. Hogue cross-examined those officers to say, let's draw down on when that was supposed to have happened. He said it was supposed to have happened at the final confrontation. The same place where Greg's on the phone with 911? Yes. That's what he thought he said. So whatever he said on 911, Mr. Hogue asked the investigator, would that be the most accurate way of knowing what he really said? And that investigator, just like all of you, would say, of course. Whatever you heard, whatever the state presented in the 911 call, whatever you can listen to again, bears no resemblance to what Greg McMichael, after a stroke, and the panic and the fear and the sadness of those moments when he was interviewed, thought that he said on the 911 call. You're the decider of the facts. You're the ones that are going to have to make the decision about what's true and what's not true about this case. Jason Sheffield said the word red herring, so I went ahead and looked it up. I've always heard that phrase, and the definition is something that's intended to be misleading or distracting. So I'm going to tell you I've got one more concern before I sit down. And that is, and I could be completely wrong about this, but I'm concerned about it, so I want to share it with you since I can't come back up in case my suspicions are correct. I'm afraid of why the state kept introducing into evidence still shots of Greg McMichael with various people at the scene. I noted them in the beginning, thinking it wasn't any big deal. I take down a lot of notes, like you all do. And then I kept seeing a pattern. And again, Ms. Dunikoski, I could be completely wrong about this, but I'm concerned that Ms. Dunikoski is now digging so deep to make this case that she's going to suggest to you that Greg McMichael was on that scene manipulating testimony and evidence. It seems kind of wild when you think that the whole event is on video and that the people that came in with that video said it hadn't been altered or changed in any way. And that Officer Minshew is there in seconds on the scene, and we see everything that's happening on his body cam. In fact, it was Travis and Greg who waved him down. But there's photos of Greg comforting his son. There's a photo of Greg McMichael, after 30 years in law enforcement, having a conversation with Captain Tom Jump. There's evidence that the film, Officer Minshew said, Roddy's got this on the film, and Greg was able to say, Travis, it's captured on film. There's a screenshot of Diego talking to Greg, even though Officer Adam Jackson, who testified, said, I spoke to Diego Perez. He said, I got some camera footage, you want it? And we got the security camera footage from Diego Perez through Adam Jackson, unadulterated, and presented to you. So I just have to say, thank goodness that as awful as those recordings are to hear and see, they reflect the truth of what happened, who did what, and why. And there is no way to suggest that there was any manipulation of evidence or testimony at the scene. So now, it's time, very soon, probably not soon enough for you, but very soon, for you to deliberate and reach a verdict. A verdict rendered by members of your community about an event that happened in your community. Glynn County, filled with communities that are filled with neighbors. Why did it take us 11 days to select you? Well, the media descended on this case. And unless, I think several of you said, unless you lived under a rock, you knew something about the case. Some facts that were accurate, some facts that were ridiculous, and some facts that were outright slanted for shock value. And we as humans do, we begin to form opinions when we begin to hear things that we believe could be facts. And then there's the social media. People posting arguments, comments, and opinions. And then with the algorithm of Facebook, you're going to get more and more of the same opinions and comments and opinions that are like the opinions that you seem to be interested in. And next thing you know, you think that these people's opinions are facts. And the other issue is this is a small county. Many of the jurors that were summoned knew the defendants. Many of the jurors that were summoned knew the Arberies. Many of the jurors that were summoned knew people who were close to people who knew either one of them. And consistent with human nature, those folks had formed opinions. So why are you the 15 that remained? Because you were determined to be the people most likely to do what I submit to you is the impossible. To set aside opinions and beliefs you'd formed before you came into court. To set aside facts that you thought were accurate before you came to court, and to promise with your oath, hand to God, to base your verdict only on what you hear in this courtroom. It's kind of a ridiculous standard, but it's all we've got for these men to have their day in court. And we had to assess your honesty. We had to assess your candor, your truthfulness, that you would do what you said you would do. This incredible, awesome responsibility that you've been selected to undertake. Jury deliberations are not like a meeting. They're not like a business meeting where you're going to each put in your opinions and thoughts and reach an agreement, a little give and take. It's not like going to buy a car and you're dickering over the price. It's not even like the legislature when they're trying to come up with a budget. Hey, this is the stuff I really want in my packet, and this is the stuff I really want in my packet. I'll give up a little bit of this if you give up a little bit of that. That is not at all how jury deliberations work. Because you see, compromise has absolutely no place in the deliberative process. The judge will instruct you. Keep an open mind, talk with each other, consider each other's points of view, but the bottom line, ladies and gentlemen, is that each of you will form this verdict on your own. You are the gatekeepers of this jury process. You're the gatekeepers of the oath that you each took. If some of you feel strongly one way, and others of you feel strongly the other way, keep talking, keep working. This is important. But you are not to give up any opinions you have, any thoughts and beliefs you have, just to get along or just to be unanimous. You are not to consider what the possible punishments just might be. You can't have the kind of conversation that says, well, you know, that malice murder, that is kind of ridiculous given the facts of this case. So let's just agree on that felony murder. That can't be that bad. It's got to be less than the malice murder. Or, you know, some of you really want felony murder, and some of you really want not guilty. What if we just sort of meet in the middle with one of those ag assaults? Absolutely not. Absolutely not. I encourage you, I beg you, to slam on the brakes if you hear any conversations like that in the jury room. The only thing you're asking yourself is whether the state removed every logical reason for you to doubt that Greg McMichael had the requisite knowledge and intent to execute a citizen's arrest. And if that's the case, then not guilty is the only verdict you can reach. Because every single count in this indictment is so serious. And every single count in this indictment is life-changing for Greg McMichael. Your deliberations should be guided by the rule that the judge will give you. If in any way your minds are wavering, unsettled, unsatisfied, then that is a doubt of the law and you must acquit.
We're at the bottom of the hour. That means we have to take a break. We'll get you right back into the courtroom live next.
The motion for mistrial.
Kevin Goff is renewing a motion for mistrial right now outside the presence of the jury. He said that today it was noted that a group, he said he's not sure if it was members of the Black Panther Party or others, were carrying a coffin with names of the defendants on it.
Driving around the courthouse with coffins with our clients' names on them with semi or fully automatic weapons. I mean, I'm not sure that this is no longer a figurative mob. This is a literal mob. And inevitably the proceedings, despite best efforts are tainted, we would move for mistrial.
Thank you, remaining defendants.
You can go first.
Yeah, our position again is if the jury has been exposed to it, yes, we would be gravely concerned and we would need them to let the court know that they've seen it and it's had any influence on them. Short of that, if it's folks exercising their First Amendment rights outside and our jury is unaware of it, then we're okay.
And I would agree with Mr. Hogue. That's what I was going to say. And I would, one more thing. To make sure in this most important trial that the jurors are not being exposed to these matters, I would ask the court to affirmatively question them altogether, to remind them, to bring it to your attention or the court deputy's attention if they have encountered it or been contacted in any way.
State asks that you deny the motion for mistrial. We leave it to the discretion of the court.
Yeah, the court's again denying the mistrial. I've indicated previously and mentioned to counsel that I agree with the concern that is out there with regard to the jurors having exposure to anything that may be going on outside. Whatever may be going on outside, it has not been brought to my attention on a security level. Again, individuals have a right to be outside the courthouse. I agree with Mr. Hogue that the court needs to keep a very close eye on whether or not whatever may be going on outside the courthouse has any influence upon the jury, and the court has taken steps to ensure that the jury is insulated from anything going on around the courthouse so that they can focus on their business before the court, which would be to consider the evidence presented as well as the arguments of counsel, and I will continue to endeavor to do so.
Can I inquire, Your Honor? Has the court talked with the jury bailiff at all, and also keeping lines of communication up with the jury bailiff so that she would say, Judge, there's some murmurs or there's some things being spoken? Is she keeping an active ear out for the court?
Without getting into detail, I will tell you that the court I'm trying to stay apprised of whatever may be going on with the jury. As far as what's going on outside, that's up to whoever's outside making sure that everything's okay. But as far as this jury is concerned and what may be going on that may affect the proceedings in this courtroom, yes, I have tried to ensure that I'm at least aware of anything that may be important enough to affect the proceedings. And if something did happen, I would probably be bringing it to everybody's attention because I think it would be important for counsel to know.
Thank you.
One other thing, I wanted to move again that we replace juror number 12. And I will tell you, I tried to make some eye contact with her during my closing. She had nodded off. She was done. She was sleeping. And so at one point I walked closer to her to try to rustle her up. And I even thought there was someone that might have even moved her chair, kind of kicked it, and she then still nodded back off again. So I would ask again, since this is now about the third or fourth time that we've had to deal with it, that we have her replaced with the first alternate.
We would join that.
Juror 12 is sitting right in front of me. I never saw this. She had her eyes open.
Right. So Ms. Duncan's talking about what she saw, so let's
This is
let her
what I
finish.
saw, and I was facing Ms. Hogue while she was talking, but I was very closely watching the jurors, and juror 12 is right in front of me. I did not see her nod up. I didn't see her close her eyes at all. I saw her actively paying attention to this. That is what I saw.
I will again start focusing on juror number 12, where I think is sitting close to the bailiff now, and make sure.
And for the record, Your Honor, is there anyone else at the council table that's able to indicate whether you agree with what I saw? I thought that you and I had made some eye contact. I must have misunderstood that I thought you were looking straight at her.
Yeah, I apologize. I didn't mean to interrupt Ms. Dunikowski. I did see it. There were 2 times where I thought about turning over a box accidentally or kicking the table hard, but I didn't want to interrupt her, Ms. Hoag's closing, but there were 2 times.
I'm hearing a couple different things, so I'm going to keep an eye on juror number 12 again and ensure I did not see a juror sleeping during closing arguments. But that, of course, is something, particularly with what has happened previously, that I now will, again, start keeping a close eye upon.
Thank you.
Your Honor, if she was nodding off during Ms. Hope's presentation, I mean, she may need medical attention. We may have a coma here before I'm done.
Well, let's get going.
Okay. With that, we're in recess. Let's go about 10 minutes.
Oh, I suppose that little joke Kevin Goff just made is an indication to us that he will be taking the full hours, or full 2 hours, excuse me, or close to it when he delivers his closing argument. So the judge has set a time limit for each of these advocates. They've got 2 hours maximum to give their final arguments to the jury. And what we're going to do is step aside, take a quick break. We'll continue our analysis and live coverage next here on Court TV. Welcome back to Court TV Live. I'm Julie Grant. We are waiting for the jury to come back from a brief break to then hear the last of the 4 closing arguments. This one will be delivered by attorney Kevin Goff. He represents William Roddy Bryan. He's one of the 3 men accused of murdering jogger Ahmaud Arbery. And then after he finishes his close, it'll be time for the state to deliver a rebuttal argument. And then after rebuttal, then it'll be time for the judge to charge the jury or instruct the jury on what the law is, and then they will be given the case to deliberate. So soon it will be in the jury's hands. What I want to do is talk about an issue that was raised by the last attorney who delivered the closing argument. We heard from Laura Hogue. She and her husband, Franklin Hogue, are representing Gregory McMichael, the father who's charged in this incident, the father of Travis McMichael. And she said that a juror was sleeping. Juror number 12, this has been an issue that's been raised a few times now throughout the progression of this trial. I want to bring in our guest on the program today, John Mobley, to talk a little bit about this. John, tell me, if you were Laura Hogue and you're doing that argument in front of the jury and someone is sleeping right in front of you, do you do what she did and just keep on arguing and then tell the judge after the fact? Or do you take a pause and say, Your Honor, could we please wake up the sleeping beauty there in the box?
I've actually had that happen to me in the trial before, and I did exactly what she did. Continued with my argument, and later on actually requested the court to make an inquiry to that specific juror. Case law on point in my particular state there is, requires the court to make an inquiry whether or not the juror was asleep, whether or not they missed any testimony. I think it's a bigger deal if they miss testimony versus arguing the attorney's meeting. But I think that's the appropriate remedy to bring the individual juror in, and the court requests the juror and ask them whether or not they're sleeping. The juror might say, no, I'm just closing my eyes, but I heard everything. I didn't miss anything. And I think that normally kind of ends the inquiry.
Right. That's a tricky one. Advocacy is an art. It's not an exact science. I was asked during the break, what would I do? And I likely would have paused. I mean, if she was really snoozing, to me, there's a difference between those jurors who look a little tired, look like they're fighting the tiredness. That happens. There are long days in the courtroom. But if she is really out like a light, then I probably would, take a moment, see if there could be a pause. But that's awkward, right? You don't want to have to do that because your momentum's going. You want to keep closing. And so at the end of the day, the judge is not going to remove her. At least we didn't see any indication of that. The prosecutor, you saw her, John, she really stood up and said she didn't see that at all happening. So the record was made.
And actually, I think you made an excellent point about her momentum because, her closing argument was masterful. She was hitting on all cylinders regarding the points she was making, regarding her delivery. I think it would have been a disadvantage or a bad idea to stop in the middle to deal with that. Her closing argument was amazing. She hit on so many great points. Early on, she talked about the safe community and neighbors looking out for each other. She laid that foundation. She acknowledged that Arbery's death was a tragedy. She really did a great job of pointing out details of this conduct that were problematic, not attacking him. And that's very, very difficult in a case like that. She talked about the opinions they would hear about the case, and she really did a great job, I thought, of increasing the chance of getting a hung jury by stressing the jury they shouldn't really compromise or change their opinions to hold on to their conviction. So I don't think she wanted to slow that down to address something like that.
Tell me something, it was jumping out at me. I'm sure it was jumping out to many of our wonderful viewers at home. In this day and age, jurors expect technology. And I say this all the time on the show. It's true. I teach this when I teach lawyers how to try cases. They want to see technology. We're in the year 2021. I can't even hearken back to the last time I saw someone taking an easel, with a really large pieces of white paper, and every time she was kind of struggling to turn the paper over and someone took the time to write all that out for her. John, did that jump out at you as to why it wasn't a PowerPoint, a little easier?
It jumped out at me big time, and I hate to beat up on lawyers that use exhibits. Hey, at least you use some exhibits, but yeah, it's called PowerPoint, and everybody knows how to use it. If not, your paralegal knows how to use it to hire somebody, but standing there using the old, page where you kind of flip them back and forth and they're, they're folding over and they're dropping and covering things up and you need help. I mean, I just think that's something she could have really practiced more of. There's no doubt about it. I agree with you on that.
Yeah, that was just a little something that was jumping out at me there. John, we are nearing the top of the hour, so we have to say goodbye and thank you very much to you, criminal defense attorney John Mobley, joining us from Columbia, South Carolina. And earlier we know it was Jason Sheffield, who represents Travis McMichael, who delivered the close on behalf of his legal team. And tonight, just a little reminder, he's going to be joining our Michael Ayala live at 6 p.m. Eastern time. And who knows, maybe the jury will be deliberating around then. They're going to be getting this case soon. This is Court TV Live. We will be right back with more after this.
Safe. Sarah's not just a caregiver, she's part of the family. helping us keep our traditions alive.
Visiting Angels, America's choice in senior home care.
Welcome back to Court TV Live. Good Monday afternoon. I'm Ashley Wilcott. So grateful you're joining us today. We begin with breaking news in the trial of the 3 men accused of murdering Ahmaud Arbery. Closing arguments are underway, but the court is on a break at the moment. The jury is out of the courtroom. The morning began with arguments this morning from the state's prosecutor comparing the defendants to bullies who then claimed to be victims.
Think of your schoolyard bullies. Think of the 3 boys walking behind the one who's the target, kid who's getting abused, right? Okay, so you got 3 on 1, they're going down the hallway, they're menacing him, maybe threatening him, and they get him up against a locker, and he has nowhere to go. He's trapped, right? So what does the kid who's being bullied do? He takes it, and he takes it, and takes it until he can't anymore, and he finally shoves the one bully, and what does that bully do? Bam! Punches the target child, right? What's the bully always say? He started it. Isn't that what the bully always says? He pushed me. I was defending myself. Yeah, 3 on 1 with one kid up against a locker. You're bullying him. And he actually pushes you, and you get to then claim you were acting in self-defense when you punch him? Guess what? The law knows people do this. I mean, you get this. This is the law. The law knows people will goad other people into defending themselves so that they can claim, I was acting in self-defense. You can't do that either. 3 on 1, 2 pickup trucks, 2 guns, unarmed. Mr. Arbery was unarmed.
Let's go live to Glenn County, Georgia, where Court TV legal correspondent Julia Janae. I know you've been inside the courthouse. Julia, what's it been like?
Inside the courthouse, this jury is paying attention to everything that's going on in these opening statements, but we did have that juror that you heard that motion for removal from Laura Hogue asking to have her replaced with an alternate because she believes that she's sleeping during these closing arguments. I can tell you that juror is getting very close to nodding off, had some difficulty paying attention, but the judge says he's going to keep an eye on her.
All right, and just to bring everybody up to date, they are back in the courtroom, but the jury is not in the courtroom yet. Nothing is going on. Certainly, as soon as the jury returns, we'll take you back into that courtroom where we expect Attorney Goff to begin his closing arguments for his defendant, William Roddy Bryan. Julia, to that end, talk to me about some of the other activity inside that courtroom. And I understand that Ahmaud Arbery's own mother might have been rushed out of the courtroom or did rush out of the courtroom.
That is accurate, Judge Ashley. She bolted out of the courtroom. I was sitting right in front of her. This is when Laura Hogue started to talk about Ahmaud Arbery in the way that the prosecutors really tried hard to not have him described inside of this courtroom, saying that these jurors should know the reason that he was there. He knew the reason he was being chased, that he had essentially what he was wearing was something that was not someone legitimate that was inside. Even saying his shorts didn't cover his long, dirty toenails. She said she could not listen to that and bolted out of the courtroom.
All right, Julie, and I apologize for interrupting, but they're standing for the jury. We're going to go back to court live, expecting Attorney Goff's closing argument to begin.
Please seated.
All right, ladies and gentlemen, welcome back. I understand we are ready to proceed with closing arguments. Mr. Goff.
Yeah. When did Roddy Bryan know the McMichaels brought guns? When did Roddy Bryan know Travis McMichael would shoot Mr. Arbery? And at that point, what could Roddy Bryan have done to stop it? The inconvenient truth is that Roddy Bryan did not know and could not know that these men were armed until moments before Mr. Arbery's tragic death. He did not know and could not know that Arbery would be shot. And by that time, sadly, there was nothing Roddy Bryan could do to prevent this tragedy. Roddy Bryan didn't shoot anyone.
At the time of the shooting, he was some distance back. He was armed only with his cell phone. Isn't it time, ladies and gentlemen, that we send Roddy Bryan home? Roddy Bryan fully cooperated with the police. He's given several different statements. He's provided the now famous video that you've seen so many times and probably will again before we're done. Roddy provided his cell phone multiple times. He signed all kinds of consent forms. He gives them access to his truck. He gives them the night owl videos from his house, the videos that had been overlooked in the canvassing of the neighborhood because he was down at the police station. He gives them his social media. He gives them his Facebook. Ladies and gentlemen, without Roddy Bryan, there is no case. You will have to decide what justice looks like between the McMichaels and Mr. Arbery, between the McMichaels and the Arbery family. But the reason that you can do so, the reason that we can have this trial, is because of Roddy Bryan. Roddy's decision to cooperate with law enforcement to help them discover the truth about the events of February 23rd, 2020, is not the product of slick lawyering. Roddy Bryan had no lawyer on the side of the road in the minutes after Ahmaud Arbery was shot. It was not some lawyer. It was Roddy Bryan, without any lawyer, without any help, without any assistance, making that decision on his own. Roddy Bryan made the choice. Roddy Bryan decided to invite Officer Minshew to sit with him in his truck, even before Roddy Bryan has a chance to look at the video himself. All this, again, without a lawyer. These actions, ladies and gentlemen, demonstrate good faith. His conduct negatives any inference of criminal intent. Who is Roddy Bryan? Roddy never served his country like Travis McMichael. Roddy never served his community like Greg McMichael. Roddy is a quiet man. Roddy repairs small engines at the local hardware store. Roddy knows most of the English language, or so he believes. Roddy Bryan keeps to himself. His neighbors don't really even know who he is, even though he's lived in the neighborhood for 3 years. Roddy is not boastful or a braggart. He is not loud or boisterous. He is not an attention seeker. Roddy tries to avoid bad language, not always successfully. Roddy is respectful. He's an ordinary guy, a regular guy. Roddy Bryan is no vigilante. There's no evidence of that. Roddy isn't running around Satilla Shores with guns, openly carried in broad daylight. He didn't even bother to report the theft of his own trailer. After all, it's just stuff. That's what insurance is for. The Amish have a saying, what you take into your hand, you take into your heart. Roddy Bryan grabbed his cell phone. That's not intended as a comment upon anyone else, but that's just who Roddy is. What else does the evidence tell us about Roddy Bryan? Is Roddy Bryan the smartest guy in the room? Is he like some kind of rocket scientist? In these interviews that Mr. Bryan gives to the police, is there some clever wordplay like Mr. Bryan is smarter than everybody else? Is that what the evidence suggests in this case? The evidence suggests that Roddy Bryan legitimately struggles to find the right words, that Roddy struggles at times to convey the meaning, the truth behind those words. There is no evidence that he is a wordsmith, no evidence that Roddy was playing word games with law enforcement officers. He simply can't find the right words. The evidence in this case shows that context is key. If you honestly seek the truth here, which is your duty as jurors, if you listen carefully, you will see that what Roddy Bryan means, as opposed to simply hearing his actual words, it is clear that he never wished to hit Ahmaud Arbery. Why the prosecution felt it necessary to phrase the things the way they did in their opening statement, Ms. Dunikoski will have to answer to you for. I was unable to play it earlier, but we are now going to try and play the excerpt from the interview with Mr. Lowry, specifically that most damaging part of his statement, where he supposedly wishes that he had hit Ahmaud Arbery.
You said that you had handprints on your truck from where the guy was trying to get into it.
Yeah, I feel pretty sure that's what he was doing. I mean, I can't say for sure that he was up there. He wasn't on the door. I didn't give him a chance to get to the door. But after I angled him off the side of the road, you know, and I kind of went on past him because I didn't hit him, which I would have, you know, might have took him out and shot. But, you know, I probably got past him a little bit, and he come up on me, and I could see him in my mirror, and he was coming over the door. And I seen his hands on right behind the door.
Ladies and gentlemen, in the video, as opposed to the officer's testimony, you can see Mr. Bryan's demeanor, you can see his gestures and his mannerisms, and you can see that when he says that he wished he hit Mr. Arbery, he said that just after he says that he didn't hit him, and he's expressing regret because Mr. Arbery has died. And maybe if he hadn't gotten down where he was, he wouldn't have been shot. That is much, much different in context than to suggest that Roddy Bryan wished that he had hit Mr. Arbery. That's a reflection of regret that Mr. Arbery was hurt by the McMichaels. That's certainly not a suggestion that he bore any ill will. And how many other instances of that do we have in this case? How many other times has the district attorney's office fired cheap shots at Roddy Bryan? How many times have the GBI taken cheap shots at Mr. Bryan? And in the end, you may wish to ask yourself why. Now, in the defense case, and we didn't do it, we promised we wouldn't, but it's clear that Mr. Bryan did not wish to strike Mr. Arbery, that he never had any intention of hurting Mr. Arbery. He never said anything to the contrary. The evidence will show that he had no knowledge, no reason to believe that anyone else out there meant to hurt or shoot Mr. Arbery. If they had a secret intention or desire to do that, it could not be known to him. Now, there is another excerpt that I want to play from the Minshew video. Only one, okay? Because again, I think it shows you Mr. Bryan's demeanor. It has been suggested by the state that much of what Mr. Bryan says later is somehow an after-the-fact rationalization of what happened that day. But when you listen to this, I think you'll see that the truth of what Mr. Bryan is trying to convey hasn't really changed. Now, obviously, there's a reason we all don't play more of these. Go ahead, young lady.
What did it look like he was trying to do? He was trying to get on this side of the car, right? What did it look like he was trying to do? What?
Yeah, I mean, I cut him off pretty good now, you know. But
he actually pulled on your handle?
not be surprised if that's his warrants right there.
Okay.
He was trying to get to the handle.
Okay.
Yeah.
All right. All right. Did nobody got us on video? You just witnessed it, correct?
I got it.
You got it on video?
I ain't looked at it. Okay. You ready?
Yes, sir.
Yeah. All right. You want
At what point did you start videoing?
Well, I thought he was gonna get away.
Okay.
So that was the
You
reason.
was trying to get capture who he looked like.
Yeah, I mean, to be honest with you, I probably got 2 videos, 3 videos. I mean, I probably started over here. I don't know what I got because half the time I was trying to drive.
It was suggested that Roddy Bryan made up the idea that he was trying to preserve Mr. Arbery's identity, that he was trying to preserve it because he thought he was going to get away. It's been suggested that that's not what was going on. But yet, here, on the side of the road with Officer Minshew, Roddy Bryan says within minutes of the shooting that that's exactly what he was trying to do. We have one video in this case. Well, we have 2, a shorter version of the one you've seen. But when Mr. Bryan is talking with Officer Minshew, he hasn't had a chance to look at his phone. He hasn't had a chance to see what he has. He thinks he has 2 or 3 videos. He thinks he's caught much more than he had. Now, either you believe that Roddy Bryan is the smartest person in this room, that he's playing games and manipulating the police from the moment this has happened, or you know that Roddy Bryan had good faith from the start, that he tried as best he could to help the police. Maybe it would have been better if he had been able to record more, if he knew better how to operate his phone. But the idea that somehow Mr. Bryan is, quote unquote, minimizing his involvement in this case, had he recovered as much video as he thought he had, he might have had the whole thing on video. And he's giving it to the police. He's inviting Officer Minshew to sit with him in the car, to look at it with him for the first time. Not with some slick Cobb County lawyer, by himself. That tells you that Roddy Bryan is not guilty. Because unless you think he's smarter than everybody else in this room, that he's smarter than all these police officers, that he's smarter than the cream of the crop, the creme de la creme of the GBI, then you know he's trying to tell you the truth. He just can't always find the words. And to hear again all this stuff about Mr. Bryan, about all these things that happened, we'll come back to that later. But when you look at the Lowry interview, when you look at Mr. Minshew, the Minshew discussion on the side of the road, you know what the truth is here. Now, if I'm out of order, I'm sorry. But again, as I've said before, the events of this day from Mr. Bryan's perspective are chaos. Mr. Bryan doesn't know what happened up the street at the English residence. He doesn't know Mr. Albenzi is out there. He doesn't know Mr. Albenzi's called 911. He assumes somebody's called 911, and he was correct, but he doesn't know. He doesn't know that Mr. Albenzi is armed and just up the street. Mr. Bryan is not in communication with anyone prior to the shooting, not Mr. Albenzi, not Diego Perez, not Gregory or Travis McMichael. At times, as you've heard, Mr. Bryan feels like he's alone out there with Mr. Arbery, and it scares him. Roddy Bryan doesn't see any guns until moments before the shooting. We'll come back to that. I think, if I recall correctly, the testimony was, although you can see, and you will see in a moment, Greg McMichael standing in the back of the pickup truck in the moments before the shooting, Mr. Bryan, on that day, doesn't even recall Gregory McMichael being in the back of the truck. He doesn't realize Gregory McMichael's in the back of the truck until later, until afterwards. Roddy Bryan thinks that it takes the police several minutes to arrive on the scene when we know it was mere seconds. Roddy gets so many basic facts wrong, so many key facts, is it any surprise that months later he would struggle to recall details of what happened that day when he couldn't recall big, obvious details right at the time it happened? Let me shift gears for a moment. Closing statement is sometimes referred to as closing argument. Let me assure you, I don't want to argue about you with the evidence. First of all, there's 12 of you. There's only one of me, and you get the last word. Second, lawyers, we tend to remember things, frankly, sometimes the way we wanted them to be or the way we expected them to be, whereas you hear it as it actually comes out. So if my recollection differs from yours, I would trust your collective memory. And I'm not supposed to say this, okay? We're all taught never to say this. But what we say as lawyers is not evidence. The evidence is what you heard. And if something I say doesn't ring true to you as what the evidence is, you don't have to wait for someone else to object. I don't want you to consider something if you don't remember it as the evidence. Now, before proceeding any further and before I forget, I do want to express my gratitude to Mr. Bryan, to the court, to my distinguished opposing counsel. As I walk through the front doors of our courthouse every day, I am reminded what an honor and an absolute privilege it has been to come before you. What I'd like to do now is go back in time. I want to take you back, if you can join me, to the morning of February 23rd, 2020. It seems, at least to me, both so very far away and yet like it was yesterday. It was a time to which many of us might wish to return, if only we could turn back time. Ahmaud Arbery is still very much alive, perhaps still asleep. Some of us, like Brooke Perez and her husband Diego, have gone off to church. Others read the Sunday paper. The politically minded may recall Bernie Sanders is the front runner for the Democrat nomination. The sports-minded may recall that the Daytona 500 had been held a week earlier down the road. Donald Trump was the Grand Marshal. And our local newspaper, the Brunswick News, covers school events celebrating Black History Month. You may recall COVID-19 is still a mystery. It's a China problem, an Italian problem. Some guy we've never heard of, Dr. Anthony Fauci, warns us that we should conserve the already dwindling supply of masks for first responders and for healthcare workers who most need them. But Roddy Bryan isn't reading the Sunday paper. Roddy Bryan is not in church. And he probably isn't paying much attention to the corona. Roddy Bryan is working on the front porch of his home. After renting for several years, Roddy and his fiancée have just purchased their home on Burford. As a small engine repair guy working at the local hardware store, this is a big deal for Roddy, and he isn't going to waste any time before fixing it up. When you think back, it was a different world, but it's the world in which these events take place, and it's in that context that we have to look at the evidence in this case. Now, I think we have the first Night Owl video. I call it the first Night Owl video, the porch video. I think we played it for you once before. Here you can see Roddy Bryan standing on his front porch trying to repair a column. He is listening to music. The music is playing in the garage. The door is open. We've seen that from the previous picture. We'll see in a moment his truck is out front. If you look carefully, I believe you can see his hammer on the ground behind him. And I believe other tools as well. Now, we'll stop that. Now we have a still photo, which we're about to turn back on. The still photo? Sorry. Beggars can't be choosers. I'm going to wait on Miss Barton. This is the front of the Bryan residence. You have to add in Mr. Bryan on the porch. You have to add in pickup truck in the driveway with lumber in the back. You have to imagine, if you will, the music playing, and it's probably playing loud because his hearing's not so good. Is there anything threatening or menacing about this picture? Is there anything threatening or menacing about this image? Or is this something we'd expect to see in a Norman Rockwell painting? We talk about driveway decisions. Mr. Arbery has driveway decisions that he's making this morning. I'm not going back into all that stuff with the Englishes and Diego Perez and Matt Albenzi and Robert Rash. That's already been covered. And although Mr. Bryan may well have read about it on the Exit 29 page, he doesn't recall it, at least on this day. But Mr. Arbery is now running down the street, running from the English residence. He's passing house after house after house on a nice Sunday afternoon. Is there any evidence that Mr. Arbery sought help, sought assistance from anyone in that neighborhood up to this point? Maybe you heard it, I didn't. But as he comes up to Mr. Bryan's residence, he starts coming by his house, why isn't Mr. Arbery asking for help? Why isn't he calling out, hey, somebody call 911. There's crazy people after me. Maybe that's because Mr. Arbery doesn't want help. Now, Mr. Bryan spots Mr. Arbery out of the corner of his eye.
All right, we do have to take a break here on Court TV, but we will bring you anything you've missed when we come back on the other side. Welcome back. So the attorney for William Roddy Bryan is in closing arguments, and we're going to take you right back now live.
Sorry, you went too quickly. There he is. Okay, watch carefully. Mr. Bryan has said on some occasions he walked to the kitchen. On another occasion, he said he ran to the kitchen. He said he walked back out to the truck. Another time, he said he ran back out to the truck. Well, what we know from this video, it takes 13 seconds to get from the edge of the driveway into the kitchen to reach the keys and go back out to the truck. Mr. Bryan is, in fact, walking calmly to the kitchen and walking calmly to the truck. And his recollection of doing otherwise is faulty. Now, we also know, as Mr. Bryan pulls out, and by the way, we also know that he left his rifle in the house, left a hammer on the porch, and went out with his cell phone. Now, here we see when Mr. Bryan initially pulls out, Mr. Bryan is pointed to the right. Now, he backs up. Now, it's, at the very end, he backs up and he straightens out a bit. Whether Mr. Bryan said he was going to the left or the center or slightly to the left, the actual evidence in the case is consistent with him pulling straight out. And again, we know from all the other things that we've seen that Mr. Bryan's recollection of events that day simply isn't that good. Now, Mr. Bryan makes what is for him a very faithful decision. He actually pulls out in the road. Now, at one point he says he overshot the road. Another point in the same interview with Detective Lowry, he says that he crept out onto the road. The state suggests that Mr. Bryan either hit Mr. Arbery or tried to hit him and pushed him with his 5,000-pound motor vehicle. We'll come back to that in a second, but I just don't think I think the evidence is inconsistent with that. Now, I do want to talk about the indictment for a minute. Thank you. Let's take a minute to review the indictment. It is what we sometimes call a kitchen sink indictment. Everyone, all three defendants are charged literally with everything in the indictment, every crime set forth therein. You may find this confusing and difficult to sort through at times, since the factual bases and underlying legal bases for the 5 murder counts are so closely intertwined with one another. However, this is perfectly acceptable. There's nothing improper about it. Murder is murder. Each of the remaining 4 counts of the indictment, aggravated assault with a shotgun, aggravated assault with a motor vehicle or motor vehicles, false imprisonment, and attempted false imprisonment, actually serve as predicate felonies for the felony murder counts. In other words, this indictment does not allege any offense against any defendant other than murder and the predicate offenses for murder. There are a couple legal principles I feel obligated to go over in every case. One of those is reasonable doubt. Now, you've already heard several very capable lawyers go through that, so I'm not going to spend a whole lot of time there. Without belaboring the point, however, I would refer you to what I consider the core principles at the heart of the court's charge on reasonable doubt. A reasonable doubt means just what it says. It is the doubt of a fair-minded, impartial juror honestly seeking the truth. If you are a fair-minded, impartial juror honestly seeking the truth, and you've certainly given us every reason to believe that you are, if at the end of the evidence you have a doubt, that is a doubt upon which you may acquit the defendant. A reasonable doubt is a doubt based on common sense. It is a doubt for which a reason can be given. If you can give a reason to doubt whether Mr. Bryan is guilty, then your mission is complete. And at that point, you should acquit Mr. Bryan. Now, I also often use this provision lifted from Robert Bolt, A Man for All Seasons, when I talk about reasonable doubt, because I find it helpful. And let's be clear, it is not a statement of the law, it is the principle behind it. Some of you may be familiar with the play and the movie, some of you may not. William Roper asked Sir Thomas More, "So now you give the devil the benefit of law." Sir Thomas More says, "Yes, what would you do? Cut a great road through the law to get after the devil." William Roper says, "Yes, I'd cut down every law in England to do that." Sir Thomas More replies, "Oh, and when the last law was down and the devil turned round on you, where would you hide, Roper? The laws all being flat. This country is planted thick with laws from coast to coast, man's laws, not God's. And if you cut them down, and you're just a man to do it, do you really think you could stand upright in the winds that would blow then? Yes, I'd give the devil benefit of law," Sir Thomas More says, "for my own safety's sake." And when you apply the reasonable doubt standard, remember that standard, that legal principle, isn't there for Roddy Bryan. It's not there for these other defendants. It's there for all of us. And it's a principle that we cannot forsake. The court's going to charge you, I believe, without trying to put words in his mouth, on parties to a crime. The provision that's relevant to Mr. Bryan in this case is the second one. To be a party to the crime, Mr. Bryan must intentionally help in the commission of an offense, of a crime. Mr. Bryan cannot be a party to a crime by accident. He can only be a party to the crime intentionally. And we'll come back to that principle again. Now, count one is murder. And I don't want to tread over the same ground that other counsel have tread, but the issues are somewhat different for Mr. Bryan. I hesitate even to respond to count one, because by doing so, I don't want any of you to think for a moment that there's anything here even worthy of a reply. But I am required to do so. Roddy Bryan didn't shoot Mr. Arbery. He was armed only with a cell phone, and he was a good distance away when the shots rang out. Roddy did not cause and could not cause Mr. Arbery's death within the meaning of this statute. Roddy was not the shooter, so he could not shoot Mr. Arbery unlawfully. Roddy did not shoot him at all. Roddy Bryan acted in good faith on the day in question. There is no evidence whatsoever of malice. And most importantly, and I think this echoes arguments made by others, nor can Roddy be a party to the crime of malice murder, because there is no evidence that Roddy Bryan intentionally helped Travis McMichael murder Mr. Arbery. Where is that evidence? And that takes us back to the three questions I asked a moment ago when I first stood up. Roddy Bryan certainly was not aware of any intention on the part of Travis McMichael to shoot Mr. Arbery. And I'm not saying he had that intention. You will have to decide what Travis McMichael did or did not do. But Roddy Bryan certainly was not aware of any such intention, and certainly could not be a party to the crime of malice murder, because he can't intentionally help commit a crime he doesn't know is underway, doesn't know is contemplated. At this point, we're going to try and go back and play the video again, the famous video. But I'm going to repeat the three questions that I started with. When did Roddy Bryan know that McMichaels brought guns with them? When did Roddy Bryan know Travis McMichael would shoot Mr. Arbery? And at what point, what could Roddy Bryan do to stop it? We ready? All right. Now, I'm going to try and keep up with this video. At 0.03 seconds into this video, Mr. Arbery turns around on Holmes. Now, stop. What I want you to do is not so much look at the video at this point. Listen with your ears to the noises in the background, because they tell you what's really going on, even when what you see on the screen is unclear. At .04, you'll hear Roddy Bryan tap the brakes. He's still in drive, and you'll see he's going at approximately 2 miles per hour. I couldn't see. Can we stop it on the speedometer? Yeah, let's try that again. It's very, very difficult to get this video precise. Yes, we're looking for 4 seconds. We're looking for the speed on the speedometer. Okay. Well, what you can see is that Mr. Bryan is, you hear him tap the brakes. You hear Mr. Bryan tap his brakes, but he's still in drive and he's going about 2 miles per hour, which is about the same speed that Mr. Arbery is moving. He's been described as chasing Mr. Arbery, as hunting Mr. Arbery, as attempting to run Mr. Arbery down. But what you see on the video, and there is you can see that Mr. Bryan is moving at approximately 2 miles an hour, and you can see that the seatbelt is not in place. Now, at this point, we're going to go ahead and play it to about the 17-second mark. Listen for the gear shifts. I'm sorry, it's not there yet. Go ahead. You can see Mr. Bryan's foot is not on the gas pedal. Now, you hear a motor vehicle go by. We can guess which vehicle that is, but we hear it pass. And then at 20 seconds, we're going to hear the seatbelt alarm go off. At 26 seconds, you can hear the transmission shift as Mr. Bryan puts his truck in park. And then 2 seconds later, you'll hear Mr. Bryan buckle his seatbelt. Now, at about 30 seconds, and I'm going to go through this with you before we play it so you'll know what to listen for, Mr. Bryan utters the famous words, "I'm going to keep going." And you'll notice that his cell phone is down. This is where he says, "I'm going to keep going." And the state is suggesting to you, if I recall the opening statement and the opening portion today, that this is where Mr. Bryan is turning around to give chase to Mr. Arbery in the moments before his death. But if you listen carefully, I think you'll hear a somewhat different story and a different truth.
You know what? I'm gonna keep going.
Mr. Bryan says, "I'm going to keep going." He's put the car in gear. But if you watch, you'll see Mr. Bryan isn't going back towards Mr. Arbery. He's not going back towards the McMichaels. He's going in the opposite direction. And he starts at a high rate of speed. Here, the wheels lose traction slightly. Now, you can't see yet, but he's not moving towards Mr. Arbery. He's moving away, and you'll see why in a moment. Now, here you can see the speedometer is, at this point, he's slowed back down. He's at 4 miles an hour at the 51-second mark. And shortly after this, you hear him put shift the transmission again. And I think you'll see it's clear from the context, which is a K-turn, that he is putting the truck into reverse. And then a few seconds later, he puts it back into drive. This is the K-turn near the top of homes that you see on the reenactment video. Top of homes near Zellwood. Go ahead. Okay. When I start the video up, when we start the video up, it's a team project here. When we start the video up, listen for Mr. Bryan's breathing. I think when you hear his breathing, you will hear something different than the state has suggested. Now, I can't tell you how to interpret it, but what I hear is someone who is labored breathing, breathing as if he was in fear. Also, around the same time, watch Mr. Bryan's leg, which is momentarily visible on the gas pedal, and see whether you don't agree that Mr. Bryan's leg is literally shaking. Now, you know, he's not driving a Cadillac. I'm sure there's vibration in the vehicle, but if you watch his leg in relation to the rest of the car, to the rest of the truck, I think you'll agree that Mr. Bryan at this point is shaking. All right, let's try that again. Very good. Did we play the right portion there? Or did we miss it? Okay. All right. At this point, Roddy Bryan is looking down, back down Holmes. Now, what does he do here? He's pulled up his cell phone. His cell phone's been down because he was driving away. When Mr. Bryan said that he was going home, when he said the guy didn't want to be caught, that's all consistent with this video. Now we can see that he's turned around. The question is, ladies and gentlemen, why is he turning around? Technically, this is the shorter path back to his house. It may be easier to get in the driveway. You can see the bushes in the video out front. Maybe. Maybe he's trying to document what's going on. He said that's what he was trying to do. Maybe, and that's just me going out on a limb, I'm going to suggest to you that perhaps, and I know I'll get grief for this, I would submit to you that you can call it karma, you can call it fate, I would call it divine providence. Somebody is guiding Mr. Bryan, whether it's a conscious thought process or not. Something is guiding Mr. Bryan down this street to document what's going on. Just like Mr. Bryan's on his porch. Why does he go out? He doesn't know. He gets in his car, he sits out there, he doesn't even know why. He's being guided, whether that's by a God, if you believe in a God, or by some other entity. But do you really believe it's just coincidence or chance? Do you really believe Mr. Bryan is trying to lie or deceive you at this point? But we're going to go ahead and we're going to continue playing the video. Watch when the truck comes into view. Right. Okay. Mr. Bryan is traveling, as he testified, as an agent indicated in the reenactment video, he's traveling at 10 or 15 miles an hour. He's traveling faster than Mr. Arbery. But clearly, if he was trying to hunt him down, he would be going a lot faster. More to the point, at this point, as Mr. Bryan comes around the dogleg, what we're seeing here, I can't be sure whether this is the enhanced video or not, but what we're seeing here in this courtroom with the artificial interior lighting is certainly a better view than Mr. Bryan has actually looking through that phone with the glare and other stuff that's going to be in the car on a sunny day. Anyone who's tried to look at pictures on their phone while they're driving on a day like this understands that sometimes you can't see the phone at all. But assuming that Mr. Bryan has 20/20 vision, and assuming that he has every bit as good a view of his phone as he's driving as you see here, where is Travis McMichael? I can't see Travis McMichael in this picture. Really, honestly, I can't see Greg McMichael in this picture. And I certainly can't see any guns. Now, what's our post on this one? Where is this one? This is at 1:15 into a 1:43 video. And Mr. Bryan at this point has no reason to know that the individuals in that truck have guns. All right, let's, okay. All right, you can still, at this point, I think you can see that there's a shadow, a silhouette of what's Travis McMichael. But from where Mr. Bryan is in his vehicle, again, even if he has a perfect view of his phone, you can't see a weapon. You can't see anybody's armed. All right, we're going to go forward again. At 1:15, now watch, you see that Mr. Bryan's phone is focused to the right of the truck. Why? Because Roddy Bryan doesn't know Matt Albenzi is down on Jones at 220 Satilla with his phone and his gun. The McMichaels know because Mr. Albenzi's given them the hand signal. Mr. Arbery knows because he's running out of the house away from Mr. Albenzi. But Roddy Bryan doesn't know that. Roddy Bryan is thinking that Mr. Arbery, like he has for the last minute or so that he's been out there, that Mr. Arbery is just going to go around the truck like he's gone around the trucks the whole time and head out Satilla towards the exit to the neighborhood. All right, go ahead again. At 1:16, Travis's silhouette should come in view. Now, that's Greg McMichael. Or we passed that. Okay. Now there's Greg McMichael in the back of the truck. Now we know that he has a gun. I think at this point he's on the cell phone. But from Mr. Roddy Bryan's vantage point, looking through this phone as he's trying to drive on a sunny day in his truck, how can Mr. Bryan know that Greg McMichael has a gun or that he's drawn it? He can't. Go ahead. Go to 121. Play it to 121. All right, this is 121. You can see Mr. Arbery. You can see how far back Mr. Bryan is. And you could see Mr. Arbery going to the left momentarily. And way over here, and I promise not to touch the screen. This little fuzzy black thing here, this silhouette is Travis McMichael. Where on this video, putting aside the fact that Mr. Bryan's not going to have as good a view driving on a sunny day in his car, from this video alone, where is Mr. Travis McMichael's shotgun? Roddy Bryan can't see any weapon. He has no reason to know that these men are armed. And at this point, there's 20 seconds left in this video. And we're just going to go ahead and play it. And you tell me, in your mind, because you can't tell me, figure out when Roddy Bryan can see Travis McMichael's shotgun. Because Roddy's looking the wrong way. He's looking to the right, expecting Mr. Arbery to run off. Wow. We're now at what? Where are we on the timestamp? 128. We're now at 128. Roddy Bryan has never seen, and I don't care what is in any prior statement, we know looking at this video Roddy Bryant's never seen the shotgun until after it's been discharged the first time. That's not an opinion, that's fact. You're looking at it. You just never looked at it from this perspective before. Let's go ahead and play it.
All right, we are going to, it's the top of the hour, take a break. We will be right back here on the other side of continuing live coverage of closing arguments here on Court TV, your front row seat to justice. Welcome back to Court TV Live. I'm Judge Ashley Wilcott, always happy to be with you. We are going to take you live back to court just to tell you what's going on. This attorney, Attorney Goff, who represents the defendant, William Roddy Bryant, is going at detail through detail, frame by frame of that video to say, my client was there, but he was not an active participant in a crime.
Way back, moments after the shooting, Now, having seen that Mr. Bryan was going away and then turned around and put the video back up, how is that not a reasonable doubt in this case? Now, I don't know what Ms. Dunikowski is going to say, is going to say when she gets back up here. I do know that it seems like every technician in creation has been involved in this case. Drone this, footage that, filter this, enhance that. We got 20 million frames of every second of the footage in this case. But how, in the course of all that work, does someone who's practically computer illiterate figure out that they have this case all wrong? How is that possible? And how do you know that? Count the gear shifts, ladies and gentlemen. The state's theory is that there's 3 shifts, 3 changes in direction. That's 6 gear shifts. They're not audible. We know what happened. And I don't care what Travis McMichael says. I don't care what anybody else says. I'm looking at the video, and I'm listening for the changes. You know that when this, right here, when Mr. Arbery turns around, and whatever Mr. Bryan thinks he's doing with the wheel, I don't see much actual movement, okay? I see him at 2 miles an hour, and then his foot's off the gas pedal. Whatever Mr. Bryan thinks he did, I don't think it was much. But you know that he's driving away from Mr. Arbery at this point, because he can't go back and then go back and then go back again, because there aren't enough gear shifts. All right, I think we're done with that one. I want to talk to you about felony murder. Now, there are more capable lawyers than I in this courtroom, and they certainly have come up with great ways to analyze all these things that make it simple. I'm just not quite as adept as they are. So if I take a little longer, I apologize. The predicate offenses for the felony murder counts, those are counts 2, 3, 4, and 5, or counts 6, 7, 8, and 9. And I will address each of the underlying or predicate felonies in a moment. But right now I want to talk about something called proximate cause. Because to support any of the felony murder counts in this case, there has to be a causal relationship to the death of Ahmaud Arbery. And there is no such relationship in this case. Without trying to put words in the court's mouth, I think the court's going to charge you, well, I'm not there yet. You may find the defendant guilty of felony murder if you believe that Mr. Bryan caused the death of Mr. Arbery, regardless of whether Mr. Bryan intended the death to occur. That's felony murder. There must be some causal connection between the felony and the death. The court, I believe, will instruct you that felony murder is not established simply because the death occurred at the same time or shortly after the felony was attempted or committed. The burden on the state is much greater. The felony must have been directly caused, or must have directly caused the death, or played both a substantial and necessary part in causing the death. In this case, you may also consider whether any intervening act, those are my words, whether on the part of the McMichaels or Mr. Arbery were sufficient to break the causal chain of events. Actually, I believe both of the lawyers that preceded me for the McMichael defendants have pointed out the error in the state's argument here. Listen carefully to the court's charge. The words "but for" appear nowhere in that charge. They are not to be found. Why? Because "but for" is not the standard. It's too easy a standard. It's too low a standard. It doesn't meet the law. Why? Mr. Sheffield pointed out that but for, I think, Mr. Travis McMichael's grandparents, Travis McMichael wouldn't have been there. Likewise, I would say, but for Roddy Bryan's birth, there's no way that this crime could have taken place under the state's reasoning. You know, the same thing could be said, but for Larry English installing surveillance cameras. The McMichaels would never have known that this was the fellow running by them. But for Matt Albenzi pulling out his wood chipper that day and working in the front yard, he never would have saw Mr. Arbery. But for the actions of Robert Rash and Diego Perez, this incident might not have happened. But for Mr. Valbenzi calling the normal police number instead of 911, the police might have responded faster and things might have been different. But for Mr. Albenzi cutting off the Satilla Drive exit, Mr. Arbery might have escaped. But for 100 different things, all of which had to come together in the exact sequence for this tragedy to take place, it could not have happened. So simply saying that but for Mr. Bryan being there that day, that's not the standard. And the state doesn't even try and meet the standard that the court is going to instruct you on. Now maybe they're just waiting until they have the last word. And all I can say about that is that's just dirty pool. And I certainly hope that's not what's going on. Now, again, with all respect to the state, who have some very capable lawyers, when we look objectively at the events of February 23rd, I would respectfully submit to you that Roddy Bryan's presence is absolutely superfluous and irrelevant to the tragic death of Ahmaud Arbery. Now, that may not be intuitively obvious, but if you think about it, I believe you'll agree. Had Roddy Bryan stayed in bed that day, if Roddy Bryan had stayed on his front porch, would Ahmaud Arbery be alive today? If the state's theory is that these men, and I'm not saying that's the case, you decide what the deal is with the co-defendants, but if the theory is that these men were vigilantes and harbored some ill will towards Mr. Arbery, then what difference does it make whether Roddy Bryan is there or not? Mr. Arbery can't outrun bullets. They've been chasing him for a while, and he's at practically point-blank range even before he comes around the truck. The problem is, for the state, that Mr. Albenzi, thankfully not indicted, not yet anyway, Mr. Albenzi is down the street with his firearm. Roddy Bryan doesn't know that. That's why Roddy Bryan goes down Satilla momentarily as Mr. Bryan is turning up the road. You'll remember the testimony where the state was trying to say that Mr. Bryan was trying to run him over, when in fact, Mr. Arbery had already turned up Holmes by the time Mr. Bryan put his car in reverse. One of them, several times, they incorrectly stated he was trying to run Mr. Arbery over. The reason that Mr. Bryan is continuing down Satilla is he doesn't know that Mr. Albenzi is there. He can't. But Mr. Arbery does, which is why Mr. Arbery is not going to go down that way. Now, my point to you is Mr. Arbery is on foot. The McMichaels are in a pickup truck. We know they circle around all the way up Zellwood to the top of Holmes. How does Mr. Bryan's presence on the road that day, whatever he thought he was doing, okay, because if the idea is that he imprisoned Mr. Arbery by himself, that somehow, and those are the words he uses, that he cornered Mr. Arbery by himself, I guess, between his truck and the mailbox, I don't know, between his truck and the marsh, I don't know, the state will have to explain the theory to you, but the truck can go a lot faster. Mr. Arbery, if he's superhuman, might be doing 5 or 6 miles an hour, maybe 7. That pickup truck is capable of probably driving 100 miles an hour, maybe 90. Mr. Bryan's presence on the road has nothing to do with the ability of the McMichael defendants to cut Mr. Arbery off. Why? Because even though Roddy Bryan doesn't know it, Matt Albenzi's cut off one of the 2 exits from the neighborhood, and the McMichaels are already at the top of Holmes. They've cut off the second. Mr. Bryan is not trapping Mr. Arbery. He's trapped the moment the McMichaels get to the top of Holmes. It doesn't really matter what Roddy does. Now, they do come down the road, and there is a brief time period before the shooting where technically Mr. Bryan is behind Mr. Arbery. But it's clear by this point, it's certainly clear to Mr. Arbery, that he cannot outrun the McMichaels. No matter where he goes, they can follow. So again, how is Mr. Bryan's presence on this day in any meaningful way the cause of this shooting? And by the time Mr. Bryan gets around the dog leg, Mr. Arbery is already well within range of the shotgun that Travis McMichael is holding and the handgun that Gregory McMichael has. So if their intention, and again, I'm not suggesting that it's their intention, but if the McMichaels meant harm to Mr. Arbery, if they meant to shoot him that day, what in the world does Mr. Bryan's presence out there have to do with anything? I would submit to you that this is basically all a smokescreen from the state, because Mr. Bryan's presence doesn't contribute in a direct or substantial way to the death of Mr. Arbery, because the McMichaels were certainly capable of catching up with him and shooting him if that was their intention. One more proximate cause issue I want to discuss on these 4 felony murder counts, because it's basically the same issue. And the issue, the principle is one of intervening acts. The judge is going to instruct you that the causation must be direct and it must be substantial. And although the charge doesn't use the words, essentially it must be unbroken. Anything that breaks the chain of causation prevents a return of a verdict on felony murder.
Objection. Obviously, there's an issue. That is.
Mr. Goff, if we could please, if you were going to make representation with regard to the law that will be charged to the jury,
yes,
if we could remain within the charge that has already been approved by the court and that will be read by the court.
Let me, thank you, Your Honor. Let me go back and make sure I haven't misspoken. The court is going to charge you, I believe, that the felony must have directly caused the death or played a substantial and necessary part in causing the death. In this case, what I'm suggesting to you is that if either the actions of Mr. Arbery or the actions of Travis McMichael or the actions of both contributed to Mr. Arbery's death, then Mr. Bryan cannot be the direct, the substantial, and the necessary cause of that death. What am I talking about? I think it's already been referenced. I could be wrong. I don't want to misspeak. That Ahmaud Arbery turns in front of the vehicle at the last, the white pickup truck at the last moment, and basically meets Travis McMichael in the front of the truck. We can't see in front of the truck, but we know that's where they are. The question for you is, and I'm not trying to decipher who did what or why, because from Mr. Bryan's perspective, it doesn't matter. It does for yours, but from Mr. Bryan's perspective, it doesn't matter. But Mr. Arbery's decision at that last moment to turn left instead of right, as Mr. Bryan would have expected, as you can tell from the way he's angling his phone, anticipating Mr. Arbery's path of travel, when Mr. Arbery turns to the left, does that not break the causal chain in this case? I would submit that it does. Whether Mr. Arbery is justified in turning and coming at Mr. McMichael or not, that's for you to decide. That affects other people in this case. But Mr. Bryan is not responsible for that. That breaks the chain. The causal chain is no longer substantial and necessary. It's no longer direct. Likewise, when Mr. Travis McMichael closes the distance from to the left of the truck as you're looking at it on the screen towards the middle of the truck, or exactly where, I'll let y'all figure that out. But When Travis McMichael does that, regardless of whether Travis McMichael is justified in doing so, doesn't that also break the direct causation? Does it not also break the substantial and necessary part of Mr. Bryan in causing the death of Mr. Arbery? I would submit to you that Mr. Bryan cannot be the direct and substantial and necessary cause of Mr. Arbery's death. Whether that is the fault, for lack of a better phrase, of Mr. McMichael, the fault of Mr. Arbery.
All right, this attorney poses the question to the jury. Did his client, William Roddy Bryant, cause a direct relationship with this crime against Ahmaud Arbery? All right, stay tuned. We'll be right back here on Court TV, your front row seat to justice. We're going to take you back to court where closing arguments continue in Brunswick, Georgia. The argument being, listen, the actions of William Roddy Bryant were different from those of the other two defendants, and he should not be found guilty.
The roadway of Mr. Bryan's aggressive driving. Where are the tire tracks, the brake marks, the skid marks? For all the times Mr. Bryan supposedly has stopped short or changed direction so that it doesn't destroy anything. There's simply no physical evidence of aggressive driving. What about the lumber in the back of the truck? The evidence shows it's still in the back of his truck afterwards. There's no evidence that any of those timbers went through the back of his windshield. No evidence Mr. Bryan had to drive back around the neighborhood picking them up. No evidence of damage to the bed line or the tailgate. I don't believe there's evidence of even a scratch attributed to all the acrobatic maneuvers implied by the state. I'm not sure there's even a picture of the front of Mr. Bryan's truck in evidence, but if there is, I'm sure Ms. Dunikoski will provide it for you. Nobody's been looking for that evidence because there was no crime to investigate. There are no witnesses. Nobody will testify that they saw Mr. Bryan drive aggressively or recklessly. No neighbors will testify to that because it didn't happen. We have a neighborhood chock full of security videos. None of them catch this aggressive driving. What does the medical examiner tell us? The medical examiner testified extensively in this trial. He testified, I believe, that the pickup truck could be a deadly weapon, depending on the manner in which it was used, and that's consistent with the charge this court is going to give you. But what evidence is there that Mr. Bryan did, in fact, injure Mr. Arbery? I don't recall there being any testimony of any physical injuries to Mr. Arbery attributable to Mr. Bryan's actions. The cause of death was gunshot. Let's talk about the fingerprint evidence for a moment. The fingerprint or palm print is at the driver's side door on the side of the pickup truck. Mr. Bryan points this out in the minutes after the shooting to Officer Minshew. There are no prints or cotton fibers on the front of the truck or on the back of the truck. Now, last I checked, unless you're a Hollywood stunt person, maybe a veteran of Fast and Furious, Tokyo Drift, you're not in control unless you're out of control. I think that was the trailer for the movie. Absent something extraordinary like that, we know that pickup trucks don't move sideways. We also know, when I said earlier there was no witness, we have a witness, and that's Travis McMichael. Travis McMichael testified about the events of 2/23/20. Travis McMichael did not testify to aggressive driving on the part of Roddy Bryan. Travis McMichael testified, I believe, to Mr. Arbery attempting to get in Roddy Bryan's vehicle, not once, but twice. Carjacking is a felony. Attempted carjacking is a felony. You will be charged on what attempt is. But the point here is that the objective evidence is not that Mr. Bryan was engaged in aggressive behavior. The evidence is that Mr. Arbery was. And I don't say that as a measure of disrespect to Mr. Arbery. That's just what the testimony is. And I think the state questioned that. I could be wrong, but I could remind the jury, I believe during the testimony of Special Agent Jason Sechrist, during that testimony, I believe I specifically referenced page 54 of that transcript. There's a time there when Roddy Bryan is testifying and he says, he's coming back at me and I'm like, oh, blank, excuse me, again. And I started a kind of evasive action, which we see on the video, and dropped the phone. So long before Mr. Bryan has any reason to believe that anybody else has seen this, he's provided that information. I'm getting a look. What time is it? Oh, okay. Getting back to Mr. Bryan's statements, as I've indicated before, context is the key. It's not what the words Mr. Bryan's using. It's the truth, the meaning that he's attempting to convey with them. And I think I may have used the example before. If I were to say, I ran into your ex in the parking lot at Walmart, you wouldn't assume I ran them over, although technically you could interpret the words that way. There are a lot of words that we use. When we talk on this coming weekend, when Bulldog fans talk about wrecking tech, we don't actually expect that they will. It's a figure of speech. And again, through the examination of these officers, we see that the words that the state has taken have been taken out of context. We see that they've been juxtaposed in inappropriate ways to suggest a conversation that was different than it was. But I can tell you remember this discussion previously, so I'm going to truncate that discussion by pointing out the obvious. 3 police officers interview Roddy Bryan. They don't Mirandize him. They don't tell him that he's under investigation, because he's not. At the time of all these interviews, Roddy Bryan is a witness. At the conclusion of the Glenn County Police Department report, Roddy Bryan is still a witness. Roddy Bryan may not be careful with his words, because Roddy Bryan's never been told anybody's looking at him. But the bottom line is this: 3 good, solid police officers that you heard testify all interview Mr. Bryan. All of them write written summaries of their reports. I think I went through the 5-page version of Mr. Sechrest. I think I went through the versions of the other officers, not the transcripts, but their actual summaries. 3 police officers who know exactly what they're doing interview Mr. Bryan. None of them interpret his words to suggest that he committed an aggravated assault. None of them interpret his words to suggest that he was involved in any false imprisonment. None of them hear that in what he says. And I would humbly suggest to you that if 3 police officers interview Mr. Bryan for what turns out to be a total of hours, okay, you remember we had an argument about how long the transcripts were and what that would mean. I don't care how you break it down. 3 experienced police officers interviewed Mr. Bryan. None of them summarized for their superiors that Mr. Bryan attempted to run over Mr. Arbery, attempted to strike Mr. Arbery, or attempted to imprison Mr. Arbery. It's not there. And if that isn't a reasonable doubt on count 7 aggravated assault, I just don't know what it would be. Before I leave count 7, I do want to discuss lesser offenses. I'm not really sure why we call them lesser offenses, but that's what we call them. With respect to the aggravated assault count, with respect to Mr. Bryan only, the court is going to charge you on 3 lesser offenses. 2 of them are pretty much garden variety. One of them is a traffic offense. We'll leave those for your consideration. The third one I do want to discuss, however, that is reckless conduct. We don't see that one as often, so let me take a minute and discuss that. In reckless conduct, that offense is committed when a person commits reckless conduct when that person endangers the bodily safety of another person by consciously disregarding a substantial and unjustifiable risk that his act or omission will cause harm or endanger the safety of the other person. And the disregard constitutes a gross deviation from the standard of care which a reasonable person would exercise. I would suggest to you that Mr. Bryan did not consciously disregard a substantial unjustifiable risk.
It is the bottom of the hour. We need to take a break, but we're continuing to listen to this attorney argue that it was not involved in the crime, but rather just a witness. We'll be right back here on Court TV. Welcome back. We're going to take you back to court live. I just want to mention the closing argument is now focused on false imprisonment. Specifically, Attorney Goff is saying even if he blocked his way in the car, blocked his path, wasn't false imprisonment. Let's go back to court.
She has been falsely imprisoned. The third customer, the college freshman, for whatever reason, ignores the bank robber. The college freshman says nothing, but runs out the door just as fast as he can. He never looks back. When his parents call later that day asking how he's doing, the college freshman doesn't even mention his near-death experience. The college freshman, although certainly fortunate to be alive, has not been falsely imprisoned. Likewise, in the case before us under Georgia law, I would respectfully submit to you whatever other crimes may have been committed that day, Mr. Arbery was not falsely imprisoned prior to his tragic death. Now, Ms. Dunikoski may see things differently. For reasons that should soon be clear, she may contend, remember, under Georgia law, she always gets the last word, that Mr. Arbery did somehow submit in the last moments of his life to a combination of the harsh verbal commands of the McMichael defendants, if they did so, and the brandishment of the shotgun, if that happened. That's not exactly the way I recall the evidence, but I would submit that there's still no false imprisonment here as a matter of law. Why? Please look more carefully at count 8. Mr. Bryan is not charged with falsely imprisoning Mr. Arbery with either verbal commands or guns. That is not how the indictment reads. It alleges that Mr. Arbery was confined and detained, quote unquote, using said pickup trucks. The Cobb County District Attorney, I would suggest that you should hold them to that language. Nor does count 8 allege that Mr. Arbery was falsely imprisoned on Burford. Count 9 alleges an attempt to commit false imprisonment on Burford. We'll come back to that. But count 8 does not allege that Mr. Arbery was falsely imprisoned on Burford. Now, that may be where the state contends the chase started, but the indictment alleges the false imprisonment with pickup trucks happened on Holmes. The state contends that what you see on the that's what the state contends you see on the now famous video. We'll come back to that. There are several legal principles we should review before I move on. Again, I think I've discussed this. Abandonment is a defense to the charge of false imprisonment. And I think I've been through that, so I won't torture you with that again. We're getting here. Things I've already covered, I'm not going to repeat for you. All right. Trying to find. We've covered that. All right. Attempted false imprisonment. In count 9, Roddy Bryan is charged with attempted false imprisonment on Burford Drive. He's not charged with attempted false imprisonment on Holmes, only Burford. There are reasons for that, but they're really not relevant to this discussion. The court will charge you that in order to commit the crime of criminal attempt to commit false imprisonment, the state must prove intent to commit false imprisonment, because that's required to be a party to the crime. In other words, to prove an attempt, which is what is known as an inchoate crime, the state must show Mr. Bryan's specific intent to falsely imprison Arbery. In other words, for the attempt charge, Mr. Bryan would have to know that the McMichaels with whom he had not spoken lacked probable cause. Now, whether you ultimately determine that the McMichaels had probable cause or that Mr. Bryan had it on his own, there obviously was some considerable testimony about his trailer being taken, something taken out of a family member's truck. He had indicated he got the security system because of concerns. He had heard a bunch of stuff at work, but specifically with respect to the McMichaels, because he's not spoken to the McMichaels, he can't have the specific intent to help them falsely imprison Mr. Arbery. It's just a quirk of the law that he can't be convicted on that basis. Now, almost done. When I go home this evening to 174 St. Clair, I will be sleeping soundly for the first time in a while, because this case hopefully will have been submitted to you by then, and my work will be done. Ms. Dunikowski is going to get the last word. I ask yourselves to ask the questions that I will not be able to. Please don't allow any more cheap shots, no more gotcha moments in this case. You will recall the state, I believe that was Ms. Dunikowski, playing the video of a utility truck stopping at the English residence, and the guy jumps out to use the porta potty, which was relevant to absolutely nothing other than Ms. Dunikowski's desire to reinforce for you the fact that Mr. Arbery was dead. That was clearly inappropriate. It was what I call a gotcha moment. And I would submit there's already been too much of it. You know, we've had professional witnesses come in here trying to tell you who you should believe. Again, please no more cheap shots in closing. And then, of course, we have the state talking about the death penalty for theft, for which they were admonished by the court. Now, I'm not trying to rub it in, but I would suggest to you that given all of the cheap shots and all of the misstatements, I won't say they're knowing, we won't be jumping any assumptions, but given all the cheap shots in this case against Mr. Bryan, I would hope that when Ms. Dunikowski has the last word here, that you will hold her accountable and that you will not accept or tolerate any more cheap shots when I have no opportunity to respond. Again, I'm going to posit these three questions to you. When did Roddy Bryan know the McMichaels brought guns? When did Roddy Bryan know Travis McMichael would shoot Mr. Arbery? And at that point, what could Roddy Bryan possibly have done to stop it? Mr. Bryan put his faith in the Glenn County Police Department, and then he put his faith in the GBI. He put his trust in law enforcement. He put his trust in our government to do the right thing by him. His trust was not rewarded, and now he finds himself before you. We place Roddy Bryan's fate in your hands. We ask you to return a verdict of not guilty on all counts. I ask you to send Roddy Bryan home. Thank you.
All right, thank you, counsel. All right, ladies and gentlemen, we are going to take a 15-minute recess. We need to work through some scheduling issues and figure out where we are, and we will bring you back out for a continuation of the case or other announcements in about 15 minutes. Thank you.
All right, for jury.
So he has excused the jury for a 15-minute break. It is 4:40 Eastern Time, which is the time this trial is in, and we know that there is still rebuttal to be offered by the state. He just commented they're going to discuss some scheduling things. Certainly we're going to watch and see what those are, but I can imagine it might be about how long do they keep the jury today versus if they continue tomorrow.
But see,
All right. It is it's almost 4:45. As far as the state's remainder of closing.
Yes, Judge. I'm going to take the full 2 hours. I have way too much to talk about and to rebut, given the excellent 3 closing arguments that were just done by the defense attorneys.
Sorry from counsel.
Yeah. Chairman, thank you. We're ready to hear it. We're hopeful to hear in complete closings tonight. It seems like the jury wants to keep going. And we're prepared to stay and listen attentively and I guess then do charge in the morning.
That's the position of Greg McMichael as well. They do seem to want to continue on, and you said they've been very actively engaged in wanting to keep this process moving.
I watched 12 through that. 12 seemed actually quite attentive.
Yes, agreed.
Agreed. All right, I'm going to, unless there's an objection, I might find out if there are any conflicts or issues with them knowing that there are 2 hours potentially of argument and that they won't get the case tonight because the court is going to charge them tomorrow. Okay. Anybody have any objection?
No objection to inquiring what the jury wants to do.
No objection.
No objection.
No objection. No objection. Okay. Yeah, we're going to break then. Let me break and we'll make that inquiry. I'll notify counsel of the result of that inquiry.
All right, you can see they have taken a break. While they're on a break, we're going to take a break, but don't go anywhere. We'll continue all of our continuing live coverage and breaking down what's happened so far with the closing arguments that have now concluded, other than the rebuttal by the state. Welcome back for our continuing live coverage of the trial in Brunswick, Georgia. The 3 defendants accused of killing Ahmaud Arbery. Now, the jury is on a break, and the judge said, all right, attorneys, you get a break too. I'm going to see if the jury wants to keep going and listen to the state's rebuttal today, or rather, if the jury would like to come back tomorrow and get started with that. It's interesting, the prosecution estimated a 2-hour period needed for that rebuttal. That's how long she's allotted. She said, Linda Danowski, that that's how long she wants to spend. Let me bring in, if I could please, 2 special guests to help break all this down. Jim Trusty, trial attorney, as well as Leslie Ricard Chambers, trial attorney, former prosecutor. And I know I just inadvertently said her name incorrectly, the prosecutor, Ms. Dunikowski. So let's start with that so I get it pronounced correctly. If you would, Jim, let me start with you and tell us, if you would, just your overall thoughts about these closing arguments.
Well, you know, it's very interesting when you have a joint trial dynamic. I mean, that's my starting point is if you are the McMichaels, you're sitting there and hearing this closing argument that we just heard, and you're dreading it because essentially it's a rift. There's a difference between Mr. Bryan and the McMichaels. And so it's an interesting dynamic that his attorney basically says, I don't really care what you do with those guys, but my guy is flat out innocent. The other observation I would just make is that, and this is just like the Rittenhouse case, in that credibility of witnesses is really such a traditional battleground for these types of criminal trials, including self-defense. But here, you know, with the advent of video, it's much more about the legal analysis by the jury of how this tricky thing called self-defense plays out with largely uncontested facts when it comes to the video. So I think that's an interesting dynamic too, and certainly one that this last closing argument played up.
And I want to circle back to that self-defense in just a moment. But first, Leslie, I'd welcome, what are your overall thoughts as you've watched these closing arguments?
Well, I think that I saw what I anticipated that I'd see. Number one, that the counsel for Roddy Bryan would do a lot of finger pointing and suggest that his client is not just the least culpable, but had absolutely no participation, no active participation in this crime happening. And furthermore, didn't know that these defendants possessed guns or presented some imminent danger to the life of Ahmaud Arbery. And so initially, I throughout the course of this trial, I did think that there would be more of a cohesion in terms of how these defendants' theories of the case played with one another. But today, really surprised at how much the defense counsel for Roddy Bryan sort of threw the other co-defendants under the bus. And so that's my initial observation in this course of closing arguments.
And he did ask the jury to consider 3 questions, and he believes if the jury asked these 3 questions that they would acquit his client. One was, when did he know the co-defendants had guns? When did he know they'd shoot? Or rather, did he know they'd shoot? And then the third is, what could he have done to stop it? And the argument is nothing. At least that's the argument that he's put before this jury and asking that his client be acquitted. Jim, let's circle back. There are 2 different laws that I'd like to look at with both of you. One is just briefly the citizen's arrest law, because we know this is no longer a law in the state of Georgia, but at the time of the incident, this was one of Georgia's laws, OCGA 17460. A private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge. Let's just stop with that part. In his presence, within his immediate knowledge. We know it was not within the presence of Travis McMichael. Jim, how well do you think the prosecution has argued and proven that it, though, is within his immediate knowledge, not the prosecution, rather the defense, that it is within Travis McMichael's immediate knowledge?
Yeah, I think it's a stretch. I mean, you're pointing out one of the flaws of the self-defense argument here for the McMichaels, because they just made assumptions. That's really the bottom line here. And I think when you have a very kind of technical felony of breaking into an unoccupied house that's, you know, again, I think a lot of people would admit that when a new house goes up in their neighborhood, they feel pretty comfortable browsing at the inside of it. So you've got kind of this technical felony. You don't have it clearly within the immediate presence or even the immediate knowledge of the McMichaels. And you have this kind of self-appointed ex-police officer deciding to take charge and exploit this type of law, it's not a good recipe for self-defense under these particular facts.
And I do think it was really important for the state to say this is a dwelling, so it doesn't matter if it's being built or if it's been built, because it is important, I think, for that jury to understand, even though the house wasn't completed, technically, definition burglary still dwelling. All right, let's ask, if we could, Leslie, I'd like to look together at another part of this law, and that's what Jim just referenced, the self-defense law and some of the required elements. And I agree, this jury is going to have all of the law. We know they'll receive the jury instructions from the judge after this has been, the closing argument rebuttal has been concluded. But here are aspects, elements of our self-defense law in the state of Georgia. Number one, individuals can use deadly force to prevent their own death or great bodily injury. Number two, not justified if a person was the aggressor. And number three, it's important to note, also not justified if the individual initially provoked the other person. Leslie, what's your analysis of this case and the self-defense law?
So, we've heard a lot of reference to this jury about having them consider their common sense and their own sense of reasonableness when assessing whether or not the force and the reactions of the McMichaels in particular, Travis McMichael, was reasonable under the circumstances. And so what we know throughout this trial, what we've learned is that the Travis McMichael, they all created this environment of an aggressive environment where Ahmaud Arbery could have reasonably assumed that his life was in danger. And so I think that the key component here that the state has to hone in on, which I believe that they've done in their initial closing arguments, is to remind them in rebuttal that what Ahmaud Arbery observed, witnessed, felt, his what was happening in that very moment was unreasonable in terms of being ganged up by three people and by McMichael's own statements being pinned in like a rat, and then Travis McMichael approaching Ahmaud Arbery with a 12-gauge shotgun. Put yourself in that position and ask yourself if those actions were reasonable.
All right. Thank you, Leslie. You're going to stay with us. Jim Trusty, trial attorney, thank you so much for joining us and squeezing in some analysis while they're not in court. We are going to take a break while they are in court. And up next, we will continue to cover this trial live from Brunswick, Georgia. Welcome back to Court TV Live. I'm Ashley Wilcott. Thank you for joining us for your continuing live coverage of the case out of Brunswick, Georgia, against Travis McMichael, Gregory McMichael, and William Roddy Bryan. We're going to take you straight back into court. The jury is not in the courtroom, but the attorneys are handling some logistics issues with the court.
It's the first time I've been in that room during, really, the proceedings.
Okay.
I heard something and did in fact say, oh, have y'all been hearing this? And the response was, oh, we just heard that. That's it. So, no. And it's muffled. You can't actually hear what it is. You just hear there's a commotion. What I heard was just, it apparently right as I went into the room, a group went around the side of the building. So it was on my radar, and just for the record, heard it. And no, it is not, I understand the concern, and I'm understanding where we are with the case. Thought I'd put it on the record simply to say, here's what we're doing. But no, they're not being moved because there's a commotion outside. They're being moved because I thought, based simply upon that and me hearing that, it was in the best interest of the court to go ahead and put them into one of the courtroom's interior.
Thank you. Also, if the court could put in place something to prevent, during deliberation, people walking around the courthouse. It's not a necessary feature of the First Amendment that they walk on all four sides of the courthouse to make their First Amendment speech heard and known. If we could keep them on the front, if the court could do that with the Sheriff's Department, we would ask that you do that. We just think this is a tipping point issue for the jury if there's any chance of them hearing that or seeing that.
I'll think that through. Candidly, I have some concerns about doing that, only that any action of the court or the Sheriff's Department generally is met with some type of reaction. And I don't want to do that. I don't want to create problems where there aren't any. It's just a matter of this afternoon, there was a group that walked around the courthouse and I could hear it. That's one thing. If it is something different or becomes much more significant, then I need to figure out how to address that and make sure that there isn't an issue with the jury. I'll go ahead and do that. Understand the concern, though. I think I've worked through the McMichaels and Mr. Bryan.
No, Your Honor.
Okay. All right. I'm going to bring the panel in. I'll dismiss them for the day, and then I'll step down if counsel could discuss whatever you need to discuss, and then let me know if there is something we need to do on the record before the defendants. If not, it sounds like I probably need to meet with you all in the back anyway based on the questions that were asked by Ms. Hogue.
Thank you.
Okay. All right, let's get the panel.
So rise for the jury. Please be seated.
All right, ladies and gentlemen, we're going to go ahead and break for the day. So we're going to start a little bit earlier tomorrow. We're going to start at 8:30. So we're going to get into the state's closing at 8:30. During the recess, again, do not discuss this case amongst yourselves or with anybody else. Don't go looking for any information about the case. If anybody approaches you about the case, please let the court know and we'll go ahead and get that addressed. Don't go looking for any information in the news. Don't look at social media. And again, if you're in the presence of anybody that wants to talk about the case, you need to walk away and you need to let the court know if that has occurred. So, again, I want to thank you for your service. You've heard me say it over and over again, and you're probably getting tired of it, but it is greatly appreciated by the Superior Court of Glynn County. Have a good evening, and we'll see you back here at 8:30 in the morning.
All right for the jury.
We mentioned earlier, the judge indicated that he was actually going to talk with the jury to find out whether or not they wanted to stay longer today and hear the state's rebuttal, or rather if they would like to go home and come back in the morning, and they said, go home, please. So they're coming back at 8:30 in the morning. Now with us, Julia Janae, live from Brunswick, Georgia, our legal correspondent. And Julia, you have been covering this trial since the very beginning. Tell us about today, especially given the fact that all three of the defendants have now completed their closing arguments.
Judge Ashley, it's a huge day there inside of the courtroom. These jurors have heard from both sides. They still have that rebuttal argument from the state, but essentially they've heard what these parties want them to take with them into the deliberation room. And today they seemed especially engaged in what was being said. There was some sporadic note-taking throughout these closing arguments. There was one juror who seemed to be struggling to stay awake. There were calls for her removal, but she is still on the panel. But there were things that they were very tuned into and seemed to be taking notes on, including a citizen's arrest and probable cause. There were moments that they were paying attention to the gallery and the defense table when certain things were said during these openings. But overall, these jurors just really seem keen on taking in whatever information they can. And I was paying attention to what they were going to say to this judge, whether they'd want to go into the night or if they'd want to come back tomorrow, because we know what the defense attorneys understand is that these jurors are willing to work as long as they need to, even though they were told initially they would only have to serve until the 19th of November. And here we are going into the next week after the 19th, which was Friday.
And Julia, I must ask, with all these jurors being intent, taking notes, listening, were there any facial expressions or any things they were doing with their hands that might have indicated how they were feeling or responding to these different closing arguments today?
And as far as facial expressions, we only see their eyes because they are all wearing masks. But they look very thoughtful when they are taking in these closing. In particular, during Jason Sheffield's closing, I noticed two jurors, one male, one female, with their hands on their chin, just looking and seeming to be tuned in, I should say, to what they were saying, or can't say that they were necessarily agreeing or nodding with what was being said, but they want to make sure that these attorneys know that they are paying attention. There was some note-taking during, in particular, like I mentioned, the citizen's arrest statute, but the way that Linda Denokoski, the prosecutor, described it with an analogy. She said that those two prongs that we know are required under the statute, and it's either or, whether it's an arrest that's made because a crime is being committed in the presence of that person who wants to make this citizen's arrest or in their immediate knowledge. And Denokoski told them that these are two things that are merged together. They are the same, that if someone is in an eye in the sky at Walmart, I thought she made a really good analogy there. If someone's watching the surveillance video and they see someone taking something, then that's immediate knowledge, but they aren't actually there and it's not in the presence of. But you heard the defense refuting that, even though there was a lot of note-taking during that portion of her closing argument. The defense says that's not an accurate way to describe this statute and explained it a different way during their closings.
All right,
let's take a listen to what Linda Denokoski said in her closing.
Think of your schoolyard bullies. Think of the three boys walking behind the one who's the target, kid who's getting abused, right? Okay, so you got 3-on-1, they're going down the hallway, they're menacing him, maybe threatening him, and they get him up against a locker, and he has nowhere to go. He's trapped, right? So what does the kid who's being bullied do? He takes it, and he takes it, and takes it until he can't anymore, and he finally shoves the one bully, and what does that bully do? Bam! Punches the target child, right? What's the bully always say? He started it. Isn't that what the bully always says? He pushed me. I was defending myself. Yeah, 3-on-1 with one kid up against a locker. You're bullying him. And he actually pushes you, and you get to then claim you were acting in self-defense when you punch him? Guess what? The law knows people do this. I mean, you get this. This is the law. The law knows people will goad other people into defending themselves so that they can claim, I was acting in self-defense. You can't do that either. 3-on-1, 2 pickup trucks, 2 guns, unarmed. Mr. Arbery was unarmed.
Just another example of those analogies by Linda Dunikoski. And Judge Ashley, I thought one that she used that I hadn't really heard before with trying to explain the felony murder rule to these jurors. She talked about Super Bowl rings, that everyone gets one, even if they weren't actually on the field, but they are part of the team in bringing home that victory.
And we all know as trial attorneys, Julia, that it's really hard. You have to be creative and think of accurate, good ways to put it into terms that jurors may understand. And I thought on all of these closing arguments, different attorneys did use different analogies to try to help this jury understand what their responsibilities are going to be. Let's move then, if we could, and talk about, as you're going through closing arguments that we know occurred today, Attorney Hogue and what those closing arguments were like, or what stood out to you, Julia?
Attorney Laura Hogue, who represents Gregory McMichael, she really seemed to captivate this jury. They were really paying attention to many of the words that she said. She stayed more still than the other attorney. She didn't do a lot of walking. She had an easel, so she was writing things down, and things were already written on it. She struggled a bit with getting those pages flipped, but she reminded this jury and appealed to their sense of being neighbors and told them that they are communities within Glenn County, and those communities are made up of neighbors. Here's a bit from her testimony that the jury seemed to pay attention to.
Greg McMichael's driveway decision wasn't the only decision that set this tragedy in motion. Ahmaud Arbery was not an innocent victim plundering through Larry English's house on February 23rd. Just as he wasn't an innocent victim all the other nights, like October 25th, or November 18th, or December 15th, or February 11th. Is he the person responsible for stealing Larry English's expensive boat equipment? I don't know. We don't know. No one investigated that. But can anyone reasonably believe that Ahmaud Arbery was just doing a looky-loo on those nights in what has been described and shown to you as a home drenched in absolute darkness?
Laura Hogue was probably, out of the 3 defense attorneys who spoke today, she was the one who really went after Ahmaud Arbery and who he was, painting him to be someone who was very nefarious in that neighborhood, even seeming to personally attack him, talking about how he was dressed that day, that he wasn't wearing socks and had these long toenails. That was a moment in the courtroom that Wanda Cooper Jones said she couldn't take anymore, and she left. Just those statements that were being made about her son and why he was in the neighborhood that day.
Right, right. So much to watch today. But I know, Julia, the benefit of you being there and all your attention to detail and excellent reporting is you also are aware of what's going on outside of the courthouse. What has the mood been like? Has there been a change in how it feels during closing arguments today?
Well, there's a change in what organizations are here, but not a major change to the number. You know, we had those huge numbers on Thursday last week with the pastors' rally, but the numbers have gone back down to what we've normally seen each day of this trial. A few dozen people who are here, and today members of the Black Panther Party are here. This is really the first time we've seen their group in large numbers. So they arrived today. They've been standing around the courthouse. First time we've seen weapons being held outside of the courthouse, but they have been chanting justice for Ahmaud. And you heard Kevin Goff mentioning the coffin that was brought to the front of the courthouse. Now, he mistakenly said that on that coffin were the names of the 3 defendants, but rather this was more like a funeral procession that was happening outside. And that coffin that you see there with the names written in white on it are actually the names of victims of violence, many who have been unarmed victims of police violence. George Floyd's name is on it, Breonna Taylor, Devontae Wright. So this was more of a showing of respect to Ahmaud Arbery and not necessarily in this moment something that's aimed at the defendants. But you did hear that mistrial motion from Goff for what is being seen outside, including that we're now seeing weapons that we didn't see before. Georgia is an open carry state, so not a violation there.
All right, and I know that there have been renewed motions for mistrials based on all of this going on outside of the courthouse. Very impactful when you see that coffin. But Julie, I know the judge has said, nope, not going to grant that motion because the jury hasn't been affected in his opinion based on the arguments and what he knows. So we'll continue to watch as this goes forward. Julia Janae, live from Brunswick, thank you so much as always for all of your reporting and good information there live on the ground. We are going to take a break. When we come back, exhibits marked. What are the exhibits that have been introduced into evidence and that the jury can rely on in making their decision? That's up next here on Court TV, your front row seat to justice.